Donna Adelson testified today. The judge needs to know whether or not she's planning on testifying because I guess he has to read her rights, and they need to figure out court scheduling. Now, yesterday they released everyone about 2 hours early. I thought it was because maybe they had a witness that was scheduled to testify and then couldn't, but we don't really know. So today we're going to start off with some courtroom drama. I guess we'll get into that now. And then Wendy Adelson's attorney who represented her during the divorce with Dan Markel is testifying on the stand right now. So we get to hear some more details about that. However, I'm wondering, can they use this attorney's testimony against Wendy if Wendy's ever, if she's ever prosecuted down the road and she has her trial, if that ever happens. But I mean, some of the stuff that the attorney is testifying to, I'm like, I feel like this is going against some of the things that Wendy was saying. But anyways, we'll get to that part when we get there. And good morning, everyone. Hello. Hi, Rain. I hope you guys are doing well. We've been doing recap videos for this trial. So if you guys are not caught up or if you don't want to watch long trial stuff, the recap videos are on my channel. So feel free to check it out. And guys, I hope today is an early release day, although I like to maximize the court days, but I do like getting off early. It is nice, especially when you've been here for hours and hours and hours and hours. Hi, Go Lucky. Hi, Joe. Hello. Hi, Millie. Good morning. Good morning, everyone. All right, y'all, let's do this. So a little bit of courtroom drama today. Sorry. I'm still warming up my voice a little bit. All right, we are in day 8 today, y'all. Day 8. I think they were planning on maybe finishing this Friday. However, maybe it will continue on to next week. We'll see how the scheduling goes. And then we'll see if the state, if they would do a rebuttal. Now, the audio kind of just cuts in. I don't know what was going on. Hey, Laura.
I'm not accusing the state attorney's office of doing anything. I'm merely advising the court what transpired. Mr. Campbell advised that when somebody from the sheriff's office went to speak with this officer, the officer expressed to that superior that they were no longer willing to speak with us. And was no longer available, in fact, that the officer was going to be on leave.
Well, we can bring in Under Sheriff Google, however, at this point in time, this does not invoke the court to need to go through an inquiry. The witnesses that you're referring to, have they been disclosed to the state?
It's not by us, Your Honor, because again, we have not had a chance to speak with her.
Do you intend to call these individuals?
So the answer is no. They have not been disclosed to the state.
If we can confirm the information,
These are not answers. If you're not actually intending to call a witness that has not been previously disclosed, at this point, I do not have to engage in a Richardson hearing on this matter. But as far as witnesses that you may be investigating or you may speculate have relevant testimony, until you disclose them, until you actually intend to call them, there's really not much I can do.
Wait, a Richardson hearing. Oh, we had that in Sarah Boone trial, right? Give me a second. Purpose of this hearing is to determine whether or not there's been a violation of discovery rules, and if so, to determine an appropriate remedy. Okay, so judge is thinking no Richardson hearing.
If you wish me to hear from the Under Sheriff, I will. But as far as perfecting a subpoena and speaking to these people who are either not under subpoena or not as witnesses, there's not very much I can do.
Judge, is the...
Why do they want to call this person? So Zellman is saying that they're trying to get in contact with someone or maybe have them testify. This person has not been subpoenaed. This person has not been disclosed to the state. I guess like they're not on the witness list. So I wonder why Zellman wants to have this person on. Apparently they tried to reach out to them and then the person was told that they should not talk to the defense or something like that. And Zellman's like, judge, help us out. Get this person here. There's nothing I can do. Where's your subpoena?
The defense position that between 12:30 and when we got to the jail shortly before 5, somebody from the sheriff's office spoke with this officer and convinced her that it was not in her interest to cooperate with the defense. We are asking for the court's assistance because the rules...
To do what exactly?
So that we can at least speak with her to find out if she has anything that's admissible.
The court has...
So we can speak to her and find out if she has anything admissible, okay?
Jurisdictional authority limits. For someone who is not under a subpoena, I just can't compel them to come here, go there, or do certain things. There is no subpoena for this individual. If they choose not to speak with you, so be it. But please bring in the undersheriff. He can speak to these matters that you've raised.
What does Mr. Zellman expect the judge to do? Look at the judge's face. He's like, you should know this.
Judge, if I may. Whatever happened after we spoke with the officer yesterday afternoon, even if we had a subpoena ready to serve, they have represented to us that she is not available to be served. Without the court's assistance, we cannot accomplish that.
Well, and this goes to the
What does that mean? Even if we had a subpoena, they represented they would not be available to be served. Like they're going to be in hiding. They're going to run away from you.
timeliness of the witness itself and the fact that it's occurring in the middle of the trial. But that part of it, again, there's certain things I cannot assist with. And the Sheriff Google, please raise your right hand, sir. Do you swear or affirm the testimony you're about to give to be the truth?
Yes, sir, I do.
If you can just stand in front of the court reporter instead of taking the witness stand.
Thanks,
If you can
Sandra.
explain to me what occurred with, I believe this is one of the correctional deputies that may or may not have testimony concerning this case. Please explain what happened with them to the best of your knowledge.
To my knowledge.
All right. Something about the testimony of a correctional deputy. Is this going to be more tea on the inmates that were snitching on Donna?
I was approached by Captain Georgia Dent, who had spoken with Deputy Franklin, and Deputy Franklin informed Captain Dent that she had received a phone call from inmate Allison's attorneys, and they were advising her that they were going to be at the detention facility later that afternoon, which was on yesterday, and they wanted to speak to her. So she was inquiring with Captain Dent if she actually had to speak to them, and she was saying that she didn't know what they wanted to talk to her about. Captain Dent then came to me and gave me that information. I then talked to our general counsel, the agency's general counsel, and we were in agreement that she could speak to them if she so chose voluntarily. If she did not want to speak to them, they would have to have a subpoena to compel her to speak. So after speaking with general counsel, I spoke back to Captain Dent, and she relayed that information to Deputy Franklin.
I mean, that sounds reasonable to me. Zellman was saying that she was told to not talk to the defense team. It seems more reasonable that they talked about it. They're like, hey, like, you can talk to them if you want. Like, we can't hold you back. You know, it's up to you. You can talk to them if you want to voluntarily. And then she's like, well, if I don't have to, then nope.
Did you or any other person in a position of authority over this guard instruct them not to speak to the defense?
No, sir.
An examination for under Sheriff Google by the defense or state?
Not gonna say it, Your Honor.
See, it's like, no.
Good morning, sir.
Good morning.
It is our understanding that Officer Franklin is now on leave and not available to be served.
That's not my knowledge. I have no clue about that.
So she is available to be served?
I would think so. I'm not aware of her being on leave.
Thank you.
Yes, sir.
So is she on leave for like personal stuff, maybe on vacation? I don't know. I guess Zellman's trying to make it seem like she was told to not talk to the defense, and now she was put on leave so she can duck from the defense. If the defense were to serve her with a subpoena. But maybe it's vacation time, you know? Maybe it's vacation time.
Sheriff Google, there is no more inquiry that I will make of you concerning this topic. I appreciate you being here this morning.
Yes, sir. Thank you.
Concerning the other witness, who is not the guard, was the defense able to make contact with this individual?
Just a moment, Your Honor.
So another witness that's not a guard. So who's this witness?
Judge, the information that we provided to Your Honor was purely to put it on the record that we had followed that information. After discussions amongst Ms. Fulford and I, we had decided that we were not going to pursue that given the status of that individual and the misinformation we believe we were being given.
The misinformation. What now? Who gave misinformation? They decided not to pursue it given the status of the individual and something about misinformation.
Discussions amongst Ms. Fulford and I, we had decided that we were not going to pursue that given the status of that individual and the misinformation we believe we were being given.
Oh, the misinformation that we believe we're given.
Right. As to the, I believe, second witness, is this person going to be disclosed, or are you going to seek to call them as a part of your case?
No, Your Honor.
As to the guard, if you need to follow up with a subpoena for this individual, if they have chosen not to speak with you, you need to do so with all haste. The jurors, at the time of selection, were told this would be 3 weeks, that it could possibly go longer, but 3 weeks is what they were told. For today's witnesses, let's go through that before the jurors are brought into the room.
So we're on week number 2 right now. The judge is basically saying that we might need to come back next week.
Does not have a chance to prepare a list. At least for this morning, our intent is to call Kristen Adamson, Linda Bailey, Sarah Newhouse, and Marisol Descalzo.
For this afternoon.
This afternoon is up in the air, and that's going to require some additional conversations with our client.
During the lunch break, that would be your opportunity to have any final
Conversation with my client. So, I mean, the impression that we've gotten so far, it seemed like Donna was going to testify. However, maybe she'll change her mind and be like, you know what? I'm good.
Concerning whether she will in fact testify. We'll give the jurors a longer lunch break if necessary to accommodate this. Instead of an hour and 15 minutes, it will be an hour and 30.
Yay.
After that, we are going to have to go on the record concerning is she or is she not testifying.
Yes, sir.
So, judge is going to give the jury possibly a longer lunchtime, an hour and a half, if Donna wants to, think about whether or not she wants to testify. But she needs to know that she needs to let the judge know ASAP, soon. By lunch break, I guess. Before lunch break is over.
Please bring in the jurors.
Your Honor, I know that 3 of the witnesses are here. Mr. Scalzo's plate does not arrive until a little after
10 o'clock is
Yes, sir.
Okay, so witness number, who are we on, do you think? Witness number, we had a lot of witnesses yesterday. Number 9, I guess? Yes, witness number 9.
Ms. Peppelman, I neglected to give you an opportunity to speak. If you actually wanted to be heard, please do so now.
All right, witness number 9. Were we here with the witness number 9? Let me see.
In your work as a family law attorney, did you have occasion to represent Wendy?
Okay, cool. Yeah, we're right around here. All right, cool. So next witness, let me get her on the stand just so I can have her name. Did I hear Christina Applegate?
Or for the testimony we'll give today will be the truth. You may take your seat.
Hi, Nicole. What's Georgia wearing today? Oh, I didn't see.
When you're ready.
Thank you, Your Honor.
Hey, Roma. Hey there, Corgi and gang. Hello, how are you? What's going on? Mufasa's here. How's it going? Hey, chat. Hello. Hey, John.
Good morning.
Good morning.
Can you please introduce yourself to the jury?
I'm Kristen Adamson.
And Ms. Addison, how are you employed?
I'm a lawyer.
What type of law do you practice?
I practice family law, and I have done so for 37 years.
How long have you been practicing?
37 years.
Okay.
Zelman, are you listening?
Are you board certified?
Yes, I am board certified.
Zelman's probably multitasking right now. So, Kristen Adamson, family law, 37 years. Now, she was the attorney for Wendy Adelson. And I'm like, is this the same attorney? I have a lot of comments about this attorney. But starting off the bat, is this the same attorney that represented Wendy? And at some point, Dan Markel was going after the attorney and Wendy. And so the attorney decided to recuse himself because they thought they might have to be a witness, because Dan Markel was essentially accusing her of filing like frivolous claims and possibly being in on it with Wendy about hiding assets. So I could see her being up here to try to clear her name and maybe make Dan Markel look like the bad guy. All right.
In your work as a family law attorney, did you have occasion to represent Wendy Adelson?
I did represent Wendy Adelson in the end of 2012, I believe it was, 2013, and part of 2014.
Would you call her divorce a bitter custody battle?
I would not. That's not how I would characterize it.
How would you characterize?
Really? I mean, so far the jury has already seen Dan Markel's, some of his motions and some of the filings and the back and forth, and then the Donna emails. Like, it sounded like it was pretty contentious.
She had a relocation.
Maybe she's seen worse, but it looked a little spicy to me.
case where she desired to go to Miami. All relocation cases are a little bit more difficult than just regular custody cases because we almost always have to have a court determination on a relocation case because unlike almost all other family law cases, relocation is a win-lose thing. Almost everything else in family law is sort of a split the baby. Relocation is not. So we did have to go to court on that. And that going to court always is a little bit harder, but in general, this was more or less after that a run-of-the-mill kind of parenting issue kind of case.
Is it unusual to seek, in your practice, has it been unusual to seek relocation?
No, not at all. I have two right now.
Now, speaking to Tallahassee, why is it not unusual?
Why is it not unusual?
Yes.
It's not unusual because it depends on why someone is here in Tallahassee. Tallahassee has a lot of students with the university. They may graduate with a degree, have children, expect to be able to move somewhere else after they graduate. One person wants to leave, the other person doesn't want to leave. The two cases I have right now, they're not here in front of this court, so they're actually, one of them settled. But one of them, the mother received a potential job offer in North Carolina. The father lived here. She wanted to move to North Carolina. All of his family was here.
So she's just going to give some relocation examples with our clients that she has right now. Ooh, hey, Donna. I wonder what Donna's thinking so far. So I kind of looked around. It seems like the general feedback about yesterday's trial, it seems like a lot of people were kind of confused about where the defense was going with some of the witnesses, and that possibly some of the witnesses may have been more helpful to the state than the defense maybe realizes.
He referenced parental
Oh, let me turn up the audio. Give me a second. Audio in the courtroom is really low today, or maybe it's like law and crime.
alienation. Have you dealt with parental alienation in your practice before?
I have.
And what is that?
Well, it's not actually a recognized legal term, and it's not actually a recognized mental health term by the mental health professionals, but it does happen. I mean, we all know that there are parents
Wait a second. We are not here.
who be dismissed because it wasn't the correct way to go about doing. I was pretty much once a week or once every other week. Markel had almost $500,000 worth of not able to pierce that veil of confidentiality.
But for our purposes, in order to talk about what
Give me a second. Let me find my spot. Oh, no.
specifically happened concerning that asset and mediation, do you need
Non-marital portion to be determined. Trial all the time in some way or another. They do. And it's always best if you can settle your case and not
Oh, hey. Donna's bench is full today.
leave it to a court. You have much more control if you are the decision makers rather than the court. Basically, if the judge had already determined this without hearing from Professor Markel, we didn't really have it. That gave him to opposing counsel. Sometimes what does happen is able to obtain a job in Atlanta and move up there to her former husband. So
Okay, so there's examples, maybe around here.
Now, let's talk about the family law rules of procedure generally. Do the rules require the exchange of certain materials in dissolution proceedings?
yes.
And what are those?
We have mandatory disclosure in divorce and modification proceedings, including custody and just regular divorce. And pursuant to the Florida Supreme Court rules and 12.540, we have to file a financial affidavit under oath that the parties and lawyers and their paralegals help them fill out. We also have to provide a laundry list of documents that keeps getting larger. It's bank statements for 3 years, it's retirement statements, it's deeds, it is credit reports. I mean, it's a very large, voluminous amount of documentation that we have to exchange with the other party, the other counsel.
And when completing the financial affidavits, specifically
Quick check their teeth. Good veneers equals friends bought with money.
when you completed Miss Adelson's family law financial affidavit, did you gather records in the process of completing that so you could disclose everything appropriately?
We did. We gathered all those records and we exchanged them and gave them to opposing counsel. Sometimes what does happen is the other side has all the records. For example, tax returns, we have to exchange tax returns for 3 years. Sometimes the father or the husband might have all the tax returns, the wife might have all the tax returns. So you do rely sometimes for the other side to provide the documents that you should have. But
Now,
that does happen.
Do you have to list all assets on a financial affidavit?
Within reason, you do have to list your substantial assets. Sometimes I have people that want you do have to list your substantial assets. Sometimes I have people that want to list minutia assets, de minimis assets. We don't really do that. We try to keep it as global as possible. We don't list everybody's clothing or, but we list all the
You mean you don't want me to list my Beanie Baby collection?
cars, generally speaking. But financial affidavits are also a work in progress. We can amend them. And that is part of what happens when you
I guess with this generation, what is it, like Labubu collection?
go through a dissolution. Sometimes more documents come to light. A lot of times when people are getting divorced, they're not always in their best mind, and they're not always working as well as you'd want them to. So it takes a lot of help to get a lot of these documents sometimes. So we amend financial affidavits, and I always tell them, don't worry, we'll amend before we go to court. If we have more documents that come up or we find out more information or you change jobs, we have to do that.
What about non-marital assets?
We generally list non-marital assets as separate if we have knowledge of them. Non-marital assets can be very clean, where you absolutely know something's non-marital, or they may not be, because what people don't always understand, it's an education process as you're educating your client as they're going through divorce. Simply because it's in your name alone does not mean it's non-marital. So it can be in your name alone and still be marital if you have obtained it during the marriage. However, sometimes it can be both, and we have to separate things out. I know with Wendy's case, that was one of the things that happened, is she had an asset that was potentially marital and non-marital because she owned some of it before the marriage, and then she had some of it, she contributed some of it after the marriage. So it's hard to determine how much initially, and we sometimes have to hire expert witnesses, financial witnesses, to come and help us determine what part of this is non-marital and what part is marital. For example, if you have a retirement account and you've contributed to that retirement account before the marriage, everything you contributed before the marriage is yours. It's not marital. And whatever increase in value due to the market is also non-marital. So if you have $100,000 in a retirement account, you get married, that $100,000 theoretically, except for 2009, that $100,000 continues to grow, so you're entitled to the growth on it too. It's non-marital. So that's why sometimes it gets very complicated and we can't determine it initially.
So again, they're explaining all this because they're going to get into the part where Dan Markel, months into, I think like in the beginning of 2014 is when he throws the accusation that Wendy was hiding assets and he was going to go after Wendy and this attorney.
When doing a financial affidavit, but we do try to determine it by the time we get to court at least.
Okay. Now, I want to back up a little bit. What happened with Wendy Adelson's relocation?
She did not win her relocation.
Can you tell us what happened at that hearing?
So we had a hearing on the relocation. We put on Wendy Adelson, and she testified about the reasons that she wanted to move. She did have a job offer in Miami. We put on...
She had a job offer in Miami. This whole thing, I think, was just fabricated with Donna. So wasn't there an email or a text or I forgot what it was, but essentially someone testified. Who testified? This was like within the first couple of days of the trial. Donna was saying that Wendy had a job offer in South Florida. This job offer was going to pay Wendy $1 million a year, and that she was going to have more time, more freedom with her children. It was at this law firm. They were going to make her partner. And I was like, damn, that sounds a little too good to be true. So what happens? Wendy ends up moving down there after Dan Markel dies, and the firm didn't end up hiring her. And then the family were pissed. So I don't know if Donna was just if the person was just talking the talk, or if Donna was trying to get this person to come up and testify and lie on the stand or something like that. But there was someone from that firm that came up and testified saying like, yeah, Wendy, we're going to offer her a job. She's going to work in my firm and stuff like that. Oh boy. But that never came into fruition. And I forgot who testified about that. Maybe was it Jeff Lacasse? Oh boy.
On the lawyer from the law firm that was had offered her the job. He testified about what the job would be, how much more money she would be making, and the flexible hours, et cetera, et cetera. We put on all of that, and then at the end of our testimony, the judge asked to speak to counsel, which happens a lot, and she took counsel out. It was me and Professor Markel's lawyer, and she told us she understood.
Oh, and I think this is the attorney that Charlie and Donna were complaining about. Like, oh, we're paying this attorney so much more money and we're losing all this to Dan Markel. They were so angry at Dan. They were so bitter.
Understood why Ms. Adelson wanted to move, but she wasn't going to allow it because she didn't think she had met her burden of proving it was in the best interest of the children.
During that hearing, or after the judge made those comments, did Wendy go out in the hallway to speak to her parents?
Well, after she made those comments, I went to both Mr. Duggar and I went to our respective clients. We told our respective clients what the judge had said, And basically, if the judge had already determined this without hearing from Professor Markel, we didn't really have a chance of winning this at all because she'd already heard the best case of our case. So I talked to Wendy about that, and then Wendy's parents were there, and
I don't understand how this is good for the defense in any way. It seems like when they were going through the state's emails, the defense was trying to allude that Donna didn't know that when the judge denied the relocation with prejudice, Donna didn't know that this was like a done thing, that it wasn't going to be something that they can litigate again in the future. And then remember, when Wendy testified a couple days ago, remember Wendy's shitty excuse? This is what I'm saying. If Wendy ever goes to trial, I don't know if she will, but if she ever does, remember how she was testifying saying that, oh yeah, it was denied with prejudice. I actually forgot what with prejudice meant. And so she thought that there was still a chance that they can still fight for relocation. Not only that, when the state was going through the state's emails about Donna, you know, essentially saying that like she was scheming and all that stuff. Well, the defense was trying to say that Donna didn't know that there was no choice, no chance. And then I was like, I have a hard time believing that. You're telling me this attorney right here represented Wendy for almost 2 years. And after they had this major hearing, she never explained to them, hey, the relocation was denied with prejudice. That means that's all that we've got. Like, it kind of sucks. Sorry, guys. Like, we can't file for this again. That's what I had a hard time believing. Not only that, but there was also Wendy's an attorney. Wendy went to law school. She should know what it means. And also, Donna was outside of the courtroom because she was waiting to testify. You're telling me no one told Donna what was happening? She's telling otherwise. She's saying that like, oh yeah, you know, I was there. You know, I talked to my client. Wendy was there. Wendy went to go talk to Donna and tell her what was going on. I feel like it's just unfolding for the defense right now and for Wendy Adelson as well. Her attorney is here testifying, essentially saying that it seems like Wendy's lying. What a crazy thing. I'm so this is so wild to me.
What the judge had said. In basic clients, we told, well, after she made those comments, I went to both Mr. Duggar and I went to our respective clients. We told our respective clients what the judge had said. And basically, if the judge had already determined this without hearing from Professor Markel, we didn't really have a chance of winning this at all because she'd already heard the best case of our case. So I talked to Wendy about that, and then Wendy's parents were there, and I
talked to Wendy about that. Wendy's parents were there, so you explain it to them. Oh gosh. And then remember, there was that when I guess like when the defense was maybe trying to say that Wendy didn't know. Well, sorry, the defense was saying that. When the defense was trying to say that Donna didn't know that the relocation case was just completely done. Remember how Georgia Kappelman, or maybe it was Sarah Dugan, pulled up the emails with Donna venting to a friend a couple days after the hearing, saying that it's done, there's no appeal on this, essentially to combat against what Donna's defense, saying that Donna didn't know what was going on. And then this makes it even worse. Oh gosh. How is this helping the defense like right now?
We spoke to Wendy and her parents, and then she went and spoke to her parents again, I think, if I can remember. It was a long time ago, but I think she spoke to her parents outside of my presence as well.
Did Wendy ultimately stipulate to the withdrawal or the denial of that petition with prejudice?
So what happened at that point was we went back into court. The judge denied Professor Markel's motion to dismiss because he had filed a motion to dismiss our pleading.
I was thinking maybe she'll testify. I should have said that, like, you know, after the hearing was over, I had an emergency and I had to run out. I didn't have a chance to talk to my client. I didn't have a chance to see if Wendy talked to her parents. But no, she said, I talked to my client. I explained to them. I explained to Donna, Wendy. They were all there. And then Wendy talked to Donna.
She found our pleading to be sufficient, so she entered an order denying his motion to dismiss. She entered an order that we stipulated on the records that we would agree to the denial of the relocation. And then she entered another order where we all stood there and worked through with the judge what the temporary visitation would be for the next summer and the next several months before we got to another agreement.
And at this point in time, I believe it was approximately the third week of June of 2013?
Yes.
And what was Wendy's reaction?
At that point in time, I think she was upset that she wasn't going to. Nobody wants to not win their case. She was upset. She was always calm during all of my meetings with her. She understood. She's a lawyer. She understood what I was telling her in terms of the legal ramifications. I think she was resigned.
She understood. Oh, Wendy, you were lying on the stand a couple of days ago. She said, Wendy understood. But Wendy testified a couple of days ago saying that she didn't know what with prejudice was. And they thought that she still had a chance and that mom didn't know that they didn't have a chance anymore. Oh, what a mess.
Her. She understood. She's a lawyer. She understood what I was telling her in terms of the legal ramifications. I think she was resigned to it. We did speak a few times after that because we had to get geared up for the next round of this. We had already gone to mediation before that, and we had not been able to agree at the mediation on the relocation. So we knew we had to go to another
Does this attorney know what Wendy testified to a couple days ago?
mediation. So I talked to her several times about the next mediation, which would be dealing with all the other parenting issues and the financial issues. So I did talk to her quite a bit after that, and she seemed resigned to it.
Now, although the court denied the petition, would it have been
Draw them a diagram. She basically saying she did everything except draw them a Venn diagram or diagram about a relocation with prejudice hearing.
possible for Wendy Adelson to offer Mr. Markell any financial incentive in order to convince him to change his mind?
Well, we hadn't finished the case. We still were going to go to another mediation. It's always possible. I tell everyone that even after an unsuccessful mediation, people settle their cases on the eve of trial all the time in some way or another. They do. And it's always best if you can settle your case and not leave it to a court. You have much more control if you are the decision makers rather than the court.
Is there anything improper or illegal with one party offering a financial incentive to the other party to obtain relocation?
No, and I actually have negotiated that in the past
Now,
and since that time as well.
Subsequent to that hearing, did you have another mediation on the dissolution, the distribution of assets, and the parenting time?
We did. And at that mediation, we came very close to settling it, and we were there for quite a long period of time. But we did not settle it at the mediation. I think we settled it within a week after the mediation, where opposing counsel and I exchanged a lot of phone calls, and because we had gotten very, very close at mediation, and we were able to resolve all of it within a week of mediation.
Now,
Before we had a court trial set, I believe, and so we were able to do it before the court trial.
Thank you. Prior to adjourning mediation, did an issue come up concerning a potentially non-marital asset that Ms. Adelson had?
It did.
And what asset was that?
It was if I remember correctly, it was the Charles Schwab account that we had listed on the financial affidavit in the marital portion, and then on the non-marital portion, we had listed Charles Schwab non-marital portion to be determined. And we went into mediation in that way, not knowing exactly what was marital and what was not marital.
So she explained earlier that months before, they all had a meeting discussing the Charles Schwab account and all the assets and stuff like that. And now, after the relocation was denied, and this is like months into, maybe we're getting towards like the end of 2013 and the beginning of 2014. There was a lot of back and forth between Dan and Wendy, it seems at this point. And Dan decides to go after Wendy and Wendy's attorney. So this is where they're like leading up to right now.
Now, I know in our pretrial discussions, you indicated, can you typically talk about what happens at mediation?
Mediation is confidential, and that's one of the things I tell my clients is that the mediator can't be called to testify about what happened in mediation, and I can't testify about what happened in mediation, et cetera, et cetera. So the theory behind that is that people will be as open to negotiation without fear that it's going to come back in court and hurt them in some way in front of a judge. You can't talk about the settlement offers that were made. For example, in mediation, if they say, oh, but he offered to pay child support above and beyond child support, and then we don't reach an agreement, you can't come into court and say, but he made this offer. So it keeps everybody moving forward and not worrying about what the offers are.
Is there an exception for disclosing what happens in mediation if you're ordered to do so by the court?
There is. And there's also an exception about what happens in mediation if the marital settlement agreement is asked to be set aside for some purpose like fraud or overreaching or something like that, then the terms of it and the mediation would potentially be able to pierce that veil of confidentiality.
But for our purposes, in order to talk about what specifically happened concerning that asset in mediation, do you need the court to order that you disclose that information?
I would certainly like the court to order that. I don't want to fall foul of any mediation rules. I can tell you that my client has waived that confidentiality. The mediator, who was a friend and a lovely person, Joe Boyd, he is not with us anymore, and Professor Markel is not with us anymore. So a lot of people in that mediation are gone, and Ms. Adelson has waived confidentiality.
With the waiver of confidentiality by your client, I will order you to testify on the subject matters being inquired into. The state may cross-examine as to all subjects as well. You may continue.
Thank you very much, Your Honor. Ms. Adamson, can you tell us that Charles Schwab account that you mentioned, how was that addressed at mediation?
So this became sort of a last-minute little dust-up during the mediation. So what we did was we called the Charles Schwab account representative. And this is not uncommon in mediation, and I had Joe Boyd, who was the mediator, come in and talk to the Charles Schwab account representative. So it wasn't just me talking to the representative and telling the other side what had happened. I wanted the mediator to actually do it and to hear it. And so he talked to the Charles Schwab representative, who outlined, in his opinion, what the possessory status of that Charles Schwab account was, who owned it when, where it was, how it had been separated into multiple counts apparently, and which ones were marital and non-marital. And then he went into the other room. We're not in the same room. We're in, Ms. Adelson and I are in one room, and Professor Markel and his lawyer are in another room, and the mediator is going back and forth between the two rooms. So in our room, he listened to the what the Charles Schwab representative said, and then he went into the other room and told them what he had said. And after that mediation, Mr. Duggar and I discussed the fact that it actually happened, and everybody felt comfortable with what was marital and non-marital.
How is this relevant, and how is it not hurting Donna's case and reiterating the motive? I don't know. I mean, and earlier on, she said that it wasn't a contentious divorce battle.
And that was...
I think so far, she's already proven that Wendy lied about... It's possible that maybe she really sucks as an attorney and she didn't properly explain to Wendy. And it's possible that Wendy really did forget what with prejudice meant. Do I believe it? No.
When, along with other little things about the parenting and other loose ends being tied up, we were able to actually have a marital settlement agreement. The Charles Schwab account, in all its different permutations, was listed in the marital settlement agreement. And Professor Markel had almost $500,000 worth of non-marital Charles Schwab accounts of his own.
Okay.
So he had non-marital money as well.
So based on what you've discussed, Mr. Markel was aware of the non-marital status of that portion of Wendy Adelson's portion of what she would get.
He was.
And as you said, shortly thereafter, that case was settled.
Within a week, I think. Ish.
Shortly after the divorce was final, did Wendy invite you to a get her groove back party?
I don't remember when the party was, whether it was a month or 2 or 3, but she did.
Oh boy, can we see the event invite for that one? I want to see what the cover page is.
Invite me to a party in her new, I think it was an apartment or townhouse. I don't remember what it was exactly, but she invited me to a party. It was called Wendy Gets Her Groove Back, and I had several friends I knew of Wendy's that were there as well, and it was just sort of a, Wendy's in a good place, come celebrate my new life.
Did she vomit at the table?
Party, yeah, in Tallahassee.
Throughout the course of your representation, could you tell us the total amount of attorney's fees and costs that you incurred in this case?
I think the total amount of costs and attorney's fees, we did take a couple depositions.
Don't forget to leave some touch DNA on that like button. Thanks, John. Appreciate that. Lawyer Not Understanding Prejudice. No wonder she didn't get a show. Hi, Suki. Hello. I don't know. I'm still kind of warming up to the hair color. It's a little bit reddish for me, and I like a little more chunky highlights, but I didn't communicate that with my my hair color, so it's my fault.
We had 2 mediations.
All right, talks about mediation. I think it was like 30 grand overall. She said 30 grand, may sound a lot, but it's actually not a lot compared to my other cases.
A lot, but it wasn't that much compared to a lot of litigated cases.
Okay. Now, litigated cases have multiple evidentiary hearings.
Correct.
Did this?
No, we had. I don't believe we actually had any evidentiary hearings. The only other hearing that we really did have was post-dissolution.
So aside from the relocation, prior to the divorce being final, there were no contested hearings?
There were no contested hearings.
Now, subsequent, did the marital settlement agreement require that Mr. Markel pay Wendy and yourself certain sums?
So according to the marital settlement agreement, Professor Markel kept the house. So he was supposed to pay Wendy for her part of the house. And all the other assets were divided equally, so that he kept an equal amount, she kept an equal amount. He was supposed to pay, I think it was about $120,000 for his part of the house within 60 days. He had the money because he had more than $500,000 in non-marital assets, and he had also marital assets as well. He was supposed to pay me $10,000 in attorney's fees because he made a lot more money than Wendy did, and it's based upon, attorney's fees is based upon who has more resources, and he had considerably more resources than Wendy did. So that was part of the agreement. He was supposed to pay me $10,000, he was supposed to pay her $120,000, all within 60 days of the agreement, which was July, sometime 2013.
July 31st?
And then Dad was like, nope.
I think that's right.
Did Mr. Markel pay the sums that he was obligated to pay under the settlement agreement?
He was supposed to transfer, if I remember, from one of his Charles Schwab accounts to Wendy, the money. He gave her $50,000 of the $120 in a pretty timely basis, and then he just didn't pay the rest. And I don't like to file enforcement hearings on things like that because it takes a long time to get to court. It's not fun. It's just kind of, so I was pretty much once a week or once every other week asking opposing counsel if Professor Markel was going to pay.
Did he pay?
He did not.
What did Wendy ask you to do to enforce that?
At some point, I wrote a letter, I believe, to opposing counsel. So this was, first it's a bunch of emails and phone calls, and then it's a letter saying, please pay, so we don't have to file an enforcement. A part of our marital settlement agreement, if we have to file an enforcement and we win, which we would have because he had to pay, then he would also have to pay additional attorney's fees for doing that. So then it just becomes more and more money that he owes and he's not paying theoretically. So, and this was all on property issues. So unlike custody, we're not going to be able to, or child support, we can't put him in court or in jail. We're not going to be able to put him in jail or anything like that. We're only going to have to be able to go after his assets and things of that nature. It's a lot easier. People will just pay. So I finally filed a motion for enforcement saying he'd only paid $50,000. He owed the other money, and he owed me money, and I asked for a court hearing on all of that.
Okay. Sounds like it was a pretty straightforward motion that you filed?
It was pretty straightforward. It was probably 4 or 5 paragraphs.
Okay. Did that prompt Mr. Markel to pay?
No, I did not.
What happened?
So then Mr. Markel hired a new lawyer. And his new lawyer filed a responsive pleading to my motion, basically saying that he shouldn't have to pay because Ms. Adelson had breached the marital settlement agreement.
How did he allege that she breached the settlement agreement?
He filed multiple motions, but this first responses and motions, this first one, basically, if I remember correctly, was all about the money. And he said that...
So I think we're around 2013, end of 2013 to around like beginning of 2014. Somewhere around there.
He shouldn't have to pay because she had hidden the Charles Schwab money from him, and he used to have power of attorney, so he knew that she hid the money, which doesn't make sense because if he had power of attorney, he would know what the money was. So it didn't make sense to me. But anyway, that she had hidden that money and that she hadn't told him about several other of her retirement accounts, and therefore...
It just kind of sucks because we don't have Dan here to explain it, so we don't have his side of the story. I don't know if it's even worth for Georgia to even call Dan's attorney to testify about this, to rebut what she's saying. I don't know if it's really that important, but yeah. I mean, we're only hearing one side of the story at this point, so. Oh, God.
Or the marital settlement agreement was breached and he shouldn't have to pay her the money.
So he filed a response, but did he seek to have the settlement agreement itself voided or set aside?
He did not. So, and that is what I told Wendy at the time, is that is not a proper defense for not paying the money. Professor Markel, it was pretty obvious that he had actually written this pleading himself, and the lawyer just signed off on it. It had footnotes, which is not something litigation lawyers would do. It was voluminous, and it was very personal about what was going on in Wendy and how I don't think at this point he alleged that he might have alleged that she had committed fraud. But an appropriate pleading would have been for him to file a 12.540. I know it's kind of technical, but basically if you think that an agreement is reached and it is not in good faith, or there's assets that were not provided, then you must file within a year for a 12.540 to have the whole agreement set aside. You can't just say one good breach is another. And I filed a pleading basically saying that his motion should be dismissed because it was inappropriate. And
you filed a motion?
I don't know what's going on right now, but I have the live stream up for the case, sorry, for the trial, and they took a little break. Something's happening, and I guess the defense is scrambling to find their witness. I don't know what's going on. Or maybe they finished a little too early with this witness.
A strike as a sham pleading?
I did. I filed a motion saying this was an inappropriate pleading and it should be dismissed because it wasn't the correct way to go about doing what he wanted to do. And so I then tried to set hearings on those motions so that we could move this forward and everybody could get paid.
Now, in the process of doing this with his responses, did he file subsequently a pleading that further alleged fraud on Wendy's part?
I think he filed at least one or two more pleadings that did that.
And before we get to the final one, that, you advised Ms. Adelson along the way of what you just told us about the unlikelihood of his success.
I did not think he was going to be successful in his response because it was an inappropriate pleading and it should have been dismissed, which I believe it would have been dismissed. And you can't say, I'm not going to pay you because you breached this agreement by not giving me documents. That just, first of all, there's a lot of case law that says that if a case is heavily involved with mediations and lawyers and all these documents have been produced, you had your shot at it. So he was not going to be able to do that. Plus, I knew that he knew about these assets because we had that conversation at mediation, and I had several conversations with his lawyer afterwards, and the marital settlement agreement listed all these.
This makes me want to read it now. I don't think I've ever read of it. I've seen excerpts of it. And it's been referenced in pretrial stuff, but I haven't actually read this entire pleading that Dan Markel wrote. How many pages is it? Does anyone know?
Assets that he was claiming he had no knowledge of, and they were already listed on the marital settlement agreement. So it was not, in my opinion, a successful response, and I told Wendy that it wasn't, and not to worry about it.
So glad finally caught it live. Definitely the best coverage and awesome chat. Thanks. Thanks, Corky. Thanks, Uki. I appreciate that. Thank you so much for the 5. Thank you for the super chat. I appreciate your support. She getting a little pissy. I think, you know, she got some bitter feelings towards Dan Markel.
Now, there was a hearing in February of 2014. I think the records indicate that that Mr. Markel and his attorney were attempting to depose Ms. Adelson.
So what happened was I wanted to take his deposition so I could find out why he wasn't paying. And their response was to want to take her deposition, which I did not believe was appropriate because we were simply trying to enforce a marital settlement agreement, and there's nothing that would happen in terms of that marital settlement agreement that would require him to ask her any questions. So I did file a motion to protective order so that he would not take her deposition. We went to court on that issue in front of the same judge.
And what happened at that hearing?
At that hearing, which we did not have transcribed.
Maybe he wants to take Wendy's depo because he wants to ask about the asset that he believes, the assets that he believes that Wendy hid.
Which we usually do, but we didn't because it was pretty much a 15-minute hearing. The judge read all of the pleadings, and she said that she was very unhappy with Professor Markel's pleadings. She did not like them. She thought they were a poke in my client's eye, and they were not appropriate, and she never wanted to see pleadings like this in front of her again, but she was going to allow the deposition.
With some limits?
With limits, yes.
Okay.
I don't remember exactly all the limits, but they could only be about certain things.
Now, subsequent to that, did Mr. Markel file an additional pleading concern?
Was that a little smile that Donna had on her face? I don't know, man. It looked like a little smile there, a little micro smile. I think she was happy to hear that the judge was reprimanding Dan Markel.
Complaints that he had about right of first refusal, parenting time, and things of that nature.
So that's the first time, and this is actually almost a year after the divorce, and we're done with the whole divorce. That's the first time that he brought up any parenting issues. And it was a series of issues that he had now about the parenting, and it was that Wendy wasn't allowing him to FaceTime with his children as much as he wanted to. That they weren't allowed to go to be present at the same birthday parties. That if there was a birthday party that he was at, she wouldn't come, things like that. And that she wasn't. I think there was a right of first refusal in it, and that she was let her mom watch the kids, and he didn't like her mom watching the kids, and I think he alleged that her mom was saying bad things to the kids, potentially about him. I think that was the first time.
Yes, let's remind the jury again.
Also, I think it was that pleading where he went on a little bit more about Wendy and how she should probably be disbarred from the practice of law, and that I should be disbarred from the practice of law. I think it was that one.
As he's filing these things, are you still trying to set a hearing, or set the depositions and set hearing on your enforcement motion?
I've still been trying to do that. There were a number of hearings that got canceled. Some of them I think were because of the court needed to move things. Some of them were because I was trying to work this out. Still, I'm always trying to work out a case and not go to court if I can. So we were trying to work it out, but he wasn't paid, and I was trying to set hearings on all of this so we could get the money and we could get his motions dismissed because they were frivolous.
Okay. Now, the one motion concerning his my client, Mrs. Adelson, he referenced parental alienation. Have you dealt with parental alienation in your practice before?
I have.
And what is that?
Well, it's not actually a recognized legal term, and it's not actually a recognized mental health term by the mental health professionals, but it does happen. I mean, we all know that there are parents who do alienate their children against their spouse by saying really terrible things or trying to put up roadblocks to parenting. And I've had cases that were pretty serious in the past where little children, it doesn't usually impact teenagers. By the time they're teenagers, they've already done they want to do their teenage thing. It really truly impacts not children this young either. It's usually like 7 to 9-year-olds that we deal with when we have parental alienation, where they've completely aligned with one parent inappropriately, and not because the other parent is doing something like abusing them or something like that. It's because the other parent truly is putting up these roadblocks. They do use those terms. I've seen it.
Okay. The statements that were included in the March 26, 2014 pleading filed by Mr. Markel that were attributed to my client, would that have resulted in any sort of relief preventing my client from having any sort of unsupervised time with the grandchildren?
No. It's not possible. And I told Wendy that.
Okay. Now, as Professor Markel continued filing things, did you realize that you were going to have to become a witness?
So I can't remember how many pleadings he filed on that regard. It may.
But did Donna know that? Did Donna think that? I feel like Donna still took it as a blow that Dan Markel was coming after her. I think it was an ego thing, and she was like, "Fuck Dan Markel for this." I think that's the reason why Donna got so angry about everything. Just because Wendy's attorney may have been like, "Hey, like there's no chance that he's actually going to win this." I don't think Donna really cared. I think Donna took it really personally.
There have been 3, and it was the last one that he filed. I believe it was in May, I believe, where he said that where he became very personal to me, which occasionally happens. It doesn't usually happen with professional people, so I was surprised. But he became very personal towards me and said that I had committed fraud and that I should be disbarred based upon what had happened. At that point in time, I knew that I was going to actually have to be a witness now in this case. And as a witness, you can't be a witness and a lawyer representing your client. So I knew that I had to withdraw. So I withdrew so that I could testify in the case that was going to come up. And I sought a new counsel for Ms. Adelson at that point.
Did that result in the hearing that had, now, let me back up, had you been able prior to withdrawing to schedule?
And Donna must have been so pissed about that. She loses the relocation. Dan Markel goes after her saying that she should have supervised visits with the grandchildren. Not only that, Dan Markel goes after this attorney to the point that she had to withdraw and they had to scramble and find another attorney. We're just reminding the jury just how angry Donna Adelson can be because of all the stuff that's happening.
The hearing on your enforcement motion as well as Mr. Markel's motions?
I had it scheduled. It was scheduled, but then I had to withdraw because he filed that pleading after it was scheduled. So I had to withdraw, and I called Jimmy Jenkins and asked him if he could please represent Ms. Adelson. He said yes, but he needed more time to get up to speed on that case, so the hearing had to be moved.
Okay. And around this time, were you aware that Mr. Markel had to change counsel again as well?
I did not know that.
Okay. Were you aware that as Mr. Markel is filing these pleadings, including the one in March, that he continued to ask my client to watch the children during his time sharing?
I don't know what they were. I don't know anything about their correspondence. I really only dealt with Wendy.
And on that note, we discussed earlier that it's not unusual for parents or family to be involved in meetings. Was my client, Donna Adelson, involved in any of the meetings that you had with Wendy Adelson during her initial dissolution proceeding or any of the enforcement proceedings after the fact?
She was not involved in any. I never spoke to her except for the one hearing on relocation that she and her husband came to. But even then, it was very brief. They were very nice, lovely people. I didn't even afterwards.
They're very nice, lovely people. Okay, we're getting a little bit of pro Donna here. Look at Donna over there checking up on the jury. I wonder what they're talking about right now. Hold on.
or family to be involved in meetings. Was my client, Donna Adelson, involved in any of the meetings that you had with Wendy Adelson during her initial dissolution proceeding or any of the enforcement proceedings after the fact?
She was not involved in any. I never spoke to her except for the one hearing on relocation that she and her husband came to. But even then, it was very brief. They were very nice, lovely people. I didn't even after the even afterwards. I didn't. They were fine. I had no issues with them. But I never spoke to them. I never emailed with them. They never came to any meetings. They were not involved with me.
Right, because what the state has shown so far was it was Donna working the behind scenes with Wendy. I was like, hey, tell your lawyer this, do that. Here, I'll put my edits in.
And do you have a recollection of whether my client and her husband were in the courtroom for the relocation hearing, or were they out in the hallway?
I believe they were in the hallway. I don't believe they came in.
Just a moment, Your Honor.
Yeah, but you're telling me that Wendy didn't come outside and tell Donna what happened. You're telling me that you didn't explain, this attorney didn't explain to Donna and the family what happened? Which one is this? The relocation, right? Yeah, the relocation. Come on now. I don't believe that shit.
Morning.
Good morning.
So you said you weren't aware of Donna Adelson's involvement.
She was,
All right, we're in cross-examination now. Cross of witness numero 9? Witness number 9. Okay. Kristen.
she was not involved with me.
Okay.
So no.
Did you know that she was drafting Wendy's filings and having Wendy copy and paste them to send to you?
She couldn't have drafted any of the filings because I drafted the filings.
What she would like to be put in the filings? How about that?
I'm not aware of any of that, no.
Okay. Do you know that she was drafting things for Wendy to put in her filings in Wendy's voice?
Not that I'm aware of.
Okay. Did Wendy, though, give you input on things maybe to put in filings or things that she would like said on her behalf?
Not a lot. I talked to Wendy on a pretty regular basis when I was filing something on the phone or by email. And she was a very good client, in all honesty, where she listened to me and she basically, we have clients that don't. Now we have clients that give you ChatGPT and want you to do ChatGPT pleadings, so there's that. She wasn't that client. She would say something like, well, and my pleadings were very short. I mean, my pleadings were very, very short. They were to the point and like, no, dismiss this, that's not true. There wasn't a lot more going on in most of them.
So you wouldn't have knowledge of Wendy sending pleadings to her mom and saying, let's edit this?
No, because I wouldn't have edited it based on that anyway.
Okay.
I mean, maybe they did, but I didn't do it.
All right.
And I never heard about it.
Okay. So this would have been between Donna and Wendy.
If that happened, yeah.
You mentioned that, of course, she had a shot with relocation, but given the situation in this case being that the kids were raised in Tallahassee, the parents' jobs with FSU, you were not personally surprised when the relocation was denied.
I'm never surprised when a relocation is denied.
Because it's hard to prove detriment at that
Well,
time.
I'm always hopeful, you know, but
Right.
And I thought she had a good shot, or I wouldn't have let her do it. I mean, I'm not going to file a frivolous motion, and I thought she had a good shot for a number of reasons.
Regardless, though, of what you think, do you ever have clients or family
Oh, green. Green looks good on you.
members of clients who have unrealistic expectations of what the courts will allow or what you can do for them?
Yes,
Okay. Even given your best guidance?
yes.
Okay. That's not an uncommon thing.
No, that's why parents are often involved in these cases and come to talk to me about what they think I should be doing. Yes, I get that a lot.
Right. And at that relocation hearing where Donna and Harvey Adelson, possible witnesses?
You know, I've been trying to think about that. I think that that's probably why I had them sit outside, is because
Right.
they could potentially be witnesses in invoking the rule. However, I think we had come to either the close of our case.
But you wouldn't know that until
Right.
you were done calling witnesses.
Correct. So
and-
that's right.
Did you explain to your client what prejudice meant? Did you explain to Don and Harvey what it meant?
Yeah.
Okay. So that's why they were
Because Wendy's making it seem like you didn't, Miss Attorney.
in the hallway.
That's
most
why they're in the
likely.
hallway, yeah.
Okay. Not because they didn't care or they weren't involved.
Oh no, they were very nice. I mean, I met them. They were there when I got there in the morning. They introduced themselves. They were very nice. We did our thing. Came back and told them afterwards. Nobody yelled or screamed or cried or did any carrying on, which sometimes happens. So no, it was all very appropriate.
Okay. Do you sometimes have clients or family members of clients who take the news harder than you do when they lose something in court?
I don't like to lose either. So there's that. I don't like it. That's why I don't like to go to court if I think I'm going to lose. That's why I want to settle things. But sometimes they take it really hard, especially family if they're not there. They do.
Okay. And you said Wendy was upset when she was denied the relocation, but she was calm. Oh, let me also ask you this. Wendy Adelson stipulated to the denial of the relocation after you found out behind the scenes from the judge that it was going to be denied.
Correct.
Okay. And she was upset about it, but calm.
Yes.
She's not screaming.
No.
No. Okay.
And I have people do that. I mean, I've had to have my own clients taken by the bailiff out.
I'm sure you've seen it all. And how did Donna Adelson feel about not winning the relocation?
I don't know how she felt. I can only tell you that I came out, I talked to Wendy, and then briefly, as far as I remember, because I mean it was 13 years ago, I think I talked to all of them and kind of told them what happened and what was going on. And, you know, I didn't agree with the judge, but this is the judge, and they get to make the decisions. And I think that Wendy went and talked to her parents without me and then came back and said, okay.
I mean, they're all essentially saying that either you were incompetent in how you explained to them or they just weren't listening to you. But they're saying that, oh, they came out of it not knowing the finality of it.
We're good. We can go into court and we can stipulate,
Okay.
which is what I suggested.
So if there are emails of Donna Adelson being upset about and very disappointed and about it being denied or unhappy with your representation for some reason, that's not something she's telling you to your face?
No.
Okay. You talked about Dan Markell not paying what he was supposed to pay according to the settlement agreement. In Dan Markell's court filings, did he give, and I know you don't agree with those reasons, but did he give his reasons for not paying?
He gave his reasons,
Okay.
yes.
And that included the fact of that he was accusing Wendy of noncompliance.
That's true.
Okay. Eventually, did you seek to have Dan Markell held in contempt of court?
I did. That was part of my motion, was to have him held in contempt of court and enforce it. That's not the kind of contempt where I can throw him in jail.
Yeah, what does that mean, contempt of court? Can you explain that?
So in a child
Not a contentious divorce, by the way.
support hearing or an alimony support hearing, if someone doesn't pay their child support or
Maybe to her, she's like, well, this is all the stuff that happened afterwards, so it doesn't count. I don't know, man. This sounds really contentious to me. She's talking about how both sides are pointing fingers at each other. Dan was accusing her of fraud and Wendy of fraud, that her and Wendy should be disbarred. Oh, gosh. She was trying to have Dan in contempt of the court.
alimony is we can have someone held in contempt of court and put in jail if we can prove they had the ability to pay, but they're just not paying, and then the court can put them in jail until they pay the amount they're supposed to pay. Okay,
Really?
So, because they have it. If it's a property issue, we can't really have them held in contempt of court because it's a property issue, and that was part of why Dan's pleadings didn't make a lot of sense, because he was mixing up property and child issues, and you can't do that. It's strictly property or it's kid issues. In a property issue, it would be a multi-step thing to have him held in contempt of court. He would basically, the judge would have to find that he was not paying, he's willfully not paying, and then...
Could I ask you a different question?
Okay,
I'm sorry.
but even in a property situation, the court could put him in jail ultimately, but it would be multiple steps I would have to go through. It wouldn't be just one step. It would be difficult.
What ultimately is the consequence of that is my question.
So ultimately, the ultimate consequence is we would probably get a final judgment against him for the amount that was owed.
Like a lien.
And a lien against, and we would get a lien against the house, and I have to do this often, I would send them to a debt collector attorney who would then have to file another suit to be able to collect that money, and then they would probably be able to go into his assets and get the assets. So it's a multiple stage process, which is why I just wanted him to pay the money and not make me do this.
So if it was successful, probably a lien. Worst case scenario, he could go to jail. And then him being an attorney, though, could he lose his bar license, possibly? If he's held in contempt of court? Or at least be in trouble with the bar?
He could. I've had lawyers held in contempt of court over these issues before. I haven't had one lose their license yet.
Okay.
But they could. It is a possibility.
Did you inform Wendy Adelson that you were seeking to have him held in contempt?
Yeah, I'm pretty sure I probably did. Because it's kind of a generalized form. It's a motion for contempt and enforcement.
Okay. And then at some point, did he allege that Wendy Adelson should be held in contempt?
I don't know if contempt, I can't remember if he actually said she should be held in contempt legally the way that I was using it. I think his pleadings were much more, Wendy should be disbarred.
Okay.
I mean, that's what he specifically said.
Right.
She was committing fraud and she should be disbarred.
Would you describe this divorce as contentious?
I wouldn't describe the divorce as particularly contentious at all compared to most of the divorces I had. And
Thank you, Sarah. Come on now. The way that she's describing everything.
Would you describe this divorce as contentious?
I wouldn't
You wouldn't describe it as contentious?
fraud and she should be disbarred.
Would you describe this divorce as contentious?
I wouldn't describe the divorce as particularly contentious at all compared to most of the divorces I had, and we settled it. I don't settle a lot of my cases where we actually go to week-long trials over things of that nature. I think it was like any divorce where there were ups and downs of moments where it was contentious and not fun, but for the most part, we kind of settled it. We settled it after mediation, and it wasn't a problem. I do think that this whole issue of the enforcement got a little contentious. I really didn't understand it because he paid the first $50,000 fine, and then all of a sudden he decided not to pay the rest, and I didn't really get it and know why he was doing that, because the parenting stuff didn't come up for like several months afterwards. So none of what he was doing made sense. I think he just got upset with Wendy or something. I don't know what it was.
Okay, thank you for that information. it wasn't contentious, but you did say that his motions were very personal. His pleadings were very personal.
That's where I think it became contentious is when he did that.
Was that personal attacks on both Wendy Adelson?
I think she should have just said that it was contentious. I don't know. It seems kind of weird that she's kind of like protecting that.
And you.
Correct.
And he was alleging that Wendy Adelson committed fraud, right?
Yes.
He's alleging you committed
I
fraud.
did.
It got so bad that you had to get off the case so that you could be a witness on Wendy Adelson's behalf, right?
Correct. That's happened before, though. I mean, I've had that happen before.
And he alleged Wendy should be disbarred, you said.
Correct.
And he's having issues with Wendy's mom, Donna Adelson, even being able to watch the kids, is what you said in one pleading.
One of the pleadings said something about the right of first refusal that he had, and she shouldn't be allowed to have the kids unsupervised, I think, during right of first refusal because she was saying things about him to the kids, he thought.
And did the litigation between Dan Markell and Wendy Adelson continue even after you got off the case?
Once I got off the case, it was the end of June, and I think that he was gone within a few weeks after that.
So you were supposed to be a witness on Wendy Adelson's behalf, right?
Correct.
Were you ever able to have that hearing?
No,
Why not?
because I got a call from Jimmy Jenkins when I was in Tampa at something that he was dead. It was pretty shocking.
Does that happen very often in your divorces?
That does not. We've had a few people get murdered, and I've had a few suicides, but it's rare, and I remember all of them.
Right, but not contentious.
Sometimes I don't know with the suicides. I don't know.
That's all.
Thank you.
Redirect examination.
Briefly, Your Honor.
I wonder if the jury's looking at her sideways for the contentious thing. Oof. Redirect.
And first witness.
You may.
Ms. Adamson, I'm going to approach and show you. I'm sorry. It states the demonstrative A, I think it's exhibit 1, page 441 of the demonstrative. And then I'm holding 454. Can you hold that,
Sure.
please?
Okay.
Is that the March 26, 2014 pleading that Mr. Markell filed?
It appears to be.
Can you turn to 454 that I attacked?
Yes.
Is that the prayer for relief for that motion?
Yes.
Can you direct your attention to the portion that reflects my client's, Donna Adelson's, time with the children? Does that reflect that Mr. Markell was asking that my client's unsupervised time with the children not interfere with his right of first refusal?
I think you're talking about paragraph 6, where it says, enjoin the former wife from allowing the maternal grandmother to have unsupervised time with the children, consistent with the right of first refusal. That was that right of first refusal.
Yes.
And to impose appropriate limitations to safeguard the children from being subjected to disparaging comments about their father.
How does that help?
Ms.
Where are we
Adamson,
going with this?
You testified that the divorce was not contentious, but some of his pleadings post-divorce were contentious.
I think that's accurate.
Okay. And that his pleadings were personal. Essentially, he attacked both Wendy Adelson and yourself.
Correct.
Is that what caused you to withdraw?
I'm very used to personal attacks. I've had a lot of personal attacks. The only reason, and I'm fine with that, the only reason that I withdrew is because I was going to be a witness, not because I cared what he said about me.
Had Mr. Markell not included in his pleadings these attacks, would that hearing have gone forward in May of 2014?
If he had not included personal attacks against me that I would have had to testify about, then I would have continued with the hearing.
Now, I want to go back to relocation. After the relocation hearing, my client, Donna Adelson, appeared to accept the court's ruling. To you.
As far as I know,
You don't know what she said privately, do you?
I do not.
Isn't that like the state's question? After the hearing, she appeared to be, okay, she accepted it. But you don't know what she said behind closed doors, do you? Yeah, we do know because we saw the emails and stuff. It was bad.
Concerning Wendy Adelson's involvement in drafting of pleadings, I understood your testimony on cross to be that you'll take input from clients, but ultimately you're the one who is drafting the pleadings.
I take responsibility for my pleadings, and I've never filed a pleading based upon what a client told me I have to do. I will take input because I don't know all the facts.
It's so funny. Donna was like drafting away. You know, Wendy was pretending to take her inputs and give it to her attorney. It would be funny if Wendy just took it and just like, okay, I'm not going to give it to my attorney. I'm just going to let my mom think that she's like more involved in this lawyer shit than she really is.
Facts. Sometimes I need more facts from them so that I can do it.
I don't think Wendy was telling the mom the truth, man.
I'm ultimately responsible. My name's on those pleadings.
And so you're not going to cut and paste from what a client sends you.
Well, and sometimes if they send me really good facts, I'll sort of go, oh, these are good facts, and then I'll take the facts and I'll put them in, but not legal arguments or anything like that, no.
So if you took facts that were provided to you by Wendy Adelson and put those in the factual statements or arguments concerning pleadings or memoranda, the law is still your own writing.
The law is, and I don't really think Wendy, I don't remember that Wendy had much input into any of it, honestly. She wasn't that client. I have clients that are those clients, and she was not that client. I get a lot of ChatGPT now, a lot, telling me what I should be filing.
Okay.
I don't think you're the only
You've already said that. No one asked.
one there, ma'am. Had you not withdrawn to be a witness, the motion would have been heard in May of 2014.
May or June, whenever it was set. I don't remember exactly when it was set.
Okay,
Whatever the docket says for whenever it was set, yeah.
So if the docket reflects, I think it was May 15th of 2014, the hearing would have gone forward.
Correct.
The judge would have been able to make a decision on all the pending issues.
I believe that's the case.
Nothing further?
Will this witness be recalled?
Just a moment.
Maybe. Get Wendy up in here.
She's free to go about her business.
Thank you.
You may step down. Please call your next witness.
Dun, dun, dun. Do they have a next witness?
Your Honor, the next witness is Linda Bailey. She could be quite lengthy. I don't know if Your Honor wants to take a brief break. Jurors need one.
Do any of you need to take a break or use the restroom? Please raise your hands. A very equivocal wave, but I'll take it. The bailiff will take you to the jury room. Resume at 10:05.
Okay. They said they had a next witness, Linda Bailey. It's going to be quite lengthy. Does the jury want to take a break? That's nice. Uh-oh. Defense team is scrambling and looking at someone's phone right now. What's going on? So they're not scrambling, but they're all like looking at the phone. All right, I'm going to use the restroom really quick. We'll be back, but they take a really long break, and they're still taking a long break. Oh my gosh.
Testifying based on her review of the file. She does have some notes with her if she can't remember something.
That's fine. All right, please stretch your legs or use the restroom if you need to.
Wait, she's right there. Okay, then what were they scrambling then? Sorry, I was only looking at the long crime chat.
We'll try to start
Okay,
with
that's the
10:05.
next witness. All right, y'all. Get up, stretch, use the restroom real quick, and we'll be back in 2 minutes. Ooh, it is cold. I got the AC on. All right. Do we believe Donna's going to testify? I don't know. I thought she was going to testify, but now I'm like... I wonder if she's changing her mind. I wonder if she's got something else up in her sleeve. All right, so they're supposed to take a short little bathroom break, but it is kind of long. Judge is back. Let's see what happens.
When we advised Ms. Bailey of this information.
Well, if whoever's listening on digital, if you can go ahead and look through the sidebars for Thursday and Friday to determine when the topic of Wendy Bailey as a witness was discussed. As I recall, I believe it was discussed that she would be permitted to be in the courtroom. Whether or not there were any other matters that were discussed along with that, I cannot completely recall at this moment, but we'll review. And at minimum, Ms. Kettleman, exclusion is always the most extreme of remedies, and that is disfavored by the Supreme Court and the appellate courts.
I don't know what remedy I could pursue, Judge. That was the one that comes to mind.
Well,
And I'd like them to stop violating the rule of sequestration now.
Hold on, let me slow it down. Hold on. What's wait? Okay,
courts, but
I can't really hear it. Compliment sounds like she's really upset, but she's walking away from the microphone. Georgia, come back! I can't hear you.
I recall, I believe it was discussed that she would be permitted to be in the courtroom. Whether or not there were any other matters that were discussed along with that, I cannot completely recall at this moment, but we'll review. And at minimum, Ms. Kettleman, exclusion is always the most extreme of remedies, and that is disfavored by the Supreme Court and the appellate courts.
I don't
But
know what remedy I could pursue, Judge. That was the only one that comes to mind.
well,
And I'd like them to stop violating the rule of sequestration. That would be the remedy I would seek.
as it related to
I like them to stop violating the rules of sequestration. That's the remedy I would like to seek. George is just so annoyed with the defense right now.
the witness yesterday, I gave instruction concerning that. Concerning Ms. Bailey, we'll review the sidebar. At a minimum, you may question this witness concerning whether she has in fact tailored her testimony based on being in the courtroom.
Judge, I'm familiar with this witness. I don't think she would do that, but as we know, the rules are in place for a reason.
Oh, absolutely.
Things can happen without us knowing they're happening consciously, so that's why we try to keep these witnesses isolated from each other.
You can let the jurors know. I'm going to go to the court reporter's office to check the sidebar. From there,
All right, so they're going to check the sidebar. I think the judge says, I think we discussed that should be permitted in the courtroom. George is like saying, yeah, the defense keeps violating rules of sequestration. So they're going to figure out to see whether or not in their discussion, if they were supposed to be cool with having this person in the courtroom listening to other testimony. Georgia did say that she knows his witness, though. She doesn't think she's going to tailor her testimony to other people's testimony. But, you know, maybe you could do it subconsciously. All right, let's see what happened.
finish this matter.
Hey, Jessica, what's going on? Good morning from Chicago. What's the weather like in Chicago right now? I'm dying over here. It's so hot in LA. I hate it. I hate it. I hate it. I hate it. My divorce was over in like 5 months before a child custody case dragged on for 3 years. It took me that long to figure out that he would violate, I guess, the court order out of spite. Oof. Well, I hope you guys are okay now. At least for the sake of the children or something, you know? So hot, I hate it. I know, me too.
Hot from the presses from our very capable court reporters. Has everyone reviewed the transcript at this point?
Yes, Your Honor.
Please make your argument.
Judge, I mean, I think it's clear from the totality of this that I am agreeing for their experts to review the testimony of other experts, and that in reference to lay witnesses, experts are not going to listen to the testimony of lay witnesses.
Mr. Zellman.
Judge, on page 62, we specifically said Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies And then I addressed our forensic expert to share the transcript of Sergeant Corbett's testimony. Certainly, I see later where we're discussing as to the lay witnesses, page 63, starting lines 11 through 14, as to the lay witnesses, so non-experts, other than Linda Bailey and Kelsey Guy, to be able to observe witnesses. We were not asking for that.
As to both the context and the discussion that's concerned an adverse expert listening or reviewing or listening to the testimony of the other expert. Ms. Adamson was called as part of your case in chief. Ms. Bailey is being called in your case in chief. Ms. Adamson was not an expert. The state never agreed to what is being discussed now. Why should this witness be permitted to testify?
Defense, what are you doing? What is going on here? Are these, I'm genuinely asking, are these rookie mistakes, or is this an oversight, or is this just, what is going on over there? So, audio is like kind of meh. Georgia said she was okay with Linda Bailey, who's going to be the next witness. She was okay with Linda Bailey because she's an expert, with going over expert testimony. She didn't expect, I guess, Linda Bailey to be watching lay expert testimony, and the judge was saying that Ms. Adamson, the attorney that just testified just now, she's not an expert. The state never agreed to having Linda Bailey watch her testimony. Why the fuck was she here? And why should I let Linda Bailey testify next, defense? What's going on?
Judge,
Why should this witness be permitted to testify?
Judge, the prior page specifically says that Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies.
You brought this up, yes, but the state made no agreement as to anything but an adverse expert as to observation of testimony that would otherwise go to the rule of sequestration.
Kind of quiet over there.
Judge, with respect to the context and the statements, we were obviously asking that.
It's in black and white. I know what you asked. What happened, though, is the opposite of that. As to that, what is your argument now?
Your Honor, exclusion of a witness is an extreme remedy, as you recognized previously. We took the court's, this conversation to authorize Ms. Bailey to be present during Kristen Adamson's testimony. And that is what we advised the witness when we spoke with her later in the week. But for this conversation, we would not have done that.
This is the second time in this trial where a defense witness has been in courtroom inappropriately in violation of the rule of sequestration. When this was addressed at sidebar, you brought up the topic, but the state only agreed as it related to your expert reviewing an adverse expert, their expert's testimony. That has not been the case today. Why have you not been more careful with this individual, or even brought up this topic to make sure we did not end up in this point in place?
Judge, we thought we adequately addressed it last week during the sidebar.
Ms. Cappelman, what are you asking for?
Seeking exclusion, Your Honor.
Oof.
As to exclusion, what is your argument?
That this is not the first time this has occurred, that this issue was addressed at sidebar, the ruling was clear, that witnesses, that our experts would be permitted to listen to, and only in that circumstance, and that particular exclusion, which we're all familiar with in the rules, the other side's experts. So I'm just a little miffed that here we are. I didn't ask for any exclusion the first time this happened, or really any remedy. But you
Sorry,
admonished
no.
the defense to not let it happen again, and now it's happened again. So, does the state get a fair trial too? Do we get a remedy when it's the second time that the rule's been violated? I think it's appropriate. So.
As to your point of the state getting a fair trial, Ms. Cappelman, the court is bound by the rulings of the Supreme Court and the appellate courts. I don't get to make it up on the fly. Clearly, this has happened twice, but moving to exclusion, again, is the most extreme remedy.
Judge, if I may,
Last word.
viewing Earhart.
Exclusion is like the most extreme remedy. I think the judge is going to probably do something less severe. I don't know, maybe do you just limit their testimony or something, or just let them testify?
exclusion of the witness, court may exclude the witness only if it finds that the testimony of the challenged witness was substantially affected by the testimony to be heard, to the extent that his testimony differed from what it would have been had he not heard testimony in violation of this rule.
Which is why I believe you wanted Ms. Bailey to listen to Ms. Adamson's testimony in the first place.
I'm sorry?
You wanted Ms. Bailey specifically to listen to Ms. Adamson's testimony for a reason.
Our expert requested it, yes.
As it relates to what you just read in that passage, how the expert's or the witness's testimony somehow would have changed or been affected.
I think the only way to determine that is to speak with Ms. Bailey concerning her testimony.
Ms. Bailey, come to the witness stand so that Crawford can be taken on this matter. I need to make a ruling.
All right, proffer time.
The testimony you're about to give will be the truth.
The jury's not here, by the way. They're going to proffer, and then the judge is going to decide whether or not he's going to allow her to testify.
I do.
Please be seated. You may inquire for the purposes of the proffer.
Thank you, Your Honor. Good morning, ma'am. Can you please introduce yourself to the court?
Yes, my name is Linda Bailey.
And Ms. Bailey, were you retained as an expert on behalf of the defendant, Donna Adelson, in this case?
I was.
Specifically in what area?
The scope of my requested testimony was to evaluate the divorce docket, pleadings, motions, orders, etc., in the Adelson-Markell divorce, and to opine whether or not the divorce would be exceptionally contentious or unusual within the context of a family law case.
What? We're going to spend so much time on this witness? Why? Donna has other things she needs to worry about. There's just so much more. Okay, I guess. Zelma did say that her testimony was being lengthy.
In the course of preparing for
Okay.
your testimony, can you briefly summarize what you reviewed?
Yes, the primary source that I reviewed was the family law pleadings, motions, notices, orders that were provided in a prior litigation in this matter. I think it was an exhibit from the state which detailed all.
I'm in IE. It's the worst. Where's IE? Where's that at? That's not in America, right? Are we starting the murder trial? No, we are litigating whether or not this is a divorce is contentious.
The pleadings in the family law folder. So that was my primary source. Then other than that, I spoke to Ms. Adamson for about an hour a couple weeks ago just to confirm what I supposed were facts. And I have known Kristen for 40 years. We went to law school together. And I know how she practices. I practice against her often. So I had some ideas about the lack of strength of Mr. Markell's motions. And
Defense is lost in the sauce. They are lost in the hoisin sauce. If anyone eats pho, you would know what hoisin is. Yum, 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 yum.
she agreed. I read her prior testimony in one of the other trials. I think it was Charlie Adelson's trial. I reviewed some exhibits, but they weren't very helpful to me. They were, one of the officers had done some sort of a PowerPoint presentation with faces and arrows and timestamps for communication, and I don't even know why those were provided. I didn't take anything from those. I reviewed
Did you review some emails?
I reviewed texts and I reviewed emails. So I reviewed emails between Donna Adelson and Wendy Adelson. There were a couple between Donna Adelson and Charlie Adelson that were much later, but they happened to be in the tranche of documents that I had. I reviewed text messages between Wendy Adelson and Dan Markell. I read some text messages between Donna Adelson and Wendy as well.
And in preparing for trial in this case, did you request court authorization to sit in on the testimony of Kristen Adamson?
I did.
And why was that?
Just to confirm that I had the facts correct.
Okay.
And I did.
And you sat this morning through Ms. Adamson's testimony.
I mean, I guess it's like, hey, guys, the divorce was not contentious. Look, we even have an expert that's going to testify that it wasn't contentious. We even have Wendy's attorney that's going to say it wasn't contentious. So why would they have a reason to kill Dan Markell? Well, the relocation was still denied. That's the reason why.
Testimony.
I did.
To what extent, if any, is your proposed testimony impacted or affected by the testimony you heard from Ms. Adamson?
It was very consistent with what I believe the facts to be, so it didn't change what my opinion is.
Nothing further for purposes of the proffer?
Job well done. An examination for the purpose of the proffer.
So it was very
Some
consistent with
poison
what you knew
sauce.
before. Was there anything new that you learned from Ms. Adamson today that you had not learned previously in your
No.
preparations?
I think so.
Okay. No, Your Honor.
Please step down, Ms. Bailey.
She's so annoyed. She's so annoyed. Georgia, I feel you, man. I feel you.
Turn in a few minutes.
All right. Judge is going to make his decision. Long. I'm sure he's going to maybe, he's going to reprimand the defense again, maybe.
Concerning this issue of the testimony of Wendy Bailey, the court is going to find there has been a second violation of the rule of sequestration by the defendant. The matter that was discussed at sidebar brought up the issue of a witness sitting in court. However, the state made no agreement beyond an adverse expert listening to the testimony or reviewing the testimony of their expert. With no other ruling being made on the issue, Ms. Bailey should have not sat in courtroom. The test for determining whether a court may properly exclude the testimony of a witness for violating the rule of sequestration is whether the testimony of the challenged witness was substantially affected by the testimony that the witness heard to the extent.
Donna's like, bring Dan back in here. Give me Dan Rashbaum. You know, maybe the state, maybe they need to print out pictures of all, maybe the state should tell the defense to print out pictures of everyone that's going to testify. That way they can give to the state and the state can do like a scan every time when someone's testifying, scan the courtroom, see like if there's anyone who's in here that shouldn't be in here. Not like it's the state's job though. That's the defense's job. I don't know what's going on. But I don't know. I guess just like misunderstanding the sidebar on the defense's part. Major misunderstanding. Major.
Affected by the testimony that the witness heard to the extent the witness's testimony differed from what it would have been had the witness not heard the testimony. And this is citing to a Florida Supreme Court case, Steinhorst versus State 412-72-332. The same test also applies to expert witnesses who violate the rule. Concerning the proffer, the witness has indicated that in preparation for her testimony, she reviewed materials provided by the state. She reviewed testimony from the same witness from prior trials, and ultimately her opinions, whatever they may be, to be offered, have not been affected. As a member of the bar, I am going to give credibility to what Mrs. Bailey has stated concerning these matters, as I have no other evidence to the contrary. Although the state has asked for exclusion of this witness, this being a second violation, it still remains inappropriate. Concerning how the jury is to be instructed at the end of the trial, as to this testimony specifically, if the state is asking for instruction for how the jury is to weigh the credibility of Ms. Bailey or the previous witness who was subject to the rule of sequestration, I believe they are entitled to based on the circumstances of this matter. Does either party need to be heard further?
As long as the instruction that the court is going to give the state's going to specifically be asking for, ask the jury to determine whether the witness's testimony was impacted by what they observed.
We can wrangle over the language at a later point.
I have no objection as long as we can agree on the lecture.
Please bring in the jurors. Ms. Bailey, please come to the witness stand.
All right, defense. No more mess ups, okay?
If there are any additional matters that need to be
Stop stressing out Judge Everett, all right?
clarified, this needs to occur so we don't have any more issues with witnesses or other problems.
All right. Witness number, what now? Number 10, I think, right? Linda Bailey. Oh, what's her title? Marital Family Law Expert. Marital Family Law Experto.
Everyone can be seated. Ms. Bailey, please rise to be sworn.
All right, so this is the second time that the defense has violated court's order. They had a sidebar discussing the first violation, and that's where they discuss Miss Bailey. I guess the defense wanted Miss Bailey to sit in the courtroom listening to the attorney's testimony. The state never agreed to that at all. And when they went back and looked at the transcript, the defense was like, look, but we asked for it. And the judge is like, yeah, but we didn't give it to you. Just because you asked for it, it doesn't mean anything because the state never agreed to that. Oh boy. So she wasn't supposed to be in the courtroom listening to the lawyer's testimony. The judge is going to allow her to come in because excluding her testimony is like a very extreme remedy. So I think judges tend to not want to, make an extreme decision. And, they think that, whatever that she's going to testify to, it's not like she's learned anything new through the lawyer's testimony. And they're just going to trust that, she was being truthful about that. So they're going to let her testify. However, the state, I think, I guess around closing, the state can give an additional statement to the jury about Bailey's testimony and how she didn't follow the rules of sequestration. And I don't know, take what you want out of that one, I guess, for the jury.
Ms. Bailey, please rise to be sworn. Do you swear or affirm the testimony you're about to give?
I'm going to speed through this because they usually talk about her qualifications and stuff like that.
Good morning. Can you please introduce yourself to the jury?
Yeah, my name is Linda Bailey, and I'm a family law attorney here in Tallahassee.
Tell us briefly about your educational background.
My post-high school educational background is I have a bachelor's in psychology from Florida State University in 1983. I worked for a couple of years and went back to law school in 1985 and graduated FSU Law in 1988 with honors.
So math isn't my strong suit, but that's
37 years.
37 years.
I went to school with Ms. Adamson, so
Okay.
we've been practicing the same length of time.
What type of law did you initially practice when you graduated?
When I during law school, and then after I graduated, I initially practiced criminal defense law. Then I brought in slowly a family law practice. And then in 1994, about 6 years into practice, I shifted my focus to solely family law and went on my own and opened my own practice.
So since 1994, have you exclusively practiced family law?
Yes.
Nice.
Can you tell the jury approximately how many family law cases you've handled since then?
All right, we're going to speed through this. Since 1994. I guess you didn't like criminal law. Certifications. Dun, 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 dun. All right.
Materials you reviewed.
Yes, my primary source was the divorce file between Wendy Adelson and Dan Markel. So everything from the petition that was initiated in September of 2012 by Wendy Adelson to the last document filed, which was, I believe, a suggestion of death.
And did you review any other materials?
I reviewed text messages that were provided to me. I believe they came through the state between Wendy Adelson
Oh, I like her necklace. What stone is that? It's like a pretty purple.
and Dan Markel in the 2014 timeframe. I was provided, but didn't review thoroughly, text messages between Wendy Adelson and friends and other miscellaneous texts. There were some text messages between, I believe, her and her mother, but most of their communication, I think, was by email, and I reviewed the emails that I was provided between Wendy Adelson and Donna Adelson from maybe 2011 up through about 2017. I don't know if they were comprehensive because they were provided to me.
Did you also speak with Ms. Adamson concerning her representation of
2011 to all the way to 2017? Why all the way to 2017?
Wendy Adelson?
I did. I spoke to her for about an hour a couple of weeks ago to kind of confirm my impression of some of the motions that were filed.
Now, can you indicated that you reviewed the court file. When was the dissolution of marriage action begun?
It was
So there's already been a spoiler alert about her testimony because they talked about it earlier. She's an expert who's going to testify and say that the divorce between Dan Markel and Wendy Adelson was not contentious.
begun with a petition filed actually by Wendy, which she had a lawyer, Shannon Novi, for a brief period of time, and then she switched to Kristen Adamson. So I reviewed that petition, and that was filed mid-September 2012.
Did Wendy Adelson, in that process, file a motion for the court to determine a temporary parenting schedule?
Yeah, just about a month after the initial petition, she filed a motion for the court to order a temporary parenting plan, which is normal, so you don't have chaos pending a final resolution.
So that the filing of that motion is a typical step in a dissolution of marriage that involves children.
Well, it's very routine because what you don't want is both parents showing up to school, picking up a kid on the same day, and the kid doesn't know where they're going, and it creates a lot of stress for the children if they don't have a plan. So it's important for the parties to get together early on and figure out what they're going to do until the court can make a final ruling.
And what specifically was Wendy Adelson's request in that temporary parenting plan concerning time sharing?
She asked for a plan that would provide 51% of the time to her and 49% to Mr. Markel, which at the time, it was much more traditional, if you will, for there to be a primary parent and a secondary parent. And it was thought at that time that having a child more solidly in one household versus splitting the 50-50 was more advantageous for the child. That thinking has now changed, where there's a presumption of 50-50, but back in 11-12 time period, she had initially filed for majority time sharing, which was ordinary, but then actually in her motion for temporary parenting, she asked for a 59-41, which is 51-49, which is essentially 50-50.
Why would one party ask for 51-49?
Really, the only reason I can think of would be for an IRS tax advantage, so you'd be able to claim the children on taxes.
Claim them as dependent?
As dependents, yes.
Okay. Or head of household?
Yes.
Okay. Now, you indicated that a lot of times these issues, it's important to establish them early on. Did Wendy Adelson and Mr. Markell have to go in front of the judge to get a temporary parenting plan put in place?
No, they worked that out on themselves, by themselves, or through counsel.
So they worked out an arrangement that was beneficial for the kids and allowed them to have time sharing?
Yes, my understanding is they worked out a 50-50 arrangement.
Okay. Now, we're using the term time sharing. We also have, during the trial, heard the term custody. Historically, has the term custody been used in family law proceedings?
Not for many years. Not for many years. Gosh, it may have been a term back when I started practicing, but then it went to primary residence and secondary residence, and then it moved to simply time sharing. So there's been a change in the way we refer to it linguistically, because you don't want a secondary parent. You want all the parents to feel like they're full parents. So.
And so the term custody is not something that is used in family law proceedings any longer?
Not between parents. There's some. The term custody still lingers in some grandparent cases, which aren't applicable here.
Okay. But when we're talking 2012 moving forward, the term custody was not used in family law proceedings for dissolution.
Correct.
Okay. And the term at that time was time sharing and parenting time.
I believe back then it had shifted to time sharing. It may have been primary and secondary residence, but I didn't see that in the petition. She just asked for majority time sharing, so that must have been.
Yeah, the captions, I don't know. They either work or don't work. It's been a little bit weird during this trial, but they help with my note taking. So, and it's like blocking this part right here, so I don't really mind it too much.
When that law switched, it was around that time.
When Wendy Adelson initiated this dissolution, did the pleadings indicate that she was trying to prevent Mr. Markell from having substantial time sharing?
No.
I don't know if like YouTube did an update or something and fucked it up. Can someone give me a TLDR of the charges? Hey, HTTP, how are you doing today? Donna Adelson is charged with murder in the first degree, conspiracy to commit murder in the first degree, and then solicitation to commit murder in the first degree. So essentially, not really her committing the murder herself with a gun. She went through her son, who went through his girlfriend at the time, who went through her baby daddy and the best friend to murder the son-in-law, former son-in-law.
Didn't see anything throughout the whole file. She tried to prevent Mr. Markell from having substantial time sharing.
Can you tell the jury what
It's a whole family tree involvement, all right?
is substantial time sharing?
Well, substantial time sharing, again, the definition has changed. It used to be more, in this era, it was more than 40% time sharing. And now, for the purposes of child support adjustments, it's kind of been reduced to 20% or more. But I think when we're talking about time sharing versus how it impacts child support, substantial time sharing, I think everybody would accept would be 40% or more time sharing.
So, in other words, when Wendy initiated the dissolution against Mr. Markell, she was not trying to prevent him from having 40% or more of the overnights.
I never saw anything other than the 49-51.
In your review of the family law pleadings, can you tell the jury how many contested hearings took place prior to the final judgment being entered?
From my review of the pleadings, one partial hearing occurred, and that was the June 21st, 2013 hearing on Mr. Markell's motion to dismiss the petition for relocation, and then he had filed a motion to enforce life as he would have liked to have seen it, and then the relocation was all within one hearing. The court adjudicated the first two issues, his motion.
Yeah, I actually want to run. I actually want to run an app that listens to this live and then takes notes for me as well. That'll be nice because sometimes the transcripts for the live streams aren't available until like way later. But I'm like, do I really need that? It's like, I mean, I guess like when I take notes in my own words, it's better because I can just highlight the portions that I'm going to use for the video. But yeah, I was thinking of doing that for the future. We'll see.
To dismiss was denied. His motion for enforcement was denied because there was nothing to enforce. There was no court order that required the things he wanted to enforce. And then,
in other words, he was asking the court to enforce something that they had agreed on but hadn't been a court order?
Well, I don't even know that they had agreed on things. He had kind of a sense of the way he would like to see life, which had to do with being really intrusive at Wendy's home. He wanted to go over there often during her time sharing. He wanted to have a great deal of contact. He wanted video contact, things like that. And so, and I think there was maybe a recommendation, I could be confusing this with a later motion, where the child care owner had made a recommendation about something, and he wanted to enforce the recommendation from the owner of the child care. None of those were enforceable because they'd never been ordered by court or even put into any sort of formal document. So that was denied.
So let me understand correctly, he was asking for court authorization to be able to go over to Wendy's house?
In that particular motion, I could look at my notes, but I don't remember exactly the detail. Ordinarily, when you file a motion for enforcement, you have a court order that says the other side has to do A, B, and C. And if you don't do A, B, and C, you file a motion to enforce. But you can't enforce an email communication back and forth where you said, you can have them on Tuesday, and then Tuesday you change your mind. There's no court order to enforce. They just change their mind. So he was trying to enforce.
I wonder if I just turn it off and on. Maybe that will help. No, like it's just a YouTube thing. Because they're also working on this new. Oh, you know what it is? They're also working on this new caption feature where it will auto dub it for you. So I wonder if that has somehow messed up captions in general. Have you guys heard of the auto dub? Yeah, I actually got an email from YouTube saying they're like, "Oh, we're gonna start auto dubbing your videos in different languages. We're gonna roll that out soon." So I was like, "Oh, that's kind of cool." So I don't know if the auto dubbing. No, wait, hold on a second. No, I think it was like auto subtitles. Like they're gonna translate what you're saying in subtitles. Not about the auto dubbing. I don't know if I heard about that, or maybe I misread the email. Oh, that'd be so funny. Have you already seen it roll it out anyway? Oh.
Force conversations that he had had with Wendy that had no court-ordered basis.
Okay. Now, you mentioned the motion, Mr. Markel's motion to dismiss the petition for relocation, his motion for enforcement. Was that also the same hearing where the relocation petition was heard?
The same hearing.
Okay. And based on your review of the file, what happened at that hearing?
Based on my review of the file, the court adjudicated his motion for enforcement and denied it, adjudicated the motion to dismiss and denied it, and he was basically saying that the petition for relocation was baseless and that the court should deny it, and the court said no, it had merit, so we're not going to dismiss it. And then my understanding is before the hearing finished, Wendy essentially capitulated and said, okay, I'll agree to the denial of my relocation. And what's consequential about that is if they could have continued the hearing, finished their testimony, and appealed the order. So by her capitulating and stopping the hearing midway, she waived her right to appeal the denial of the relocation.
Subsequent to the June 21st, 2013 hearing, did Wendy Adelson and Mr. Markel resolve the other issues in their dissolution of marriage?
Yes, on July 31st, they signed a full marital settlement agreement that addressed all issues. So within 5 weeks of the denial of relocation, they resolved all their financial issues. Wendy waived alimony, they adjudicated child support, they put into place a parenting plan, which is kind of also new lingo. A parenting plan is kind of the overarching rules on how you make decisions, how you communicate, who's able to go to events for the children, plus the time sharing schedule, plus communication provisions, how often you can speak to the children. Sometimes, like in this case, it's very general language, maybe what school the children go to. So they resolved everything 5 weeks later. Now,
the marriage settlement agreement also put in place a parenting coordinator?
It did.
What is a parenting coordinator?
A parenting coordinator is a professional, generally a lawyer, but it can be a therapist who is trained. I think they do a 40-hour course too, but I'm not certain. And they have a certification. And what they're trying to do basically is teach people how to communicate, teach people how to be reasonable. There's no parenting plan that you can draft that deals with all contingencies.
I'll turn off the captions for now since she's just giving us like vocab definitions and stuff.
People are always going to come up with something, and we don't have a provision in the marital settlement agreement to deal with that. So a parenting coordinator helps people set, for example, communication guidelines. Maybe one person is calling 10 times a day, and that's overbearing, and it interferes with the other parent's life in households. So a parenting coordinator may help them reach agreement on what a reasonable communication might be. Maybe it's once a day at 7 o'clock. Maybe it's every other day. Maybe it's 2 times by video and 4 times by telephone or something like that. So they help them work out the details and just keep the conflict low.
Now, can a parenting coordinator put in place provisions in parenting plan that are not already included in the marriage settlement agreement?
No, the parenting coordinator's role is to help the parties have a civil discussion and come up with a reasonable resolution. But if there's no reasonable resolution that they accept from the parenting coordinator, then they can go to the court and ask for a remedy in certain circumstances.
In certain circumstances?
Yeah, for example, the parenting coordinator is not permitted to add provisions that are not in the marital settlement agreement. In that circumstance, you can't just go to the court and say, hey, I want this provision added. You have to file a supplemental petition that requires a material and substantial change in circumstances plus best interest. Kristen talked about that earlier. And you have to, it's basically starting a case over. It's very difficult to modify a marital settlement agreement. What you can go to the court for that a parenting coordinator might be involved in is somebody's not returning the child on time chronically or violating communication provisions that are already in the marital settlement agreement. You may go to the parenting coordinator first to try to avoid court and say, hey, can you get him, her to stop? Can you get them to be more timely? Can we find a new meeting location, something like that? And you can go to the court for those types of issues, violations, but going to the court for modifications isn't going to happen unless you've had a material and substantial change. And the case law says that has to be an extraordinary change. So it's very difficult to get a modification or add terms.
Now, with
Not buying the all this is resolved BS. Right. I mean, although she was saying how they were resolving things outside of a judge's presence, it doesn't mean that just because they resolved it, it wasn't like a spicy going back and forth between the attorneys and everyone, right? Or even between Dan and Wendy.
respect to the Adelson-Markell case, other than that June 21st, 2013 hearing, were there any other, did they litigate any other issues?
During the divorce?
Yes.
Up through July 31st?
Yes.
No. No, they resolved everything. Temporary parenting, permanent parenting, support, property.
How many months elapsed between when the petition, the initial petition for dissolution of marriage was filed, and when the final judgment of dissolution was entered?
10 months.
How does that compare with cases that have similar issues?
If you take the relocation issue out, it's probably average. If you add the relocation, it was brief. Most relocation cases take 2 years or so to get to trial, and
One sec. 1, 2, 3, 4, 5.
10 months.
And between when the petition, the initial petition for dissolution, did they litigate any other issues?
During the divorce?
Yes.
Up through July 31st?
Yes.
No. No, they resolved everything. Temporary parenting, permanent parenting,
Resolved everything. Resolved everything. Temp parenting. Permanent parenting. I wonder if things were. I wonder if things were smooth between Wendy and Dan, and it wasn't until Donna's meddling that things started getting a little unhinged or something.
support, property.
How many months
Okay.
during the underlying litigation, so between September 2012 and July 31st of 2013, when it was when the final judgment was entered, did either party file a motion to compel against the other?
No, and what that is if you're upset with the other side because they're not providing either the required financial documents that Ms. Adelson spoke about earlier, or if you do a request to produce more documents and they don't comply, then you would file a motion for the court to compel them to provide those documents.
And that's what we call discovery.
Correct.
Were there discovery fights here?
No, there were no discovery fights. There was afterwards when Mr. Markell's lawyer was trying to depose Wendy about the money he had not paid, but prior to July 31st, there were no discovery fights at all. There were, I think, requests to produce, and there was no motion to compel or any complaint about responses to those. I didn't see any third-party subpoenas to banks or holding companies or brokerage accounts or brokerage companies.
Can you explain to the jury what a third-party subpoena is?
Yeah, so for example, if you believe that a party has an asset that
Okay, so through the other attorney, Zalman clarified saying, all right, so, maybe things were contentious after things were settled, but during the divorce stuff, things were fine. And she's like, yeah. So I think they're kind of playing on a technicality here where technically the divorce proceedings were not contentious because they settled things pretty okay. However, it was things afterwards that happened that maybe you can classify as contentious. Because how this case has been described, the divorce proceedings between Wendy and Donna, was that the divorce was contentious. It's like, okay, well, it was still contentious afterwards then if you want to go by the defense's definition. And the stuff afterwards, it seems like things were really heating up between Wendy and Dan. Dan didn't want Donna around unsupervised because she was saying shit to the grandchildren. To me, I just feel like it wouldn't make a huge difference as a jury. It's like, okay, well, let's just pretend and say that the divorce was fine, and then everything afterwards, maybe we'll say there was some contention here or there. Okay. Sure.
they're not disclosing. And if you know, and
Now, if the state made a gross misrepresentation that, it was so bad between Wendy and Dan, things were horrible, they were attacking each other, and then the defense goes over and says like, oh, well, we're going to have this expert here and show that it wasn't contentious. And then when the expert goes over, you know, the emails between the two of them and it was completely amicable and things were completely fine and the state was completely lying, then that's where it's like, wow, this is actually like, this is a big deal. But where I think the defense is angling at, I just feel like it just wouldn't be a huge deal for me as the jury.
In general, sometimes we do kind of blanket ones, but generally if you know where those documents might be held, whether it's Fidelity or Wells Fargo or Bank of America, then you can do a subpoena. You do a notice first, and then you have to wait 10 days, and then you can issue the subpoena directly to the bank or the person holding those records and ask them to provide you the records directly so you don't have to get them from the other party. So oftentimes, not oftentimes, sometimes we'll have parties who just don't cooperate. They don't provide anything. We know they have retirement accounts. I have one right now, and he will not give us his retirement account because he does not want it split. So
Yeah. So, you know, I guess they're saying that like when the final judgment was entered, she went through and looked through the divorce stuff between Dan and Wendy. There's no motion to compel. There was no third party subpoenas, you know, there weren't parties that were trying to hide assets and not give up assets to other people. Yeah, that stuff happened afterwards. So not only was the relocation denied and shit was brewing afterwards, that's reason for Donna wanting to have Dan Markel. She wanted to get rid of Dan Markel. Dan Markel was winning. Dan Markel was destroying the attorney, I guess, you know, destroying the Adelson family, and Donna wanted to win.
we are having to send third-party subpoenas out to all his prior employers to get his retirement records because he's just not doing it. So it's an easier way to get those records than fighting him directly.
And so in that type of scenario, you'd have to first subpoena his records from prior employers in order to get the names of the retirement companies, correct?
If I need to do that, they could be company-held employment plans, depending on what kind of company, you know.
But potentially in that scenario where you're having to issue third-party subpoenas, there are multiple layers that you might have to go through in order to get the information that the other party is not providing.
No, it's really more direct than that. I mean, once you file your notice of intent to subpoena a third party, you issue your subpoena to that party. The difficulty comes if you don't know who the party is. Then you might have to take a deposition and find out where somebody's been working. Generally, your client knows where their spouse worked, so you have that information in that example. But there could be, like we have a case right now where there's like 140-something real estate properties all over the country. That makes it more difficult, obviously. So we're having to go into databases all over the country in different states to look for people and then find out who the management company is and then third-party subpoena the management company. But that's an outlier.
Needless to say, you didn't have to do any of
And I'm not blaming her in any way. It's she's just here to testify for the defense. She's just doing her job.
that, or none of that had to be done for Wendy Adelson's divorce.
None of that happened.
What about non-party depositions?
What I saw was there was one non-party deposition from Dr. Phelps, who was the owner of Creative Preschool, where the children went. And essentially, I did review that deposition, and it essentially said the kids were doing great. And then there was a deposition of someone who worked at the law school.
And aside from those two, were, I believe, Wendy, was she deposed?
I don't recall seeing that Wendy or Mr. Markel were deposed.
Okay. Now, you testified earlier that you reviewed emails between my client and her daughter.
I did.
Okay. Did you find anything unusual about my client, Donna Adelson's involvement in her daughter's divorce?
No. We have parental involvement, as Ms. Adamson said, often. Sometimes it's employer involvement. Maybe they're very attached to their employer and they want to nurture them, or we'll get siblings who are lawyers involved. So family involvement, and especially moms, I see a lot.
A lot of mothers?
A lot of mothers. They're worried about their babies no matter how old they are.
Now, in the emails that you reviewed, did you see my client's use of the nickname Gibbers to refer to Mr. Markel?
I did.
Did you find that especially provocative?
No. I mean, gibbers means someone who speaks gibberish. And if you look at Mr.
Did Wendy not tell you what gibbers meant? It was like the Jew in boots thing. That didn't we get that out from Wendy's testimony? I think a lot of us were confused what the fuck gibbers meant. I don't know. I didn't read the Jew in boots cat book. I don't know. Maybe that cat does speak a lot of gibberish. I don't know. Oh, okay. So she's saying that the gibberish thing was just like, oh, it's just a silly thing. We're just going to I don't know, man. The jury has already saw the email. They've already seen the emails. The emails were pretty bad. Her downplaying Donna's tone in the emails. maybe the jury would be convinced and say they're like, oh, you know what? Actually, you're right. Actually, maybe the emails weren't that bad. Well, George is going to be here for cross.
Mr. Markel's motions and memorandums and responses he filed in this case, it was somewhat applicable. He was very verbose. If you looked at his writings as a complete layperson, they may at first glance seem somewhat intimidating, but when you broke them down paragraph by paragraph, they were inconsistent. They didn't make sense. They referred to, in multiple situations, he was seeking enforcement of things that were not court ordered, even afterwards in the February 2014 timeframe. So he was very wordy. He would file a 16-page response, and then he'd file a 16-page memorandum that said the same thing, and then he'd file a motion related to that that said the same thing. So he was, a lot of his, the things that he filed, papers that he filed, which were signed by his lawyer, but they were consistent throughout all the lawyers, so it appeared that he was drafting them, were very, very wordy and full of hyperbole.
In that same vein, the lawyers that represented him, have you litigated opposite them in the past?
I have.
The pleadings that they signed on Mr. Markel's behalf, are those consistent with the pleadings that you've seen them author in the past?
No, it appeared to me that Mr. Markel was drafting these pleadings because they just weren't drafted in a way you would draft them, and they didn't, again, make sense. They were internally inconsistent. For example, moving up to the February timeframe, he was complaining about fraud by Wendy Adelson and not disclosing accounts as if that impacted the settlement. But then he said, very shortly or in the same near paragraph that he knew she had these accounts because he managed one of them, and he knew about the other account as well. So all he had to do was do third-party subpoenas to Schwab. He knew a Schwab account existed. That was easy. And so you can't say fraud, I made a decision without knowing, and then in the next paragraph said, but I knew these accounts existed, that's why I know she's committing fraud.
Okay. So in reviewing those particular motions, the one that he filed February of 2014, what was your opinion about the strength of that being granted?
Well, Wendy filed a motion for enforcement at the end of October 31st, I believe, 2013, which complained about the $80,000 or so. I think there was some question whether he paid $50,000 or $51,000 or $52,000. But anyway, he was essentially just around $80,000 underpaid. He hadn't paid his obligation. So she filed a motion at the end of October. Then there was no response, nothing. His lawyer withdrew. There was nothing in November. There was nothing in December. Then January 31st, so 3 months later, he filed a response that basically said, he didn't deny not paying, but he said, her bad behavior, her unclean hands, give me a valid excuse for not paying her, essentially is what he said. And that is not legally, I don't think it was a very strong legal position.
Okay, and we'll come back. We'll come back to that.
Okay.
I want to back up to the June 21st hearing when relocation was denied.
Mm-hmm.
Did my client, in the emails you review, appear to push back on Wendy and try to get her to do certain things?
Well, what I saw from what I was provided in the hearing, I think was on the 21st, and there was a couple of days, maybe the 23rd through 26th, something like that, where...
I'm sorry, but the jury, they can see these emails and communications and make up their own mind about it without having her going in there and then explaining it to us. I don't know. It's like we've already seen what we've seen, right?
Donna Adelson, maybe the reality of the relocation had set in, the denial, and she was upset. So she was sending emails going like, how can we undo this, or is it possible to undo this? And then Wendy responded, I think at the end of that, Mom, I'm at peace, I'm good. And then they dropped off. There was no more communication that I saw
And then
between them.
certainly after the July 31st final judgment, was there anything else where relocation was attempted or discussed?
Not that I saw.
Now, when you are representing
Because of the relocation stuff was probably discussed in person. They were scheming.
clients, how do you handle the involvement of their parents or loved ones in your client's divorce?
If I know that they are very involved, I'll ask to meet with them and bring them in, because what I don't want is our third parties interfering with my advice, frankly. So if they misunderstand the law or they're giving advice to my client contrary to my advice, then I want to talk to them. I want to hear their point of view, and I want to give them my point of view. And I find it's easier for my client to have everybody around them on the same page. So I just want to educate them. If it's a mediation,
I don't remember who called Dan an STD. It was either Wendy or Donna or somebody. I don't remember who.
and I feel like they're involved, I'll ask the other side if I can bring the mother or the brother, whatever, whoever it is, into the mediation, because if they're in the mediation process, then they see how it changes over the course of the day, because other facts might come in, other considerations might come in, because mediation is not just an opportunity to reach a resolution. You learn a lot of information out of mediation. So it's always helpful to have, if there's a family member who's very involved, it's helpful to have them there so they learn as you learn, and they understand how you reached an agreement, and then the litigant, the party, doesn't go home and have to explain what happened.
Do you have situations where clients, family members, or friends are offering advice and it's passed on to you?
Sure.
How do you address that?
I ask them to call me. Sometimes I say, if you don't trust my advice, maybe you should get a second opinion, and generally they don't. And I say, this is why I don't think that advice is valid or is going to help you, and we can have that dialogue. And if they're really strong about it, then I'll definitely ask to say, let me speak to your boss, your brother, your mother, so we can kind of talk through this, because I need them to understand my position, and maybe theirs will change.
Now, you were provided with a number of emails that Wendy was sent by her mother. Did you see evidence that Wendy shared those with Kristen Adamson?
I saw no evidence that Wendy shared them.
And did you speak with Ms. Adamson about that?
Yes.
Okay. Did she receive any of the input from Donna Adelson?
My understanding from Ms. Adamson is she really didn't understand that Donna Adelson was involved at all. I mean, she was there at that one hearing, but that's very common.
Did Wendy Adelson get the parenting plan that she was requesting in her settlement agreement?
She did. The entire marital settlement agreement was very beneficial for her from all the way through. She actually got a parenting plan that was more, I think it was more like 45, 55, something like that. It was instead of 7 days out of every 14 days, he was getting 6 days out of every 14 days with 5 days and then 1 day in the off week. So it was split up a little bit, which was a typical parenting plan for that time period. So she got more parenting than she had really asked for. And that was to last 3 years. And then it went into 50-50. And I think that got the youngest child to school maybe. So they did, until the youngest child went to school, she had about 55% parenting time. Child support,
So in other words, her telling the jury the marital settlement agreement was beneficial for Wendy, and that Wendy got more parenting than she actually asked for. She was able to get more, I guess, like custody for the first 3 years, and then we'll go to 50-50 afterwards when the kids were older. It's essentially saying that she got what she wanted, maybe even better. But not only that, her and her family were so greedy that they were fighting for relocation, and they decided to kill Dan Markel. It's like, whew. Oh, man.
Division of childcare, that sort of thing.
And without going into too much detail, child support is a mathematical calculation.
It's a formula.
And it's based on a number of factors: income, child care, insurance, health insurance, and parenting time.
Exactly. And then Mr. Markel had asked for sole decision-making, for example, because he was upset if the children didn't eat kosher or whatever his complaints were. So he wanted sole decision-making, which is extremely difficult to do. The only time a parent gets sole decision-making is if the other parent is just incapable of making decisions, like drug-addicted or seriously mentally ill, something like that. So that was really also telling that he was drafting that, because I don't know that either of the lawyers that filed on his behalf would have asked for sole decision-making. That's just rarely granted. And so she got shared parental responsibility. He didn't get any superior decision-making that he requested. He also requested for more than 50% of the marital assets, because he said he earned more and he created the assets more than she did, which is not a valid legal position. And she got what appeared to be equal value of assets.
Of the marital estate.
Of the marital estate, which was part of that $120,000 he was supposed to pay her.
Did Mr. Markel get the 50-50 time sharing he was requesting?
Not immediately. He had to wait 3 years for that, by agreement.
And you mentioned keeping the boys kosher. Was Wendy Adelson required that the boys keep kosher?
That I don't know. I think there were some issues about that.
In the marriage settlement agreement, was that required?
No.
Was she required in the marriage settlement agreement to allow Mr. Markel to come over to her home during her time sharing?
No. That would be extremely unusual.
In the marriage settlement agreement, was she required to have the boys available for video calls?
No.
Was Wendy Adelson, throughout the litigation, requesting that the boys be available nightly for her to speak with them when they were with their father?
No.
Was Mr. Markel granted every Jewish holiday?
No, I think he had requested that, but he was not. They alternated the Jewish holidays.
Was Wendy Adelson required to continue counseling with Mr. Markel and follow the advice of those counselors?
No, and that would be an improper order. The court can't delegate decision-making to a third party like a therapist. The court can't say, you need to go to your therapist and follow their advice.
Was Wendy Adelson required, pursuant to the settlement agreement, to equally split time on each of her children's birthday with Mr. Markel?
No, there was a general provision that each parent would get some time on birthdays. but there was no requirement that it be equal. And I really try to dissuade my clients from putting birthdays into agreements because kids don't want to see the parents fight every birthday.
Were either parties prevented from allowing the children to see anyone else unsupervised in the marriage settlement agreement?
No. I mean, the general premise was shared parental responsibility, which is what they have, meaning they have equal rights.
I mean, we're just reinforcing just how good the marital settlement agreement was for Wendy. I guess it can go either way. You can see it as marital settlement agreement being really good for Wendy, and they were just greedy and they wanted more. They're awful fucking people. Or the settlement agreement was really good for Wendy, and she wouldn't have a reason to want Dan Markel murdered. But again, relocation, relocation, relocation. That is the main and major focus.
Rights to get information, make decisions. The whole crux of that is you trust the other parent to make decisions that are healthy for your kids.
Now, pursuant to the marriage settlement agreement, was Mr. Markel ordered to pay both Wendy a lump sum and Kristen Adamson a lump sum?
Yes, he was ordered to pay $120,000 directly to Wendy Adelson and $10,000 towards attorney's fees to Kristen Adamson.
In what types of cases is one party ordered to pay or agree to pay part of the other party's attorney's fees?
Well, there's a disparity between assets and income. So it can be assets or income or assets and income. I think in this situation, Mr. Markel's income was twice or so Wendy's, and his assets, from what I understand, including the non-marital assets, were more substantial than Ms. Adelson's.
In your opinion, was the marriage settlement agreement that was incorporated into the final judgment favorable to Wendy Adelson?
Yeah. Yes.
Now, later,
But it's very fair. It was measured. I say that favorable only because he was asking for things that would have made it unfavorable and that were unusual requests. And at the end of the day, he gave up on those, and they got a very typical marital settlement agreement.
so from September of 2012 until the final judgment in July of 2013, as far as the litigation is concerned, it was not very contentious.
Not at all.
Now, after July 31st of 2013, did either side file any enforcement actions?
Just the 3 months later, the payments for Mr. Markel were due within 60 days, so that would have had them due at the end of September. And so, taking Kristen Adamson at face value that she tried to work this out during the month of October, on October 31st, she filed a motion for enforcement of the 100, well, what's left of the 120, 70-ish, plus the 10 for fees.
Okay. So Mr. Markel had 60 days to pay those amounts.
Correct.
And Ms. Adamson waited until 90 days after the agreement was entered, the judgment was rendered, and 30 days after the deadline, she waited to file.
She did.
I mean, and Dan Marquette wasn't murdered until almost, 9 months later. So this is a portion that you can argue that was very contentious then. And that's why Dan Marquette was murdered.
And even that was a pretty ordinary motion. It didn't ask for any drastic sanctions. It didn't ask for jail time, anything like that, which couldn't have been ordered. It would have just, she's looking for a judgment that she can execute on. So you have to get a formal civil judgment from the court, and then you can execute on that by attaching other assets or garnishing wages, that sort of thing. I've had the court open up and get retirement assets and kind of claw them back from the marital estate to make the person whole who doesn't get paid.
Okay. Now, in reviewing the emails between my client and her daughter after the relocation hearing, did you see any correspondence trying to encourage my client, I guess it was after July 31st, to encourage Wendy to do anything about relocation?
Not that I recall.
From your review of the emails and the pleadings, did it appear my client accepted that Wendy was going to be staying in Tallahassee?
Yes. It was done.
Did you see the emails between Donna and Charlie? Did you see the emails between my client and text messages? Sorry, the text messages between my client and Charlie? I mean, you could paint it however you want, but they already seen the text messages and the emails.
When you say it was done, what do you mean?
I mean, Wendy waived her right to appeal that by agreeing that the relocation will be dismissed. So,
Now, prior to final judgment being entered, would Wendy have been able to attempt negotiating with Mr. Markel to try to get relocation even though the judge denied it?
she could have.
Would there be anything improper with Wendy or her family through Wendy offering some
Hold on, that's kind of interesting. What she just said just now.
my client and her daughter after July 31st to encourage review? When you say it was done, what do you mean?
I mean, Wendy waived her right to appeal that by agreeing that the relocation will be dismissed. So,
Now, prior to final judgment being entered, would Wendy have been able to attempt negotiating with Mr. Markel to try to get relocation even though the judge denied it?
She could have.
Would there be anything improper with Wendy or her family through Wendy relocation even though Mr. Markel to attempt negotiating?
Sorry.
Would Wendy have been able to attempt negotiating with Mr. Markel to try to get relocation even though the judge denied it?
She could have.
Would there be anything improper with
I mean, they knew that was never going to happen, though. For her to convince Dan Markel to quit his job at FSU, move to South Florida to be closer to the crazy family? Hell no.
Wendy or her family through Wendy offering some sort of financial incentive to Dan Markel to convince him to agree for her to relocate?
I see that all the time. I mean, I had a client pay $850,000 to somebody to get her to not relocate. I've seen $35,000 to get
She waived her right because she knew she wouldn't have to appeal. Yeah, she waived her right because the judge said that there's no way in hell they would agree to this. She just, the law, which is not on her side on this. It wasn't like Dan Markel was abusive towards the kids. I think the analogy that the judge used was there's no fingernail pulling or something like that. Oof, that's a very painful visual thing. But yeah. So I think Wendy was like, oh, okay, well, we tried. It seems like, relocation is very, very rare to be granted. And it just doesn't apply to my situation. Hey, from Australia. Hey, Daniel, how are you doing today? How's it going? How's the weather? Well, I guess Australia is a huge country. And depending on where you are in Australia, the weather can differ greatly. I hear the weather in Sydney, I think, is very close to the weather in Los Angeles.
whatever parenting plan you want or to get less time. So depending on your financial circumstances, that number can be wide-ranging, but it's common. And in mediations, it's often common to see where the pain points are. If the pain point is money, then you use that pain point to get what you want on parenting. It's a negotiation, so that's routine.
Nothing unusual about
Routine.
that. Now, you testified earlier that you were provided text messages between Wendy Adelson and Dan Markel after the divorce was finalized.
Yes.
Although they didn't agree on everything, did it seem to you that it was amicable?
Yeah, I was only provided, I think, what the state provided to you, which was between maybe April of 2014 through June of 2014. So it was a few months period, even after these motions had been filed that kind of upped the temperature a little bit, and they were working well. I saw some communications where Mr. Markel was inviting her to join him in the Boys for Ice Cream. I know that there were many occasions where he was traveling and his travel plans adjusted, and she adjusted exchange times based on his travel. I think he did the same for her. They were swapping days. It was actually much more amicable than many cases I see. They were very flexible with each other.
Now, you indicated earlier that October 31st, 2013, Kristen Adamson filed a motion for enforcement.
Correct.
Now, you mentioned a motion for enforcement and contempt. What is contempt?
Well, in this context, I think that's just a
I think like when we talk about the divorce case between Wendy and Dan, and even in the media, I think when we say contentious divorce, we're talking about the divorce proceedings and then everything leading up to it, to Dan Markel being murdered. Not just looking at the divorce proceeding as a whole. I think we're just talking about it generally, that this whole thing was contentious. They were fighting over the boys. At some point, they wanted the relocation to happen. Relocation didn't happen. Dan Markel said that Wendy was lying about the assets and that she was, lying about other things, that Wendy should be disbarred, her attorney should be disbarred, and that Donna was saying things to the kids that were inappropriate about Dan Markel. I think when the media, everyone, all of us are talking about the contentious divorce between the two of them, we're talking about the entire scope right there. So for the defense to be like, well, actually, let's just focus on this scope right here where they were actually, discussing the divorce stuff. That part is not contentious. I mean, I guess I can, it's like, yes, the defense is clarifying it more for the jury, but still, you can't just look at the divorce itself and then anything after the judgment. Are we just going to ignore? Because we all know after the judgment, it was definitely very spicy between the two sides. I just don't see how this clarifier really helps the jury that much. I guess to explain that the divorce proceedings itself was not contentious. Donna was fine with Wendy because Wendy was given a very favorable marital settlement agreement and that there's no scheming behind the scenes. The family didn't want Dan Markel dead. But it's Donna's own actions that really damage her, crucially. It's the emails, the text messages. I mean, it gets worse after the bump and stuff, but it's Donna's actions that the jury's going to look at and be like, yeah, I mean, this expert may try to paint the picture that things are, you know, fine with everyone. However, when you look at Donna's own actions, it was very different. It shows a different picture.
Title of her motion, because in the body of the motion, she didn't ask the court, I don't believe, to find him in contempt of court. She was just looking for a judgment so she could execute on the judgment and collect her money.
So although the motion itself may have been entitled enforcement and contempt, the prayer for relief did include any request that the court find him in contempt?
I don't recall seeing that at all. I think the court said make him pay, you know, ask the court to make him pay. And what that means is give me a judgment so I can enforce on that judgment, however that may be. It's just a collections issue.
You indicated that you don't think it would be helpful to see the pleading itself.
Sure.
May I approach the witness?
All right, because after the judgment, we had Donna sending those unhinged emails to Wendy saying, we're never going to lose, never lose. You know, the Adelsons are going to win. You should do X, Y, and Z to the boys to really get at Dan Markel. We're going to get under his nails. Didn't say that verbatim, but essentially that. And then we hear from Katie McBanwell, October 31st. Or no, before October 31st, we hear about Charlie and Donna discussing, you know, trying to convince Wendy to not buy a house in Tallahassee. And then weeks after that, we hear that Katie hangs out with Charlie, and Charlie's like asking, hey, do you know anyone that can hurt someone? And then the post, I guess, divorce stuff gets worse between Dan, Wendy, Markel, everyone, right? And then we hear about the secret not birthday present, and then delete this text message. And a lot of really weird shit happening.
An approach with courts 1 states demonstrative A, specifically page 338.
Oh, cool glasses. She's got them blue light thingy on.
Motion that Ms. Adamson filed?
It is.
Okay. And the body of the motion, does it seek anything concerning contempt?
In the body, which does not control the ask of the court, which is called a wherefore clause, and under the wherefore clause is where you say what you want the court to do. Above the wherefore clause, it sets out the facts. He was required to do this. It was due by here. Here's what he's done. Here's what he owes. She's incurred attorney's fees. And then she says attorney's fees pursuant to this agreement are a form of support. The former husband should be required to show cause why he should not be held in contempt for failing to pay a form of support. So that's accurate in the sense that the money owed to Wendy is not enforceable by contempt. The $10,000 fees can be enforceable by contempt. So she says that above the line. But then the wherefore, what she asked the court to do is enforce the marital settlement agreement, require him to immediately transfer to the former wife the remaining amount due to her pursuant to the marital settlement agreement, together with statutory interest on the same, order him to immediately pay the wife's attorney's fees of $10,000 and award her attorney's fees for this action. So all she's asking, she's not asking the court to hold him in contempt here, she's just asking the court to order him to pay it immediately. And the sanction for him would be he'd be required to pay the attorney's fees to Kristen for having to file this motion, and he'd be required to pay statutory interest on the unpaid amounts from the date it was due until the date it's paid. So that's his full exposure.
Of this case, was the amount of money that Ms. Adelson was seeking through this enforcement motion an enormous amount?
I didn't view it that way. I viewed it as kind of an annoyance that she had to go through these hoops to get the money because he had the money and he owed the money, but it wasn't going to put her out on the street.
Did you believe, is your opinion, that that motion for enforcement that was filed on October 31st, 2013 had merit?
Absolutely.
And what were the possible repercussions to Mr. Markel?
He would have to pay more. He'd have to pay more in fees and more in statutory interest and more to his lawyer to fight it. That was it.
Were you provided with a series of emails in mid-December of 2013 where Mr. Markel emailed the parenting coordinator and Wendy Adelson complaining about a host of issues?
I did.
Okay. Was one of those issues one where the boys allegedly said that Grandma referred to him as stupid?
Yes, he brought that complaint up to the parenting coordinator and to Wendy in the same email in December 18th, maybe, of 2013.
From your review of that correspondence, what did he want to happen?
My recollection is he was asking Wendy to be mindful of that and to be alert and make sure it didn't happen.
Did he ask that my client not be around the children unsupervised?
Donna Adelson, no, he did not ask for that relief.
According to what you reviewed, when did those quote stupid events allegedly occur?
According to the email, he said there were 2 or 3 occasions in November where the kid said something like, "Grandma thinks you're stupid," or something like that.
Did Mr. Markell file any action, any motions or supplemental petitions in November or December of 2013?
Related to that allegation?
Yes.
No.
Now, the motion for enforcement filed October 31st, when was that set for hearing?
It was initially set for
Isn't that a good thing? The fact that it happened earlier and that because Dan Markell didn't do a knee-jerk reaction means that he was trying to actually, oh my God, there's a mosquito here. Ah, I just caught it. Because say it happened in November, Dan Markell could have just been unhinged and then like drafted something in November going after Wendy, Donna. Sorry. Got the smush mosquito here. But he went into it to December to let the parenting coordinator know and telling Wendy to be mindful that it shouldn't happen again.
hearing in February. And I believe that was set in December, and it was the certificate of service, which is the bottom of the motion. You file a certificate that says where you have sent this document, to whom you've sent this document. And it went to Mr. Adelson's new lawyer in December.
Mr. Markell?
I'm sorry, Mr. Markell's new lawyer in December.
Hey, Tristan, thank you. Thanks for joining us. I appreciate it.
And then nothing happened. All of January went and nothing was filed. And then the end of January, which...
All right, she said February. I thought, wait, hold on. I thought she said February. Oh, December. No, February. The hearing was set for, hearing was set for February.
Was the certificate of service, which is the bottom of the motion. You file a certificate that says where you have sent this document, to whom you've sent this document. And it went to Mr. Adelson's new lawyer in December.
Mr. Markell?
I'm sorry, Mr. Markell's new lawyer in December. And then nothing happened. All of January went and nothing was filed. And then the end of January, which at this point is 3 months after the motion was filed, a response was filed. And then the response basically said, yes, I owe the money, but I don't have to pay it because Wendy had these other financial violations. And then she referred to the Schwab account that you've heard about, a retirement account, I think. And then 2 weeks later, I think it's February 14th, he filed a motion for contempt against Wendy.
Okay, I like timelines. Thank you for following the timeline.
I think it's February 14th, he filed a motion for contempt against Wendy. In that February 14th, it was kind of a companion document to the January 31st response. Again, he would do multiple filings on the same issues. He again just addressed, but a little more vehemently, the allegations of financial fraud. It was only a financially focused document.
What defense did he claim to have to avoid paying Wendy Adelson as he'd been ordered?
I mean, man, does it really matter that the divorce itself wasn't contentious, but everything that they're going over right now is super contentious? And this is a lot closer to the murder date.
My recollection is his defense was that she did not put on her financial affidavit a certain non-marital asset, but he knew that an asset existed, but it was fraud. It was kind of circular. And there was, he said he didn't have a updated document at the time of the marital settlement agreement or something like that to know what the then value was. But those are all pre-divorce issues. So he had ample opportunity during the divorce to do third-party subpoenas or motions to compel or other ways to get those documents. And then, according to Chris, all of those were dealt with in the marital settlement agreement anyway.
And the previous attorney said the same thing, that when Dan Markell filed this response in, I guess, Valentine's Day, that this is something that you would have settled during the divorce proceedings portion of it, not everything that's happening afterwards.
I don't have any reason to doubt that.
So I don't know. I would like to hear Dan Markell's side about it. Like, was he doing this in spite, to be spiteful? Or was there actually like a justifiable reason why he was like, hey, when he was committing financial fraud? Because both these attorneys so far, I mean, they are testifying for the defense. Both of these attorneys so far say that it doesn't make sense for him to do this because he knew about the asset.
But yeah, he was just trying to say one good breach deserves another or something like that, and it wasn't legally supportable.
That's not a valid defense.
Pardon?
That's not a valid defense.
I wouldn't make that defense, no.
Okay. Now, if a party in an action believes that there has been fraud in the underlying, securing the underlying agreement, is there a way in which they can contest that?
There is. If you're alleging fraud, and if it's fraud in the financial affidavit, you don't even have to do it within the first year. But there's a rule that Ms. Adamson referred to. It's called 12.540, and that's where you can move to set aside the marital settlement agreement based on fraud. So if you find out later that they had won the lottery before you and didn't disclose, or that they had some stash of gold bars somewhere or whatever, you can come back in and say they didn't disclose that. But it has to be material. And so the case law is pretty clear that the fraud has to be an actual fraud that impacted the agreement. For example, I think there's one case that talks about maybe there was a minor $3,000 to $5,000 tiny IRA or something like that that was never disclosed. They just had forgotten about it. It was very small in relation to the rest of the assets. And the court said that didn't really impact anything, that we're not going to set aside an agreement based upon that.
In other words, it's a high hurdle
Sure,
to
and
overcome.
it had impacted you. In this instance, it was clear from Mr. Merkel's own motions, he knew about these assets. So I think his fraud allegation was completely baseless.
Now, in some of his emails and filings, he was asking for 100% time sharing, more restrictions, more access to the kids. Did he ever present a proper pleading to the court to try to get those things?
No. What happened was he did the January 31st response, and then he did the motion against Wendy on the financial issues February 14th. And then towards the very end of March 26th, after Kristen had filed a motion to dismiss his fraud motion as being a sham pleading, essentially, I guess he kind of ramped it up a little bit. So he filed a motion complaining about parenting. And it had maybe 10 different points. It was very long. Each point was maybe a page long of different paragraphs. And in that motion, almost all of the related violations were not violations at all. There were no court orders requiring her to do what he wanted her to do. So he wanted a certain number of video calls, and she didn't give him enough video calls. Well, video calls weren't required. He asked for a certain number of phone calls, and a number of phone calls wasn't required. He was asking for there was some right of first refusal. He didn't like that when Wendy's parents would come to town, that she would maybe go to dinner with friends and let them spend time with the kids. Or she would let them stay home from school so her parents could spend time with them, and they were little babies. And he didn't like that because he wanted to be able to go to the child care during her parenting time so he could see them every day. And I think the child care person had asked him probably not to do that, but he wanted to do that. And he wanted her to go to like a therapist and follow the therapist's advice on basically doing what he wanted her to do. So it was a lot of noise trying to enforce something that wasn't a provision to enforce. There was no underlying court order to enforce.
And is that the pleading that Ms. Adamson filed a motion to dismiss about?
That may have been, I was thinking she filed it against the February 14th, but I could look at my notes and clarify if you'd like me.
If it would be helpful.
It would be helpful. Yes. Yes, it looks like on April 11th. Nope, that's his response. Let's see. Yes, it was before my recollection was correct. She filed a motion to dismiss on March 10th to dismiss the motion regarding the fraud that he alleged on February 14th. And then I think as a response to that motion to dismiss, then he kind of amped it up with this motion to enforce that dealt with the parenting issues.
And the motion to enforce that dealt with the parenting issues, is that the March 26, 2014
Exactly.
motion?
Correct. And then that was all set for hearing for May 15th.
Okay. The complaints that he raised in the March 26, 2014 motion, you indicated there were things that he was asking for that hadn't been ordered. And are you referring back to the marriage settlement agreement? There were conditions that he wanted that weren't actually in there?
Right. He was trying to enforce his view of what this post-divorce parenting should look like. But there was no court order that required her to make the children available to him during her parenting time. I think one of the complaints was he wanted one-on-one time with the kids, and she should be ordered to let him take the kids during her parenting time one-on-one. There was a couple of different provisions about communication. I think like the 8th point he made well into this very long motion.
Now I really want to read his motions. I feel like these requests sound completely unreasonable, but I want to know what his reasons are for this, or if she's giving a proper representation of what Dan Markel was asking for.
Was he brought up stupid allegation from November, and this was the end of March. So I didn't see anything in his allegations that had any recent problems with him being disparaged or by anybody calling him any names. So he mentioned that. I think it was his 8th of 10 points in that motion.
Was it in that pleading that he was asking for sole decision-making authority?
Yeah, I believe it was.
Would there have been a basis for the court to grant that?
No, he would have had to go through that supplemental petition that we talked about earlier, where he would have had to show a material and substantial change in circumstances, and that it was in the best interest. And there's no indication he would have been successful there, and he didn't plead it correctly anyway.
Now, with respect to the complaint about my client allegedly saying that she hated Dan Markel or she called him stupid, was that allegation a feature of his motion?
No, it was buried, like I said, 8 points down, 8, 10, 12 pages down.
Just a few paragraphs of his motion?
Yeah, 3 paragraphs.
Was there any indication that those claims were true?
No, and I don't think he could have proven that because he's talking about what purportedly a 4-year-old.
Wait, it was buried 3 paragraphs down, or the whole thing was 3 paragraphs of him complaining about the stupid allegation?
Just a few paragraphs of his motion?
Yeah, 3 paragraphs.
Oh, 3
Was
paragraphs.
there any indication that those claims were true?
I
No,
mean, 3 paragraphs sounds kind of significant, but she went like this.
I don't think he could have proven that because he's talking about what purportedly a 4-year-old may have said to him. And I think even in his motion, he says, I don't know if this is true or not. I don't know if Wendy was present or not. But I would like Wendy to make it stop if it's true.
Did the grant this motion, the March 26th,
Hey man, 4-year-olds, they could be like parrots, okay? They hear something, they might repeat it. Who else would say this?
2014 motion that the state has called the grandmother motion, did that request that my client not be permitted time with the children?
No.
Did Mr. Markel request that my client's time with the children be restricted?
The only thing he requested, and he had the first right of refusal, maybe point 4 or 5, and then he kind of tied in this grandparent thing on point 8. But what he appeared to be upset about mainly was when she came to visit and they kept the children home from school, that he couldn't go visit the children at school, so he didn't want her having unsupervised time as it related to the first right of refusal. He wanted the kids to go to school and not be left alone with the grandmother because he wanted to see them. The same thing with the evenings. If she went out to dinner because her mom was in town and it gave her a chance to run out and see a friend or something, he wanted Wendy to have to call him so he could watch the kids even though mom's there to watch them, which that's not the purpose of a first right of refusal.
I was just about to ask that. What is the purpose of that?
Well, the purpose is if a parent is unavailable and can't provide care for a child, then you offer the other parent the first right to take care of the child. It's not if, my rule or what I tell my clients is if you can't make it to the hospital, if you can't meet the ambulance at the hospital, it's a first right of refusal. You need to have a parent available who can take care of any emergency. It's not to prevent the kids from having sleepovers or spending nights with grandma or anything like that. That's a normal part of a kid's upbringing, and so you don't want them to never be able to spend the night with grandma or never be able to go to a friend's house because they happen to be in a divorced family. Those are just decisions each parent makes within their own household. So a first right of refusal typically is triggered when the other parent is unavailable, out of town, that sort of thing.
Okay. Now, have you ever seen a scenario where a court prohibited a grandparent from having unsupervised time with their grandchild?
Only in one occasion I can think of, and he was a convicted child molester.
What is your opinion about the persuasiveness of the March 26, 2014 motion that Mr. Markel filed?
I think it would have been similar.
Okay, so it seems like Dan Markel was essentially saying that he wasn't given the first right of refusal because Wendy would be busy with something and then have Donna come in and take care of the grandchildren. Wendy should have reached out to Dan and be like, hey, I'm going to be busy. Can you take care of the children? She's saying that that's not how you use the first right of refusal. Essentially, these are using like if the parents were like unavailable. For example, if they were like out of town, there was an emergency, and if the parent was unavailable to, I guess, accompany the kid to the emergency room or something like that, then they have to ask the other parent to do it. The first right of refusal is not to be used to prevent someone from let's say the mom was busy and then mom wants to send the kids over to a sleepover, or mom wants to send the kids over to hang out with the grandparents' house. That's not what the right of refusal should be used for. So she's just explaining it for us. So that's kind of cool to know. I don't know anything about this child custody stuff.
Similar to what Ms. Adelson described the judge saying in the middle of the relocation hearing, which is,
oh my gosh, unrelated but Corgi, how did I not know you made a 3-hour ACOTAR recap? I had to watch that video later. Yeah, I went through this phase where I was like, hey, I want to try doing book recaps, but then I realized it was way too time consuming. It was fun though. It was fun doing it. It was way too time consuming. And then it made reading not as enjoyable because you had to take a lot of notes. And then, yeah, but it was cool though. I had fun doing it. Feel free to check it out if you guys want to. And then the editing for it was very, 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 very time consuming. So the whole thing was, it was like, took like 80 hours or something. I don't know. It took a long time. But yeah, it was fun. I'm glad I did it. And then I was like, okay, I'm done. I got it out of my system.
Don't file things like this. I don't think it would have been well taken by the judge at all, because it was a complete waste of everyone's time and money and emotion, because it was baseless. It didn't tie to anything.
Now, even if his allegations had been true, would the court have been permitted to modify the terms of the marriage settlement agreement based on his filings?
No.
Why?
You have to do a supplemental petition if you want to modify terms of the marital settlement agreement. You can enforce terms, but you can't modify terms.
In reading the motion, does it appear to be intimidating?
No, I think when I was making notes, I put insert by role here. You know, it was a lot of words, and he was obviously wanting life to look like what he wanted it to look like, but that wasn't reality. So it's just a matter of breaking down each allegation and addressing them.
Should Wendy Adelson or my client Donna Adelson have felt threatened, or would they have felt threatened based on that motion?
They shouldn't have, and that's one of the reasons I wanted to call Kristen, because
Well, they shouldn't have to these seasoned attorneys, but Wendy, you know, I guess she didn't know anything about family law. Donna probably felt real threatened because she didn't really understand what was going on. So these people were saying, they're like, oh, you know, Dan was writing all this stuff, but honestly, like, it really didn't have much merits, I guess. But if you're like a normal person and you're reading all the stuff that Dan is writing, then maybe you're like, holy shit, like, this looks like he's like destroying us. Like, we're losing. Like, look what's happening to Wendy. Wendy might be depoed over and over again, and that Wendy had to get rid of her attorney, or the attorney had to withdraw, and now the attorney might have to be used as a witness. So it's like, it's not like Dan wasn't doing any damage. There was some damage done by Dan. And I think a normal person like Donna, I think she was feeling all of that. So I know they're trying to downplay Dan Markel's involvement in his own, like, what's it called? His own documents, the motions that he was writing and all that stuff. But to a normal person, I think he would read it and be like, damn, this is crazy.
because, again, when I read that motion, I was kind of taken aback that a lawyer would have signed that and allowed that to be filed. And I thought it was kind of nonsense, and I wanted to get Kristen's take on that and see if she agreed, and she did, and she said that she had advised Wendy of that, and that's what I would have expected from her.
In the emails or text messages that you reviewed, did you see any communication that indicated that my client Donna Adelson was aware of that March 26, 2014 motion?
No, not what I was provided. I saw early during the divorce period that Wendy had sent her mom a couple of documents. I know the petition for relocation, that Donna helped make suggestions to beef up the facts, which I thought were pretty helpful suggestions, because, like Ms. Adelson said, relocation is extremely difficult, and you really have to have as many facts as you can to support yourself. So I saw that there was some editing and some input on that petition, but after the divorce, I didn't see any communication about sending pleadings. I don't even know that I saw any reaction from the financial motion, but certainly not from, I saw nothing, either that she communicated the motion to her mother or that her mother reacted to it in any way. I didn't see any responses.
Would Mr. Markel have been able to sustain his burden of proof for that motion?
I'm sorry, say that again?
Would Mr. Markel have been able to sustain his burden of proof for that motion?
No, I don't think so at all. You know, if you're talking specifically about like point 8 about calling him stupid, his only evidence is a 4-year-old child. Otherwise, it's hearsay, and I don't think a judge is going to talk to a 4-year-old child about whether their grandma thinks their dad's stupid. It's just, there's so much worse that goes on. That's not significant.
In your experience, what do judges typically do when this type of allegation is raised?
My experience is the judge tells everybody to behave themselves and sends them on their way.
So we've talked about this not being a hotly contested case.
I mean, I feel like she's downplaying the stupid comment a little bit. However, it's not the fact that grandma just made a statement, you know, like a stupid statement in passing. It's grandma using the kids and involving them in this whole thing. It's the principle of it.
Or a high conflict case. How many pages are in the court file?
I think there's roughly 570. And again, a lot of those pages are kind of repetitive documents filed by Mr. Markel that might say the same thing. Like he'll do a motion, then he'll do a memorandum that says the same thing, then he may do a response that says the same thing, or in different orders. So 570 though.
Do you know how much in attorney's fees Wendy Adelson incurred, attorney's fees and costs, for the dissolution of marriage and the enforcement proceedings that began afterwards?
I only know what Ms. Adamson said, which is around $30,000.
Now, in your career, have you worked true high conflict custody cases?
I have.
In particular, do any come to mind that involved an attempt to seek relocation?
Yes, I had a particularly conflictual relocation case.
This was so not contentious to the point that it led to murder.
That started in 2018 and went through 2021.
So about 3 years?
Yes, including an appeal.
Your Honor, may I show the witness the demonstrative?
You may.
Damn, look at that. Oh my goodness, look at that. Those binders. Oh gosh.
Perhaps only one of those volumes got printed.
So the
This is all the divorce stuff?
clerk's file in the case that we're referring to as the demonstrative is twice as big as what we have in front of you.
Yes, based on just assuming 500 pages for no vote.
Thank you.
Please, let's vote.
Case. We approach. We're entitled to believe I. Judge, we're entitled to make a record. I believe I have the.
Sorry, there was an objection there.
Can you tell the jury what the issues were in that case?
Gosh, Judge, what's the relevance? Object.
Sustained.
Judge, may we approach?
No.
Judge, we're entitled to make a record. I believe I.
The judge was like, nope.
Judge, may we approach?
No.
Judge, we're entitled to make a record. I believe I have
Members
the.
of the jury, the bailiff will take you to the jury room.
Oh man. Judge is not feeling Mr. Zellman. Poor Mr. Zellman. I do feel bad though that the entire courtroom kind of laughed.
The relocation issues within this case are certainly relevant. As to a separate other case, what is the argument that you're seeking to make for the record?
Your Honor, the relevant.
Objection. Can approach. No. Laughs. Dismiss jury. All right, arguments. Let's go.
Of,
What is the argument that you're seeking to make for the record?
Your Honor, the relevance of this proceeding is the witness has identified this as a hotly contested custody and relocation matter. I think we're entitled to have her explain what the issues were, what was involved in litigating that, as well as the amount of her fees that were incurred and the expenses that were incurred, so that we can make the comparison to the case that involved Wendy Adelson and Mr. Dan Markel.
Kappelman, any other argument on this issue?
What's relevance, Your Honor?
As to the point on relevance, the court's ruling remains the same. As to issues of relevance, again, the relocation that is disputed within this case as it relates to the divorce file certainly is an issue. As to any other case files, this witness may testify concerning her experience, but we're not going to go through this case file in its entirety. Please bring back in the jurors.
Your Honor, that was not my intent to go through the case file in its entirety.
This witness can testify. Thank you. I mean, I don't know, Mr. Zellman, you brought all those case files up and it looked a little intimidating and then you wanted to ask her questions about it. So I think people were a little bit they were a little bit worried. I'm gonna use the restroom real quick. Give me a second. Okay, it seems like we are not breaking for lunch yet? What is this? Oh, I see Georgia Kappelman. Oh boy, are y'all ready? Hello, hi. We are still on witness number 10. Linda Bailey, marital family law expert who almost had her entire testimony excluded.
Ms. Bailey, please step down, step out of the courtroom doors. If you can radio Deputy Bump to leave the jurors in the room, please approach.
Wait, now what? Oh gosh. Do 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 do. Do 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 do.
Any comments? Do not make any expressions in front of the jury in any way that would be intended to inappropriately influence them. In any way, make any comments. Do not make any expressions in front of the jury in any way that would be intended to inappropriately influence them. The jurors using the restroom. Please use the restroom or stretch your legs if you need to, and we'll continue with the witness after that.
All right, they take a little mini break. Continue with direct examination. How do we think Donna's feeling right now? Donna, how are you feeling over there, ma'am? What do you think of your defense so far? Think you're gonna get away with it? Or I guess that's a wrong phrase. Do you think you guys are doing well?
Please continue with your examination.
Thank you, Your Honor. Ms. Bailey, how did the Adelson-Markell divorce compare across the variety of cases that you've handled?
Simply, it was routine, it was amicable. I've done similar cases that have had anything from 2-day to 7-day trials.
I can't wait for the cross-examination.
I've had them range from $200,000 to $500,000 in fees and costs. I've had multiple financial experts, child development experts, vocational experts, all retained, deposed, testifying. I've had cases with multiple discovery issues, discovery over psychological records, financial records, third-party subpoenas, 2 full days of deposition of just one party. This was an easy case compared to many.
Did it look worse than it was because of the way in which Mr. Markell's pleadings were drafted?
Yeah, I mean, he drafted pleadings, motions, I think responses would be more appropriate than pleadings, but that's kind of technical. He drafted them like he was drafting a law review article or something. They weren't technically correct. They were verbose, they were hyperbolic. He used a lot of inflammatory language, but when you really looked closely
So they were wordy and they were exaggerative.
at his requests of the court, there was no there. There was no foundation for his asks.
Nothing further, Your Honor.
Cross-exam.
Huh? That's it? I thought we're doing more. Okay. I don't mind it. All right. Cross-examination of witness number 10. Georgia Kappelman. Get up here, girl. Come on up. And Georgia Kappelman, she's already fired up from this morning, so can't wait to feel the passion.
What is it you were asked to do in this case?
I was asked to review the documents I was given and to opine about whether this was truly a highly contentious custody case, essentially.
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody else to decide. I mean, I've done 2,000 cases, or give or take 100 on each side. And
Dude, she's so good at just being so fired up from the very get-go, you know? Usually sometimes, like, there's some attorneys that come up and they're like, okay, well, let's start from the very beginning. All right, so let's look at these emails. So she's like, what is it you're asked to do in this case? And why does your opinion matter? Oh, man, Georgia. Oh, boy, oh, boy, oh, boy.
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody else to decide. I mean, I've done 2,000 cases, or give or take 100 on each side, and I think I have a pretty good judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce.
Thank you. That's what I was saying about Donna and Wendy. That I don't think Wendy knew anything about the family court stuff, and that Donna was a normal person. This was something that she was going through personally. So to Donna, when Dan was drafting this, yeah, it probably looked like it was scathing, and Donna felt like maybe she was on the losing end. Georgia, is she watching the streams? Georgia?
With a ton of divorces, right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with,
So
but
isn't
sure.
the contentiousness in the eye of the beholder, in the sense that to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world. Do you
Well, that's
agree
one
with
reason-
that? Do you agree with that?
Ms. Kappelman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
Do you agree that a case, as a lawyer, might be routine, whereas to the parties it's the most important thing in the world?
To some degree, that's one reason I called Kristen, is Ms. Adamson, in particular, of the lawyers in our community of the family law bar, is extremely measured and calm. And I find that when I litigate against her, we reach resolutions, that people stay measured and calm, and we get things done. She's not one of the...
This is not really her answering the question, but it's a good pivot, though. Hey, nice try. Nice try.
other lawyers in town who may stir cases up or play on those emotions. So our job as lawyers is to explain to our clients when we get emotion. If I get something, for example, that, although I've never had.
I know, I was going to say the same thing. Georgia's hair says it all. I feel like she was in the bathroom pulling at her hair or something. Like, Georgia, you got something going on right here. She's a queen. Who even are you and why are you here? Lawyer versus lawyer.
Something similar to what Mr. Markel would file, the immediate response is to call your client and go, I know you're going to read this at first glance, so it's going to seem messy. But there's no legal basis for this, so don't worry. And my understanding is that is what you communicated to Wendy.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but...
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000
But you're
pages in
not-
front of me.
You're not in the mind of the people whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
I don't think that's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Ma'am, could you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's lives change after divorce, certainly.
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
People's lives are impacted by the decisions that go on in court, which for you are routine.
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Um, I don't know if the witness is purposely trying to be obtuse, but as a witness,
What is no big deal to us is a big deal to these litigants.
as an expert witness, just answer it truthfully. Don't make it seem like you're trying to fight and hold out, okay, to defend. Just answer it neutrally, maybe give some defense a little bit of flair. But like the fact that if we can understand what Georgia is saying and this expert is seemingly saying that she doesn't understand, it just seems like she's purposely just doing it just so she doesn't give Georgia a win, I guess. I guess the other explanation is maybe this witness is really nervous and she's intimidated by Georgia, but she's an expert. She's testified, I think, I don't know, I skipped through her credentials, I'm sorry, but I'm sure she's testified in many other cases. She's an attorney. She probably knows how to work in, high pressure environments and stuff like that. Whew. Come on, Georgia's reference is pretty clear.
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
What is no big deal to us is a big deal to these litigants, right? You can't agree with that.
Perhaps.
You can't agree with it. Strike the question. You were asked.
Can the defense be like, hey, objection here? She's a little argumentative, making comments.
Strike the question. You were asked. Let me ask you this. Let's go on to something else. Have you ever had people get murdered or commit suicide based on the issues that are going on in your family law litigation?
I've never had anyone murdered. I had in one instance a Middle Eastern person committed suicide just because there was a divorce, and that was shameful. So nothing was it was literally the day after the petition was filed, and he had threatened, if you file, I'm going to kill myself, and indeed he did.
And to you, divorce is not shameful, is it?
To me, divorce is not shameful.
Divorce is not a basis to commit suicide, is it?
Ooh.
Not according to me, but I didn't grow up in Iran or wherever this custom or feeling.
Exactly, Ms. Bailey. To
Derived.
that person, it was a reason to commit suicide, right?
Apparently so.
Oh, I knew she was going to go there. I knew she was going to circle it back to that. Oh my God, Georgia, you are such a masterful person at this. Attorney, masterful attorney.
Aren't these issues raised in these pleadings potential fuel to make people upset?
Potential fuel to possibly make people upset?
Yes, ma'am. For example, you were asked about what we've called the grandma motion. You say, oh, it's no big deal, it wouldn't be granted, it was buried in there. But the allegation is, grandma is disparaging me to these kids, and I won't tolerate it, right? Couldn't that be upsetting to grandma?
You'd have to ask grandma. I don't
Exactly.
You have to ask her.
There was no proof,
It shouldn't have been, in your opinion.
in my opinion.
But in your opinion, divorce is no reason to commit suicide, right?
True.
Jeez. Georgia's so good at this.
Gibbers, according to the evidence in this case, means Jew in boots. It's not a flattering term by that definition or by your definition of someone that speaks gibberish. Can we agree it's not a flattering term?
No, it's probably not flattering, but I've seen far, far worse.
You've seen worse.
Ma'am, have you never had criticism about your testimony in cross-examination? I don't know, man. I think she's just holding... Ma'am. It's... Okay. I don't know. It's just... I think when you come off as really defensive as a expert, I think that can come across as you not being forthcoming and truthful.
I have.
If Mr. Markell wasn't paying by the deadline, isn't that something that would be potentially upsetting to the parties or their family members?
I don't know how upsetting $80,000 would be. I don't know.
$80,000 is a lot of money, isn't it, Miss Bailey?
It depends on who you are.
Ma'am.
Exactly. So we'd have to ask the parties, right? Right?
Sure.
Okay.
Yeah, I think on that issue, he clearly had the asset. So at the end of the day, he was going to pay. It was just a matter of jumping through hoops to get the money.
He was either going to pay, or he was going to get sanctioned by the court, or he was going to end up in jail, right?
I don't see any possibility he was going to end up in jail.
Okay. Well, you sat in the courtroom during Ms. Adamson's testimony,
I did.
didn't you?
I
And Ms.
did.
Adamson said that that was one alternative, an extreme alternative, obviously. But that's what contempt means, right?
But that
Ultimately.
wouldn't even come into play until the motion for enforcement, and then he didn't abide by that, and then the judge asked him to do something else, and then he didn't abide by that. I think jail was pretty far-fetched.
Well, as long as he pays. Ultimately, the teeth is you go to jail.
No, that's not true.
It's not true. Okay. Ms.
yeah.
Adamson was incorrect on that point, I guess.
Objection, Your Honor. I have a question to move to strike.
There you go. All right, defense is awake now.
I'll rephrase it.
Was the objection again?
It's an improper comment on that witness's testimony.
Stay, please rephrase your question.
I said Ms. Adamson was incorrect on that point when she said jail was a potential option. Is that correct?
Well, I can break it down. There's two different matters in that financial motion on October 31st. One was the $70,000 still due to Wendy. Jail is not a possibility on that. You don't send people to jail for failure to pay money. We don't do that. The $10,000 in fees to Kristen was more debate.
But Miss Adamson did say that they could hold Dan Markel. Didn't she say that they could hold Dan Markel in jail until he pays up if they knew that he had the money or something like that? Weren't you listening to her testimony? There's this whole argument of sequestration, and you're listening on the testimony. Maybe I heard wrong then, but it seems like Georgia thinks the same too.
Jail is not a possibility on that. You don't send people to jail for failure to pay money. We don't do that. The $10,000 in fees to Kristen was more debatable because that could have been in the specter of support, and if you don't pay alimony or child support after repeated chances, I guess you could say, jail might be an option, but there's always a purge to that. So I've seen many times in child support, if you don't pay child support, then the judge says, bailiff, get, Mr. So-and-so or whatever, and then all of a sudden he comes up with money out of his pocket and he pays and he never goes to jail. So you always have the key to the jail when you owe a support obligation. So technically, if he wanted to go to jail rather than pay Kristen the $10,000, eventually there may have been a hearing where that happened. I've seen one person in my career go to jail over child support.
I've heard about that before.
Right, because they pay because they don't want to go to jail. If there was no jail and no consequences, they would never pay, right?
Some people wouldn't. And that's just support. There's no jail consequence to the $70,000 to Wendy. It was only the $10,000 to Kristen that could have possibly remotely been a possibility.
Did you see evidence in this case of Wendy taking her mother's suggestions, cutting and pasting them into an email as her own, and then forwarding those questions to Ms. Adamson?
No, I didn't see any.
And did you see, in your review of the evidence in this case, Ms. Adamson responding to those questions and Wendy then forwarding those answers to her mother?
I don't recall that. I don't recall seeing that.
Ooh, that's not good because the jury saw it. You're supposed to review all this.
Did you review the communications from Donna Adelson, both in the form of email and text messages, that suggest that she was in fact extremely disappointed and upset about the outcome of the relocation motion?
I did.
Unless my memory is wrong and Georgia is exaggerating and I'm not remembering correctly, but I could have sworn we saw those emails where Wendy was doing exactly that.
Probably the 5 days after the relocation, which was, say, 4 weeks before the ultimate settlement in July, there were a flurry of emails where she was obviously upset.
Did you review Mrs. Adelson's communications after July 31st that suggest she's consistently still upset about this?
I wasn't provided.
So you were, I'm sorry, finish your answer. You weren't provided any?
I wasn't provided after the flurry, right after the relocation, before the final judgment was entered in July of 2013. After July 2013, I don't recall seeing any emails from Miss Donna Adelson about relocation.
Did you see any emails from her at all post-settlement?
Not until maybe December. It was a while. October, maybe.
Okay.
Several months.
If Dan Markel had agreed to the relocation post-denial, post-stipulation, post, it could still happen, right? I mean, if he agrees, it could happen.
Sure, if he agreed, she could have relocated.
All right. And if he was murdered, it could happen, right?
Well, obviously.
Well, obviously. Jeez. She's annoyed.
So you categorized Dan Markel's pleadings in a lot of different ways: baseless, untrue, unenforceable, gibberish, nonsense, suggestion of unethical filings on the part of his lawyer to sign off on them. Are you saying, I think what you're saying is that those things wouldn't amount to much in court because it's not really effective filings. Is that what you're saying?
What I'm saying is his motions post July 31st were not based in the law, and I don't think that allegations about accounts he knew of not being on an early filed financial affidavit would amount to fraud, and it certainly wouldn't excuse him not paying what he was supposed to pay under the terms of the court order. And the motion in March 26th related to parenting, he was trying to enforce things that weren't in the marital settlement agreement. There was no court order to make her do the things he wanted her to do. So there's no basis for the court to have granted his motion.
Right, so they weren't going to be successful. It's your opinion they weren't going to be successful.
Yes, that's my opinion.
But would you agree that the things he was putting in there are inflammatory?
I would agree that they were inflammatory.
And they potentially could make the parties or their relatives upset to read those pleadings and those inflammatory accusations.
Sure, nobody wants to read those allegations, true or not, about themselves in a public record.
There we go. We circled back finally, and she agreed. Earlier, she was like, well, to me, it wasn't. You know, I've seen so many divorces. Like, these weren't bad at all.
You were shown a bunch of binders on a case. That case has nothing to do with this case, right?
No, it was a relocation case.
All right. And that case, was anybody murdered in that case?
No.
Okay. So if somebody had been murdered in that case, there might have been a lot less paper, right? Case
Well,
would have been shorter if somebody had gotten murdered, wouldn't it, Miss Bailey?
if there wasn't a party, the case would have ended. If that's
And if our case, we hadn't had a murder, we might have a lot more paper in our case, wouldn't we?
No, because the divorce was over in July.
Divorce was over in July, but they kept filing papers, didn't they?
Well, and the case was set for hearing May 15th, 2014. So the motion that Ms. Adamson filed in October, and the motion that Mr. Markell filed in February, and then the motion he filed in March, were all set for hearing May 15th. And then Mr. Markell amped it up again, and on May 5th, he filed the motion that accused Kristen of fraud. So she had to withdraw, so they had to move that motion. So had that not been filed, they would have had a resolution on May 15th.
We don't know that. How do you know it was going to go on May 15th? Could have gotten continued for any zillion different reasons, couldn't it?
It was set for May 15th, and it was noticed for May 15th.
Set for May 15th, but at the time of Dan Markell's murder, litigation was still ongoing in this case. Yes? Yes. And even after that was resolved, there would be nothing stopping them from having a bunch of other time-sharing issues or whatever come up, and they might have ended up with reams of paper, right?
Objection or cause for speculation.
Overruled, the witness has provided an opinion. The state
Well-
will cross-examine.
I guess my response to that would be, I think it would have been to Wendy's benefit to proceed with those hearings, because nothing makes someone stop filing nonsense pleadings and motions better than having them ordered to pay the other side's attorney's fees. So had they gone to the hearing on May 15th,
Man, if I were Dan Markell's parents, I would be so proud to have Georgia Kappelman represent this case and going up against these people.
had Wendy have been successful, he would have very likely had to pay Wendy's attorney's fees. And I really encourage my clients in these situations to take it to hearing. So once the other side gets kind of slapped down, if you will, by the court and made to pay your fees, then they tend to back off.
But that hadn't happened yet.
It had not happened yet.
And we'll never know when that was going to happen because we never got to that point, right?
Clearly.
Because he was murdered.
Clearly.
May I have a moment to confer, Judge?
Go ahead.
Oh, man. I love how Georgia is aggressive, but at the same time, you know, behind that aggression is like, she seems like a really sweet person. And her tone usually comes from more like disappointment than pure anger. Disappointment, and I would say frustration. Oh man, her and Sarah Dugan are great so far. So you know how the defense was fighting to have this witness testify? Well, I'm glad that, I'm sure Georgia feels like she's glad that the judge ended up letting this witness testify. I don't know. And maybe the defense regrets it now. Darn. We should have excluded this witness after all. I'll have to re-listen to this portion again without taking notes.
Redirect examination.
Briefly, Your Honor.
Briefly, Mr. Zellman, are you sure about that? You sure you don't want to spend a little bit more time with redirect?
Ms. Bailey, you sat through Kristen Adamson's testimony earlier today, correct?
I did.
Did that in any way influence your testimony here this morning?
No,
What?
There was no new information.
We're going to start with that? Really? We're going to start with that? Come on.
Nothing further.
Will this witness be recalled at any point?
What?
Potentially, Your Honor, but she's free to go about her business.
You remain under subpoena.
That's it? You sat through testimony. Did it influence you? Ask and answered, man. Did you already ask that in direct?
Please not discuss your testimony with any other witness in this matter. Have a good day. Members of the jury, at this point, we are going to take our lunch break. Once again, I will instruct you not to discuss your testimony with each other or any other person. Do not review or seek out any information outside from this courtroom. We will resume with the trial this afternoon today at 2:20. Please report by 2:15. Enjoy your break.
It's a long break. They're going to give Donna and her team time to decide whether or not Donna's going to testify this afternoon or maybe a different day. So I think after when they come back from lunch, they'll let the judge know if Donna's going to testify. Oh my goodness. Maybe Georgia realized that the jury were nodding off a little bit during testimony, so maybe she wanted to wake them up.
Everyone can be seated. Any discussion that needs to take place concerning whether the defendant will testify does need to occur during the extended lunch break at this point. Are there any other matters that we need to address?
Judge, I'm still hearing reactions from the gallery over my right shoulder during witness testimony. I heard it again after the court, cautioned the gallery again. I don't know what steps the court needs to take in order for that to stop, but
What are the reactions coming from the gallery? Is it reactions to Georgia or is it reactions to the defense? Hey, people in the gallery, maybe he's talking to us. Corgi, shut the fuck up. I'm sorry, I can't help it.
the fact remains that they're doing this in front of the jury, could have an impact on the jury, and it could impact my client's right to a fair trial.
Well, this is a public trial. I cannot clear the courtroom. However, who do you believe you heard making comments or in some way doing something that was intended to distract the jury? That person can be removed. Are you able to identify them?
They're behind me, Your Honor. No, all I can identify is it's coming over my right shoulder.
Turn around.
Please be seated. I want to make this crystal clear for everyone who is observing the trial today. Should I or the bailiffs in any way notice that you're engaged in a disruptive behavior that is intended to improperly influence the jury, you are going to be removed from the trial and subject to contempt. I cannot make this any clearer at this point. Please report back at 2:15. Once the jurors are assembled, we will continue with the trial. Ms. Desclazo, I believe, is still to be called by the defense.
Yeah, I think it was the gallery as a whole. The gallery laughed when Zellman was like, "Can we approach?" And judge was like, "No," and everyone laughed. They're laughing at the garbage example. Oh, I don't remember hearing if they laughed at the garbage example. I was too honed in on Georgia Kappelman. Is that Harvey? Yeah, Harvey's back there.
Yes, Your Honor. Mr. Scalzo and Ms. Newhouse are slated.
Concerning the rule of sequestration, the remaining witnesses understand they are not to be in the courtroom.
I'm not aware that they have been, Your Honor.
Please scan the courtroom to make sure none of your witnesses are present so we do not have any continuing violations of the rule of sequestration.
I mean, are you not communicating with your clients? Like, hey, you're coming in, you're testifying at 11 a.m. Make sure you're not in the fucking courtroom, okay? Do not come in the courtroom. You cannot listen to other... Like, is there no clear communication of that? Huh? Who's in charge of that?
I don't see any witnesses in the courtroom, Your Honor.
Please return at 2:15.
Georgia's like, I'm getting the heck out of here. I'm gonna get me some Chipotle. I'm just kidding. Oh, man. All right, y'all. When we come back from the lunch break, we will find out whether or not Donna Adelson is planning to testify. Now, I don't know if that's going to be testimony today or testimony a different day. Today's Thursday. They're hoping that maybe this ends on Friday, but it can go until next week because the jury are supposed to be, or they were told that it might be a 3-week trial rather than a 2-week trial. Oh boy, I'm just going to do a very little tiny mini summary, probably a lot less detailed than I normally do. Yeah, they will do that. Today, day 8 of trial, we started with some courtroom drama stuff. Apparently, there was a witness from the sheriff's office that works at the correctional facility. I think maybe where Donna's at, possibly. Defense wanted them to testify. Defense was complaining to the judge. Hey, this person was told to not speak to the defense. What the fuck? And the judge was like, well, they're not under subpoena. You didn't disclose this as a witness to the state. I can't do shit. I can't force them to testify. And so we had someone go up there and just give a brief little, I guess maybe like a proffer, I guess, where they said that, hey, the person said that the defense reached out to them. The person wasn't sure if they needed to speak to them. They don't know what it's about. Like, do I have to talk to them? And so they talked to the general counsel, and general counsel was like, hey, if you don't want to talk to them, you don't have to talk to them. But if you want to, you can do it voluntarily. That's all. That's what happened. And then Zelman was like saying that, oh, is this person on leave? Is she available to be served? And the person was like, I don't know. I have no idea. So we'll follow up later on to see if this guard will testify. I guess the defense will try to serve a subpoena and try to track them down. We'll see what happens. We start with witness number 9. We only had 2 witnesses this morning, so both attorneys. Witness number 9, Kristen Adamson, Wendy's former divorce attorney. So Wendy was in the motions of divorcing Dan from 2012 to 2014. And their major argument with these 2 attorneys is that, well, everyone keeps saying the divorce was contentious. Divorce was not contentious. It wasn't contentious at all. But I explained multiple times throughout the stream as to why this doesn't really matter, in my opinion. How people have covered this case, they've said that, divorce was contentious between Dan Markel and Wendy Adelson, and Donna was the one that wanted the kids and Wendy to relocate to South Florida. This whole thing has been explained as a contentious divorce. However, the fact that they're focusing on the time frame of the divorce, and although these 2 women are representing as like it was amicable, it was still everything that happened afterwards that was very contentious, that it was heating up, and they were arguing back and forth, and there's accusations being thrown around. So I don't know. Essentially, the divorce attorney is going to testify about how she thought the divorce wasn't contentious. And honestly, I think the stuff that the divorce attorney testified about made Wendy look really bad, because again, Wendy, when she testified, she said she didn't know what the relocation being denied with prejudice. She didn't know that this was it. This was done. And that Donna didn't know that. And Donna thought there was still a chance. I don't know, man. I feel like I'm starting to question, because I'm like, did I just remember incorrectly? I don't think I did, though. Wendy said that she didn't remember what with prejudice meant during that time, even though she was an attorney. She took the bar, she studied law. Okay, sure. Donna didn't know because Donna wasn't there. She was outside of the court. She was outside of the hearing because she was supposed to be one of the witnesses testified. My question at the time when Wendy was testifying was, well, let's say Wendy did forget what prejudice mean. Did the judge not explain it properly? Did Wendy's attorney not explain it properly? Did they not go outside and explain to Donna what happened? That sounds really odd. Maybe that is what happened. No, we hear this attorney testified today that the judge explained, Wendy stipulated, the attorney explained to Wendy, Wendy told Donna, and at some point the Wendy did talk to the family as a whole again to explain what happened. She even said that Wendy understood. She's a lawyer. She understood the legal ramifications. Are we to believe Wendy when she testified in the stand that she forgot what with prejudice meant days ago? I think Wendy's lying. They have a party about Wendy getting her groove back. Wendy pays $30,000 in attorney fees and deposition and all that stuff. Part of the marital settlement agreement, Dan got to keep the house. He had to pay Wendy for her portion of the house. Assets were divided equally, and it seems like the divorce was done. All good. Dan has to pay Wendy $120,000 and paid $10,000 for the attorney fees. Dan paid $50,000 on a timely basis. However, all of a sudden, Dan decides not to pay the rest. And Dan writes this pleading and essentially attacks Wendy, saying that he shouldn't have to pay Wendy because she breached a settlement agreement and there was money that she had hidden. However, the attorney was saying that, well, the money was not hidden. Dan Markel knew about it because we had a meeting about it and he should have known about it. But not only that, in his own pleading, he did say that he knew about it. So that kind of goes against him saying that Wendy was committing fraud, because Dan Markel had knowledge of this assets. I don't know. Dan Markel was not here to defend himself. Dan Markel's attorney didn't testify for the state. So we're just taking the words of Wendy's attorney and the defense expert. It's all like a one-sided, it could be skewed, right? So they really get into all the stuff that happened after the divorce was done. You know, they get into the parenting issues. They get into the complaint with Donna saying things to the grandchildren, saying bad things about Dan Markel, that he's stupid, that he wants to take the sunshines away. We get into Dan Markel trying to disbar Wendy, try to disbar Wendy's divorce attorney, and the divorce attorney had to withdraw to potentially be a witness, and things were pretty fucking bad. Oh boy. Let's see, what else was there in this witness? Cross-examination pretty much it gets into whether or not, Wendy and Donna were involved in divorce filings, and the attorney was like, no, I filed it myself. I did all the legal stuff, blah, blah, blah. There was a mini break where, again, it seems to be a violation on the judge's order, second time of the same caliber, which is having a witness in the courtroom. There's sequestration orders, so you shouldn't be in the courtroom listening to other people's testimony. It seems like they talked about it in sidebar last week when no, it was a couple days ago. Was it yesterday? It was like yesterday. No, it was yesterday. It was yesterday. Yeah, sequestration order was violated yesterday and then violated again today. They had a sidebar about it, and I don't know what happened with the defense's understanding, but they somehow misunderstood and thought this witness would be allowed to listen in on another witness. And the judge is like, no, what the fuck? There was this whole thing about whether or not the witness would be allowed to testify. Georgia was really upset, makes her argument, but, the judge said that to have her to be completely excluded, that remedy is like really, really extreme. So let's see what she knows. So they have her proffer, and then they're like, okay, you can testify. So she comes up and she testifies, and again, she's going to reiterate what Wendy's defense attorney, what Wendy's divorce attorney said, not defense attorney. Same thing. This her entire testimony just basically just encapsulates the fact that this divorce was not contentious. It wasn't contentious. Things were fine. Things were moving along. They were resolving things without the judges present. They resolved the temporary parenting, the permanent parenting, property, some other stuff. And then she goes and mentions that, oh, well, Donna, calling Dan gibbers. That wasn't a big deal, And technically gibberish was somewhat applicable because gibberish just means that it's someone that just speaks gibberish. And Dan was filing these pleadings, and like he didn't really know what he was doing, and the stuff that he was writing, it seemed more like it was arguments for like a law review thing. She said something like that. So I mean, Dan wasn't a family attorney, so it would make sense that he might have the legal knowledge, but applying it in terms of the family attorney realm stuff, he probably didn't know what he was doing. Maybe that's what she's essentially saying. But again, they're trying to say that, oh, the marital settlement agreement was actually beneficial for Wendy. Wendy actually got more parenting than what she initially asked for. Dan Markel was asking for all these things that seemed really unreasonable, and Wendy ended up winning anyways. So essentially, they just go through the whole thing, and, same thing. Then they went through, hey, was Dan Markel's pleadings, were they intimidating? And she's like, no. Should Wendy or Donna feel threatened? No. But I was arguing that as a normal person who, if you're Wendy, like this is your divorce. To you probably took it a lot more personally. To Donna, she also probably took it personally because these attacks were against her as well, right? And then not only that, Donna's like not an attorney or anything like that. It's not like Donna was like, oh my God, like I'm reading this and these pleadings and these motions that Dan is filing for and these arguments that he's making, they have no merit. We feel fine. We feel completely safe, right? I think Donna was very, very threatened by it. And during cross-examination, I think Georgia just completely just destroys this witness, because when you have an expert witness that is very defensive and is not conceding to small little matters, right? If you're just holding your ground no matter what, then you look really bad. Then you look like you are truly someone that is hired by the defense to say what the defense wants. And it really seems like you're not being forthcoming. That to me is not a good vibe for experts, but maybe the jury has a different opinion on that. But the cross-examination was just masterful on Georgia's behalf. I don't even know how to even recap it, but it was just really fucking good. And, you know, she was very straight to the point. She wasn't like dragging it out or anything like that. But she starts off with, what is it that you're asked to do in this case? Was it to figure out whether or not this is highly contentious? It's like, yeah. Why would your opinion matter? And she's like, what do you mean? I mean, I'm an expert, you know, I've gone through so many other cases. I would hope that my opinion matters. And George was like, yeah, but like, you're not the one that went to the divorce, right? Maybe to the people that were going through the divorce stuff, it was a lot bigger to them. It was like the entire world to them, right? To you, it's different because you're just an expert and you're used to seeing these divorces over and over again. But to them, when you're experiencing this and this is your life, you're going to take things a lot more personally. That's essentially where George was getting at. And the lady was just being very dodgy, evasive. And Georgia gave a really good reference about, you know, to me, my garbage is stinky. To a garbage collector, it's not because, you know, they're used to it. And she's like, I don't get the reference. It's like, come on now. If the jury can get that reference, the jury is going to look at the expert and be like, you're purposely just trying to disagree with Georgia because you don't want to give her any points. And that just does not look good. Oh boy. Anyways, so they're in lunch break right now, and we'll be back in about an hour and like 15 minutes. The defense did complain to the judge about reactions in the jury, which I think, not the jury, the reactions from the gallery, which I think is good. You know, you don't want the gallery to be reacting, and I do feel bad for defense, you know, when they were like laughing, and yeah. All right, guys. Anyways, that's it. That's it for now. I will see you guys in about an hour, 15, 20 minutes. And what a day. What a way to end before the lunch break. We'll see if Donna's going to testify. They'll let us know after the lunch break and we will see. By the way, guys, so we do have recaps of the trial. So if you guys want to go back, watch some of the recaps, I do want to go back at some point and listen to some portions of Wendy's testimony. Cause I'm like, man, did I just remember incorrectly? I don't think so. Cause I just feel like Wendy's own former divorce attorney has testified about things that makes Wendy look like she's a liar. And then also kind of makes Donna look like a liar too. Because Donna's defense was trying to say that Donna didn't know that the relocation was completely done, that there could have been a chance. However, remember there was an email that the state showed to the jury that completely goes against that. Donna complained to her friend that, you know, there's no, that was it, you know, nothing else. The relocation, she was like really upset about that, it being denied. All right, y'all. So I will see you guys in a few. Take care, get some lunch, and thanks for watching. We'll be back. Enjoy Donna. Wait, where is it? Oh, here it is. Enjoy Donna. Hey everyone, hello. They're coming back from the lunch break. Oops, that's my phone. Oh god, hold on. I was forgetting about that. All right, y'all. Give me a second to get settled and let's come on back in. All right, let's get started. I forgot to stretch my legs during the lunch break. No. Usually I have to stretch my calves because they're really tight. And it makes my lower back really tight. All right, y'all. Who's ready for this? Let's get started. So, during the lunch break, the judge gave Donna Adelson and her team an extended lunch break. And for everyone else, because they want Donna to discuss whether or not she's going to testify. Okay. Oh. Hello. How's it going, y'all? Let me get the right window up. There's Donna whispering to Mr. Zellman. Everyone's coming back in. Here's a judge. I mean, I always thought she was going to testify, but I thought maybe she might change her mind.
All right, two matters to briefly address before we bring the jurors in. The first concerning the waiver of attorney-client privilege as to the testimony of Ms. Sclazo. I am going to need to place the defendant under oath concerning this. Ms. Adelson, please rise. Raise your right hand. Raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth?
Yes.
You can lower your hand. You understand with your former, or I guess I don't know the relationship exactly, but someone who has previously represented you, concerning their testimony today, are you waiving attorney-client privilege concerning what they will testify about?
Dan Rashbaum? Who is testifying that she had to waive attorney-client privilege?
Yes, I am.
Concerning their testimony today, are you waiving attorney-client privilege concerning what they will testify about?
Yes, I am.
Concerning that, Mr. Zellman, do you wish the court to make any further call to it?
Yes, Your Honor. The waiver is specific as to the counsel that our client received.
Oh, hold on a second. Is it Donna's other attorney? Not Dan Rashbaum, but didn't she have another attorney that was assisting her with estate planning stuff?
See from Mr. Scalzo,
Well, if you need to discuss with her what she's waiving, that's fine. I don't believe you can waive on her behalf.
Scalzo. Is that the attorney that was representing her before Dan Rashbaum got on the case then? That name sounds really familiar. Yeah, that was Dan Rashbaum. This is about someone named Attorney Scalzo. I was about to say, I was like, is Dan Rashbaum going to be up in here? That'll be interesting. All right, whisper. Whispering right now. Oh boy, this is very interesting.
Ms. Adelson, do you understand the scope of the waiver that you're providing? Do you understand the scope of the waiver that you're providing of attorney-client privilege?
I do, Your Honor.
What is that scope?
The information that we discuss after my son's trial regarding my travel and my state of mind.
Okay. That attorney. All right. Let me boost up the audio. I'm sorry, guys. It was pretty low.
The scope of the waiver that you're providing. Do you understand the scope of the waiver that you're providing of attorney-client privilege?
I do, Your Honor.
What is that scope?
The information that we discuss after my son's trial regarding my travel and my state of mind.
Is the defense planning to examine this witness on any other topics than what has been identified as the scope of the waiver?
no, Your Honor.
Very well. If any matters are inquired into that exceed the scope, at that point, we are going to have to send a jury out of the room. As I previously stated before, the state is permitted to cross-examine as to all topics that are inquired to on the defense direct, and also as well matters of impeachment and bias. Does the state need to be heard in any way? As to the other matter concerning whether Mrs. Adelson will testify as a part of the defense case in chief, Mr. Zellman, were you able to speak with her as to a final decision?
I'll allow, the short answer is we were allowed 20 minutes during the lunch break to speak with Miss Adelson.
In addition to the time that you had yesterday and other times?
Yes, Your Honor.
If I may, Judge, the issue is that we...
Well, one moment. Who's handling this matter?
Right. The judge seems concerned. Are you sure you want to do this? Okay, this means that the state can cross your attorney about things related on direct and also matters of bias. Are you sure, Mrs. Adelson? Defense, are y'all sure you want to go down this road?
We're not tag teaming any arguments of any sort.
I think Zellman's handling it.
Ms. Fulford and I had discussed was the factual issues that are concerning our client's decision. She was more involved in than I was. So the only thing that I intended to address was the time that we had during the lunch break. Aside from that, I'm asking that Ms. Fulford be allowed to address the court.
Ms. Fulford, go ahead.
The issue that we're facing, Judge, is this was 6 days of testimony from witnesses for the state and a great deal of evidence that they have entered. We have discussed with our client, of course, her right to remain silent or whether she wants to testify or not. We have not had an opportunity to go through all of the evidence that's been entered in this case and have a full and frank discussion with her about that evidence. If there are any issues that she thinks need to be addressed for her testimony, whether she thinks she needs to testify or not, and what her decision is on that.
What have you guys been doing during the lunch breaks? On the other breaks? What about after the court date? After the court is over? Is it hard to meet with Donna, I guess? Why are we bringing this up now?
Testimony, whether she thinks she needs to testify or not, and what her decision is on that.
When we had the break yesterday at 2:45 in the afternoon, you did not speak with your client concerning whether she wished to testify or review
Absolutely.
the evidence?
Yes, Judge, and that's what I said. We have discussed with her whether she wants to testify or not.
The defendant in every single case, Ms. Fulford, is faced with this moment as the defense case in chief ends. What are you asking for?
I'm asking for additional time to be able to go through all of the testimony and evidence with our client so that she can make a fully informed decision as to whether she wants to continue to remain silent or testify in this case.
Ms. Fulford, concerning that has been provided by the court. If she wishes to testify, we do need to go through the colloquy. If she does not, it's a simple matter. But there has been time pre-trial to prepare for this moment. There's been time during.
And it's not like she hasn't been sitting in the trial, listening in.
But there has been time pre-trial to prepare for this moment. There's been time during trial, and specifically we recessed court early for you to address any issues of witnesses
Yesterday, we ended 2 hours early.
or whether your client would testify.
Yesterday, when you allowed us to recess early, Judge, Mr. Zellman and I spent time going through the evidence that was admitted, making sure that we understood everything that was there, because there was some confusion during the trial about things being added and things being removed, so we wanted to make sure we understood completely what there was there. We left here, went straight to the jail, and had the issue with the potential new witness and spoke with our client. But that's not an ample time to discuss with her what has actually come in the state's case.
Your client is in a no different position than any other defendant who has to decide whether they wish to testify or not.
Judge says she ain't special.
I will give you 5 additional minutes to discuss this matter. From there, the defendant is going to have to make a decision of whether she is going to testify or exercise her right to remain silent. Please check with the jurors. Let them know that we will get started momentarily.
Let's make a poll. Will Donna testify? Yes? No? Let's do yes, no. Yes and no. That's it. Usually I add more options, but we'll just do yes and no. All right, y'all, we have a poll. Will Donna Adelson testify? Oh boy. They are still... That was about 7 minutes ago. Should we listen to the whole thing again? Let's listen to the whole thing again. For those of you guys who are joining us a little bit late, we'll listen to the whole thing. Jesus. So the judge gave Donna time yesterday to testify. We ended 2 hours early. There's like the recess, the lunch break, the extra time. They still want more time to figure out if Donna's going to testify. And the judge was like, we need to know. I'll give you 5 minutes.
The first concerning the waiver of attorney-client privilege as to the testimony of Mr. Scalzo. I am going to need to place the defendant under oath concerning this. Ms. Adelson, please rise. Raise your right hand. Raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth?
Yes.
You can lower your hand. You understand with your former, or I guess I don't know the relationship exactly, but someone who has previously represented you, concerning their testimony today, are you waiving attorney-client privilege concerning what they will testify about?
Yes, I am.
Concerning that, Mr. Zellman, do you wish the court to make any further call to it?
Yes, Your Honor. The waiver is specific as to the counsel that our client received from Mr. Scalzo.
Well, if you need to discuss with her what she's waiving, that's fine. I don't believe you can waive on her behalf. Mrs. Adelson, do you understand the scope of the waiver that you're providing? Do you understand the scope of the waiver that you're providing of attorney-client privilege?
I do, Your Honor.
What is that scope?
The information that we discussed after my son's trial regarding my travel and my state of mind.
Is the defense planning to examine this witness on any other topics than what has been identified as the scope of the waiver?
No, Your Honor.
Very well. If any matters are inquired into that exceed the scope at that point, we are going to have to send the jury out of the room. As I previously stated before, the state is permitted to cross-examine as to all topics that are inquired to on the defense direct, and also as well matters of impeachment and bias. Does the state need to be heard in any way? As to the other matter concerning whether Mrs. Adelson will testify as a part of the defense case in chief, Mr. Zellman, were you able to speak with her as to a final decision?
I'll allow, the short answer is we were allowed 20 minutes during the lunch break to speak with Ms. Adelson.
In addition to the time that you had yesterday and other times?
Yes, Your Honor.
If I may, Judge, the issue is that we.
Well, one moment. Who's handling this matter? We're not tag teaming any arguments of any sort.
Your Honor, what Ms. Fulford and I had discussed was the factual issues that are concerning our client's decision. She was more involved in than I was. So the only thing that I intended to address was the time that we had during the lunch break. Aside from that, I'm asking that Ms. Fulford be allowed to address the court.
Ms. Fulford, go ahead.
The issue that we're facing, Judge, is this was 6 days of testimony from witnesses for the state and a great deal of evidence that they have entered. We have discussed with our client, of course, her right to remain silent or whether she wants to testify or not. We have not had an opportunity to go through all of the evidence that's been entered in this case and have a full and frank discussion with her about that evidence. If there are any issues that she thinks need to be addressed for her testimony, whether she thinks she needs to testify or not, and what her decision is on that.
When we had the break yesterday at 2:45 in the afternoon, you did not speak with your client concerning whether she wished to testify or review
Absolutely.
the evidence?
Yes, Judge, and that's what I said. We have discussed with her whether she wants to testify or not.
The defendant in every single case, Ms. Fulford, is faced with this moment as the defense case in chief ends. What are you asking for?
I'm asking for additional time to be able to go through all of the testimony and evidence with our client so that she can make a fully informed decision as to whether she wants to continue to remain silent or testify in this case.
Ms. Fulford, concerning that has been provided by the court. If she wishes to testify, we do need to go through the colloquy. If she does not, it's a simple matter. But there has been time pre-trial to prepare for this moment. There's been time during trial, and specifically we recessed court early for you to address any issues of witnesses or whether your client would testify.
Yesterday, when you allowed us to recess early, Judge, Mr. Zellman and I spent time going through the evidence that was admitted, making sure that we understood everything that was there, because there was some confusion during the trial about things being added and things being removed, so we wanted to make sure we understood completely what there was there. We left here, went straight to the jail, and had the issue with the potential new witness and spoke with our client. But that's not an ample time to discuss with her what has actually come in the state's case.
Your client is in a no different position than any other defendant who has to decide whether they wish to testify or not. I will give you 5 additional minutes to discuss this matter. From there, the defendant is going to have to make a decision whether she is going to testify or exercise her right to remain silent. Please check with the jurors, let them know.
All right, so they are back in the courtroom. A little bit of footage here. What goes with the footage? Let's see. Peanut gallery here.
Is the response from the audience concerning things that are said by the defense. And although the proceedings are public, that has not stopped Peanut Gallery from their comments and laughter. We are respectfully requesting that the court allow Ms. Adelson to participate at sidebar as she is entitled, and for the court to address additional issues that are weighing on Mrs. Adelson's decision.
Like what?
Please approach. We're not going to do this for very long.
The court to address Mrs. Adelson's issues. The peanut gallery. Shut up, he says, in a nice way. Okay. All right, Mr. Zellman. Donna's there. Jackie. Looks pretty concerned. I'm going to fast forward it. Georgia just chilling, hands in her pocket. All right, jury's coming in.
We are going to continue at this point with the defense's case. Please call your next witness.
Before we call our next witness, we laid the foundation through Luis Rivera for Defense Exhibit 50. At this point in time, we'd like to introduce that into evidence.
Any objection from the state?
There we are.
Defense 50 is admitted.
Thank you. At this point in time, the defense will call Marisol Descalzo.
All right, so she looks real familiar. I think she was the attorney. So before these two, there was Dan Rashbaum, and I forgot the other guy's name. It was her. She was before them. I believe she was.
Please raise your right hand. Do you swear
Man, we have a lot of attorneys testifying for Donna Adelson today, huh?
or affirm the testimony you're about to give will be the truth? I do. You may be seated.
Thank you.
You may inquire.
Thank you, Your Honor. Good afternoon, ma'am. Can you please introduce yourself and spell your last name for the jury?
Marisol Descalzo. My last name is spelled D-E-S-C-A-L-Z-O.
And Ms. Descalzo, can you tell us how you're employed?
I'm an attorney,
Okay, what type of attorney?
a criminal defense attorney,
And how long have you been practicing?
since 2003.
During a period of time ending shortly after her arrest, did you represent Donna Adelson?
Yes, I represented her sometime in 2022 through maybe 3 months after she was arrested.
And I want to direct your attention specific to October, the late October and beginning of November of 2023. During that time period, was her son?
Were you the attorney that said that she, no, I think that was Dan Rashbaum. I think Dan Rashbaum was the one that told her, you know, if she wants to travel, she needs to go now or something.
On trial?
I'm not sure about the dates, but it sounds about right.
During that time period, when her son was on trial and shortly after, did you have some concerns based on statements that she was making?
Concerns about Mrs. Adelson's mental state, yes.
Yes. Can you tell us what those were?
She had made numerous statements about terminating her life if her son Charlie Adelson was convicted.
Did that cause you to take any steps or actions to determine what you needed to do?
Yes.
And what were those?
Well, first, I conferred with Daniel Rashbaum, who represented Charlie Adelson. So we discussed it, and we decided that we needed to call Ethics Council and call the Florida Bar to determine if we needed to take any additional steps, such as Baker acting her, or Baker acting as putting her in a mental institution, or anything else.
Okay. After doing that, did you have further discussions with Mrs. Adelson about her mental state and what she was going to do to try to clear things up?
Mr. Rashbaum and I spoke to her further, and, you know, she told us that what she really wanted to do was she wanted, you know, to get away on a vacation with her husband. Her husband agreed that this would be good for her mental state, and so we discussed a potential vacation.
Okay. At that point in time, was there anything preventing Mrs. Adelson from traveling?
As far as Mr. Rashbaum and I knew, there was not.
Okay. And specifically, there were no warrants for her arrest?
My understanding from speaking to Mr. Rashbaum, that Mr. Rashbaum had communicated with law enforcement.
Again, a lot of the focus is on issues that are adjacent to Donna Adelson's concerning evidence and actions. Yesterday, we focused a lot on the Vietnam stuff too, especially with one of the witnesses. Like Jackie went real hard on the Vietnam stuff. Oh, and also in cross-examination of the state's witness. Man, I feel like there's so much more they have to focus on, but maybe this is like the strongest and they just want to stick with it.
Enforcement, and that there was no outstanding warrant. I had been in touch with the prosecutor of this case, and I apologize because I only remember your first name, but with Georgia, and we had discussed previously, not around this time. We had previously discussed that I represented Mrs. Adelson, so I assumed that if anything would happen, that if there was a warrant or if Ms. Adelson was going to be arrested, that I would be contacted.
Did you advise Mrs. Adelson that if a warrant was issued, that you would provide her with that information so that she could self-surrender?
So the discussions I had with Mrs. Adelson weren't exactly like that. Mrs. Adelson discussed what would happen if there was an arrest warrant and the potential things that might happen. The prosecutor had never guaranteed for me that Mrs. Adelson could self-surrender.
Okay. Did you tell her did you tell Mrs. Adelson that self-surrender was something that could happen?
Yes, I did.
Okay.
Donna, self-surrender? Yeah, right.
And on November 6th, her son was convicted. Did you speak with her after that, specific as to her ability to travel?
I don't remember the dates, but there was discussions about her traveling after the conviction, because around that time was when she was making a serious threat, was when Mrs. Adelson was making these serious threats about her life.
Just a moment, Your Honor.
I feel like Wendy wasn't even really taking the mom seriously. There was a text exchange between Wendy and Donna Adelson. I think Wendy said, hey, Mom, if you're going to continue making threats, I'm going to have to do X, Y, and Z. And then Donna said something about like how, I forgot what it was verbatim. But my takeaway from what Donna said was she was just saying it. She wasn't going to do it.
Nothing further, Your Honor?
Cross-examination.
Good afternoon.
Good afternoon.
Now, if someone has a warrant, is it up to the defendant or the suspect, the person who has the warrant, to dictate their terms of surrender?
I don't think so. It's up to the law enforcement.
It's usually up to law enforcement to decide how or where to apprehend that person, right?
Yes.
But, so it's not a requirement of law enforcement to notify someone when they have a warrant, but that is sometimes a courtesy that's extended. Is that right?
That's correct.
And that is a courtesy that's sometimes extended in situations where, let's say, someone is not a flight risk, right?
It's in all sorts of situations you can have self-surrender extended to, I wouldn't limit it to only people that are not a flight risk.
Okay, would that be one situation?
I would assume so, yes.
Okay. And you were told that by Georgia, by Ms. Kappelman, that you wanted to know whether she had a warrant she could turn herself in. That was some amount of years ago?
It was definitely before Charlie Adelson was convicted. It was on a phone call that I had. I offered it, and as I stated, Georgia Kappelman did not guarantee that.
Okay. But that was before.
Why couldn't she travel? She wasn't under investigation at the time, was she? I think she was under investigation. Yes, she was allowed to travel at the time. There was no issue with her traveling. It's the fact that it shows her consciousness of guilt that, oh my God, everyone's going down. My son Charlie got convicted. I need to get the fuck out of here. It's the text messages, her trying to get that quick track, visa. She had to make sure it was a non-extradition country. She was saying that on the recorded phone call. She was Googling non-extradition countries. Vietnam had to be one of them. Dubai was a layover. Dubai is also a non-extradition country. However, Donna didn't know that, these countries might still ship you back because of something like murder. It was Donna just orchestrating and planning all this and trying to get the fuck out as quickly as she can. And then her texting Wendy that they're going to come after me, but they're not going to get, I forgot what it was, but essentially saying that I'm probably next, but they're not going to get me. I'll make sure of that. So it's a lot of stuff that was happening during that time. It's not like, hey, Donna's in trouble because she was traveling. That's not it. It's because she is traveling because she thinks she's next. She's trying to escape and go to a country where she thinks they won't ship her back to the U.S. Maldives? Oh, I don't know about that. Maldives seems very expensive. Vietnam, probably really cheap. I don't know if maybe the surrounding area in the Maldives, that's not the resorts. Maybe it's cheap to live there.
For Charlie's trial or verdict.
Correct.
Okay. After the verdict.
Sorry, let me go back.
Ms. Kappelman, that you wanted to know whether she had a warrant she could turn herself in. That was some amount of years ago.
It was definitely before Charlie Adelson was convicted. It was on a phone call that I had. I offered it, and as I stated, Georgia Kappelman did not guarantee that.
Okay. But that was before Charlie's trial or verdict.
Correct.
Okay. After the verdict, or I guess during the trial or after the verdict, did you disclose to anyone in the state attorney's office that Ms. Adelson was suicidal?
Of course I didn't.
Okay.
No, I had an attorney-client privilege relationship with her, and I don't think that would have been appropriate.
Sure. And why was she suicidal?
Because her son had just been convicted, and she was worried he was going to spend the rest of his life in prison.
Was she also worried about getting convicted herself?
I don't believe that was even crossed her mind. She was only worried about her son.
Okay. Are you aware of a text message where she said that she was afraid she was next, but don't worry, she would take care of that?
To Wendy.
I'm not. I'm sorry. Was that a text message to me, or?
I don't believe so.
Yeah, I don't have any knowledge of that.
Okay.
Oof, what a nice way to remind the jury about the text message.
At the time of, were you present when Dan Rashbaum told her that she may make it to the airport in time, or she may get to the airport and not be able to make it out?
Mr. Rashbaum and I don't believe that that was a telephone call. I don't believe that was in person. And I was on a call, and I myself also told Mrs. Adelson that that we did not know whether there was, that we understood there wasn't a warrant, but that didn't mean she couldn't get arrested at the airport.
Okay. When you suggested, I guess, was the suggestion that you said that she take a vacation?
I don't believe I suggested it. I believe that that's something that was being discussed between Mrs. Adelson and her husband as something that would help her with her mental state.
Okay. So that's something they suggested, but not you?
Correct. I did not suggest that they take a vacation.
Okay. Did you know at the time that the vacation that they were suggesting, they were considering Vietnam, China, or Korea?
I did not know the location of where they were going.
Okay.
And it was never discussed with me.
So at that time, you didn't have knowledge that they were specifically looking for non-extradition countries?
I did not know one way or another where they would vacation to.
If Donna Adelson was overheard by law enforcement debating between either committing suicide or fleeing to a non-extradition country, do you think that would change law enforcement's stance that she could turn herself in?
Objection, Your Honor, calls for speculation.
Overruled. The witness has opined on this matter.
I'm not law enforcement, so I'm not sure. And I've never been in law enforcement, so I'm not sure.
I can rephrase it. Would you expect that to change the stance?
If I was law enforcement and I heard a target of investigation discussing a flight.
As her attorney,
Okay.
would you expect if she's overheard debating either committing suicide or fleeing to a non-extradition country that she wouldn't be expected to be able to just turn herself in on a warrant again after that?
I don't know. I think it would take, to be honest with you, I'm a criminal defense attorney, so it would be case by case. Probably that would make the bond hearing a little bit more difficult if those conversations were overheard. But every prosecution is different, and maybe the prosecutor would agree. I don't know.
Okay, 1 second.
Out of all the other attorneys, I think her testimony was the best because it seems the most truthful and forthcoming. Very direct to the point.
Specifically, though, about self-surrender, would you expect that to change law enforcement's stance as to self-surrender, not as to a bond?
Again, I think that that's specific to each case, and I don't know exactly what was overheard, so I apologize, but I don't really have a concrete answer for you, other than what I said before, that it would come up at a bond hearing.
Thank you.
Redirect examination.
Thank you, Your Honor. Mr. Scalzo, the prosecutor asked you about fleeing the jurisdiction. My client talked to you about a vacation, correct?
That is correct. It was not fleeing the jurisdiction.
That's how she ordered it.
And the state also asked you about fleeing or going to a non-extradition country. Have you, in your career, dealt with extradition from foreign countries?
Yes, I have.
And merely because someone is in a non-extradition country, does that prevent the United States from attempting to seek their return or their extradition to the United States?
It absolutely.
Maybe the amenities in non-extradition countries are way better than countries with extradition, and that's why Donna chose non-extradition. Like, what will be the excuse for choosing that? What will be the only excuse, huh? The currency is better there? It just, I feel like all this is just a waste of time.
Absolutely does not, especially if you're a U.S. citizen.
Nothing further.
You may step down. Is this
Did
witness
Donna know
going to
that?
be recalled for
Did Donna know that? Probably not.
any purpose?
No, Your Honor. I believe she might be able to get the early flight this evening.
You are released. Please call your next witness.
Just a moment.
like, whoa, so glad I'm not on this case right now.
Sarah Newhouse.
Witness number 12. So Donna waived attorney-client privilege, so Maricel can testify about Donna's state of mind during this vacation travel to non-extradition country, where buying a one-way ticket was cheaper.
Raise your right hand down. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, sir.
You can take your seat. Please speak loudly and clearly. You may examine.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Can you please introduce yourself to the jury?
Yes, my name is Sarah Newhouse, and I am currently the behavioral wellness coordinator for the police department. Back in 2014, I was the victim advocate.
You're a victim advocate for the Tallahassee Police Department?
Yes, sir.
Okay. And in your role as a victim advocate, what does that entail when you work for the police department?
Typically, it's following up with victims that are victims of crime, usually persons crimes, homicides,
Victim advocate for Donna?
suicides, sexual batteries, domestic violence, things of that nature. And it's providing support, kind of being a middle person between them and the police investigation team.
And in that role as a victim advocate, were you working on July 18th of 2014?
Yes, I was.
Okay. Did you have occasion to get assigned to be the victim advocate for Wendy Adelson?
Yes, I did.
And were you present for the vast majority of her interview with law enforcement?
I was.
Were you also present when Wendy Adelson called her mother, Donna Adelson, towards the end of that interview?
I was.
And did you have an opportunity to listen to the portion of the interview where Wendy Adelson called her mother?
I did.
And I'm going to show you what is marked for identification purposes as Defense 71. Did you have an opportunity to listen to this exhibit?
I did.
Okay, and is the portion of the recording true and accurate reflection of what you remember from July 18th of 2014 when Wendy Adelson called her mother?
It is.
Okay. When Wendy Adelson called her mother, do you recall Donna Adelson's reaction to being told that Dan Markell had been shot?
Oh, I do remember you. Okay. Yeah, she was in the police interview with Wendy, and then she came in. That was after Dan Markell was shot. Okay. And then she got to, I don't know if she put Donna on speaker. I don't think she put Donna on speaker, actually. Okay. She was sitting next to Wendy, just comforting her.
Yes.
Okay. Did this upset her? To being called her mother. Do you recall Donna Adelson's reaction to being told that Dan Markell had been shot?
Yes.
Okay. Did this upset her?
She sounded shocked, I guess would be the word that you'd say.
And it appeared that this was the first time she was hearing about it?
Yes.
And did she make any statements that you could hear from where you were sitting?
I don't recall if I could hear other than reviewing the video, but it sounded like a normal amount of upset given a crisis situation.
At this point in time, I move into evidence Defense 71.
Any objection?
Judge, I haven't reviewed this exact item, but based on what the defense has represented to me is on there, I don't have an objection. I do want to review it on the break and reserve the right to object. So subject to that objection.
A lot of qualifications.
Well, they're just...
Members of the jury, we're going to take a brief break. The bailiff will take a brief jury room.
I hope the jury brought their cross puzzle book. I feel like every time Donna looks at the jury, she's always like, and then leaves. She's back to like.
You can be seated.
All right.
If anyone needs to stretch their legs or use the restroom, please do it now.
One in chat. Who here in chat has seen Wendy Adelson's police interview? One in chat if you've seen it. Two if you have not seen it yet. All right, let's look at the poll right now. We have 82 votes. Guys, you guys haven't voted? Put in your opinions in. Will Donna testify? 60% say yes. 40% believe, maybe no. I mean, we are getting close to the end of the day, so... Oh, what the fuck happened here? Oh no, it did a little jumper.
Please come up.
What happened? Little jumpy thing. Okay, so Georgia's listening to it right
You can be
now.
seated.
I'll super fast forward it. Maybe they'll give Donna a night to think about whether or not she wants to testify. 1, 2, 1, 2, 2, 1, 2. Okay, mix. It's a very interesting police interview with Wendy. Oh, Sarah with no H. Okay, I wrote her name wrong. Sarah Newhouse.
Wendy Adelson saying, "This is the worst day of my life."
Okay. Let me slow down.
It includes Wendy Adelson saying, "This is the worst day of my life" before the call connects, and then it includes the witness telling Ms. Adelson she did an awesome job on the call after the call disconnects. So I would object to those two comments. I'm fine. I understand they don't intend to publish it right now, so subject to those objections, no objection to the exhibit once those things are removed.
Mr. Zellman?
Do I think Charlie's going to testify? No. I don't think so. I thought if he was going to testify, I thought maybe he would be called by the state.
As I indicated to Ms. Dugan when Ms. Kaplan was watching it, I got to remember how I snipped it, but I don't have a problem removing the comment before and the comment after before it's published for the jury.
That defense 71 will be admitted. The proper redactions will need to be made. You can bring back to the jurors.
Did they actually have Donna on video doing anything incriminating, or is it all circumstantial? The state said that it's mostly circumstantial evidence against Donna. The most direct evidence is after the bump where Donna calls up Charlie and says it involves the two of us. And then she speaks in code saying the TV is probably about 5. She also drops off money to Charlie, but this defense is trying to say that Donna didn't know what the money was for. And then also Donna writing checks to Katie for 2 years. Defense was also saying that, well, Donna was only doing it because Charlie told her to do it. But you can't convict on circumstantial evidence. Alright, jury's coming back in.
Everyone can be seated. Defense 71 is admitted at this time. You may continue with your examination.
I have no further questions for this witness, Your Honor.
Cross-examination.
Did you hear any weeping or wailing going on at the other end of the phone during this phone call?
Not that I recall, no.
Did you know Donna Adelson?
No.
Have you ever met her?
No.
So you don't know what her normal demeanor is like?
Correct, I don't.
Okay. But Wendy Adelson, her daughter, presumably does know.
Correct.
And do you remember Wendy Adelson making the comment after that phone call that she handled that well?
Objection, Your Honor. That's hearsay. That's exactly what was asked to be removed from the report.
Please sit down. As to the hearsay, sustained.
No further questions.
Redirect.
Your Honor, we'll just
Too late for that.
question from Ms. Kaplan.
Members of the jury, you are to disregard.
That's true. Wendy did say that. She handled that pretty well. Oh, Georgia, did you do that on purpose?
The last question of the prosecutor is to be struck from the record. You may step down. Will the witness be recalled?
No, Your Honor.
As to
Midnight
your
Grape,
exhibit,
true.
do you wish to publish or just leave it
She kind of looks like Wendy. I can see why you would say that.
out?
Not at this time, Your Honor. I do need to make the edits that were requested outside the presence of the jury so that they remove the 2 references. It could just take a few minutes.
Well, the jury will have a brief break. They will take you to the jury room once again.
What a fucking day. The jury's leaving again. Why was this not lined up for during the lunch break or something? Oh boy. Oh boy. Alright, well.
Everyone can be seated. Please make all necessary redactions and changes at this time.
Alright, need to make the redactions. Oh, sorry, it wasn't done during the lunch break because Georgia objected afterwards. Sorry, I thought he was talking about something else. Was there no one else that could have done it for him? I guess maybe they have a really small team. Alright, so Zellman is just redacting the portions that Georgia wants out, which are the comments made before. Zellman's talking right now, but I can't hear. Oh, Zellman said something. The judge is smiling. Maybe something good.
If there are no other witnesses for the defense, it is time for the decision to be made.
I can tell the court that co-counsel and my client are deep in conversation concerning this.
I am capable of seeing that, Mr. Zellman.
Zellman just took the narration that I was doing when Donna and Drina were at the jailhouse writing notes. Thanks for the narration, Mr. Zellman.
No narration is needed.
That's my job, Mr. Zellman. Oh boy, oh boy. I guess the judge wants to know because it's kind of like, hey, we're at the end of the day. I think those are all the witnesses that they have for the defense. Are we going to end here and maybe the state will rebut and then are we going to start closing arguments, I guess? I mean, or we could just end early, Judge. End early. Let her think about it. See if she wants to... Let her marinate on it. See if she wants to testify tomorrow.
Mrs. Kappelman wants the defense rest. Is the state intending to place or put on any rebuttal case?
I think not. If they rest without calling any further witnesses, that could change if Mrs. Adelson decides to testify.
Very well. At this point, I do need a decision. Mrs. Adelson, please rise. You've been placed under...
I think the answer is going to be no. What do you guys think? I haven't looked at the law and crime chat yet. I think no. What do you guys think? Yes, no, yes, no, yes, no?
Both earlier this afternoon. At this point, I do need a decision. Mrs. Adelson, please rise. You've been placed under oath earlier this afternoon. Mrs. Adelson, I will advise you concerning your rights. You understand that you have the right to remain silent, and the jury will be instructed that your silence cannot be held against you in determining the merits of this case. Do you understand this?
I do understand.
Do you also understand that you have the right to testify as a witness in your case in chief on your own behalf?
Yes, Your Honor, I understand.
You understand if you do choose to take the witness stand, you will be cross-examined by one of the prosecutors.
Yes, I'm aware of it.
You understand that your credibility will be placed before the jury like any other witness.
Yes, Your Honor, I understand.
Have you been able to discuss with your attorneys the two rights that the court has placed before you?
Yes, we discussed the rights.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces.
Can they just ask the judge for her to sleep on it? I mean, no one's asked that judge yet. Maybe they're too scared to ask the judge. Like, hey, judge, like, I'm really sorry, but like, can you just let me sleep on it, please, please, pretty, please?
Trial. Ultimately,
This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify.
She just needs to vomit at the table and just say she's sick. Pull the Lori thing, you know? Oh, Dad, I'm so sick. Oh, man.
But ultimately, you must choose
This is
whether
tough.
you will testify or not.
I don't have to choose. I was hoping I would have some time to speak to my attorneys.
This has already been discussed, ma'am. What is your choice?
Judge, since I was handling prior witnesses while Ms. Fulford was speaking with Ms. Adelson, can I have a few minutes, please?
What exactly are we going to accomplish that we have not been able to since the trial started? pre-trial, the long recess yesterday, or even the lunch break today?
That's what I'm trying to determine, Your Honor.
I will give
Zalman says, Jackie, ineffective. Let me in there. Tag me in, coach.
you exactly 5 additional minutes. From there,
right.
Mrs. Adelson has to make a decision whether she will testify or whether she will not.
Thank you, Your Honor.
All right, all right.
If anyone in the gallery needs to use the restroom or stretch your legs, this is your opportunity at this point.
All right, Zalman. Zalman's going to talk to Mrs. Adelson. I see in my peripheral that they're back, so.
The extra time that you have been provided, that has come to a conclusion. We are not finished with the colloquy quite yet.
Why am I so nervous?
I am not talking for the sake of talking. Before we have to move into any contempt, we do need to move on. Mrs. Adelson, the question remains, as it relates to your right to remain silent and your right to testify, what is your decision concerning these two rights?
This time I don't want to testify.
Very well. As I've previously stated, the jurors will be instructed that your silence cannot be held against you in any way. We will bring the jurors back out. The defense will rest its case on the record. Ms. Kappelman, you indicated the state will not have rebuttal.
Didn't say that, Judge. May I have a moment to confer with co-counsel?
Go ahead.
Because I was thinking, if she testified, she might do a really good job at trying to convince the jury on some points. Like I said, I feel like she's a pretty good actress. Yeah, I was thinking she was probably leaning more no. But then she's like, oh, but then like I can't have the last word. I can't tell the jury my own story, my own version, in my own words. Oh, man. I mean, it may just sound like giving them 5 minutes, but the judge is saying that, you know, you've been sitting here, you sat through the evidence, you've had pre-trial stuff to talk about the evidence, you've had the trial, you've had the breaks, after trial, the recess, you had time to think about it. We ended yesterday early. All right, y'all. Let's look at the poll. We had 101 votes. 60% said yes. 40% said no. 60-40 split.
One matter, Judge, that I thought we might be able to reach an agreement on, and we have. I will need to prepare a written stipulation for Your Honor to read to the jurors.
I don't know. I think it's possible that because Georgia went so hard and ham today, maybe Donna's like, I don't want to be on that other end of it.
Or we can decide the language now if you find that more acceptable. It's a one-liner. The parties have stipulated or agreed that Patricia Bird was never listed on the defense witness lists.
As to that, prepare the stipulation in writing. It needs to be signed by counsel for all parties and the defendant. From there, the stipulation will be read prior to the court going into further instructions.
Wait, they were going to call Patricia Bird back on the stand? What? She said something about like Patricia Bird was never on the defense witness list.
The preliminary copy of the jury instructions was sent to everyone this afternoon. Did everyone receive it?
We received it, Your Honor. We have not yet had a chance to look through it.
All right. We'll bring the jurors back into the room. The defense will rest. We will send them home for the evening. And we'll give you a few minutes to look through the instructions. We'll go through the charge conference. And then tomorrow, we will move into instructions and closings.
Your Honor, can counsel have a moment to confer concerning whether or not we are going to rest at this point?
Do you have another witness to call?
That's what we need to discuss, Your Honor.
we've done a lot of conferring. Please quickly come to a decision as to whether there is another witness, in fact, for the defense.
You voted with your heart. I wanted her to take the stand. I wanted to see what she was going to say. I wanted to see if she was going to change any version of her story. I want to see if she was going to put throw Wendy or Harvey or Charlie under the bus herself. Her defense team did. I wanted to hear it come out of her mouth. And then I wanted her to get cross-examined by Georgia. Whew. What does Harvey think, you think? Harvey just looks so unhappy. Donna must be in control. I think Donna genuinely doesn't know if she wanted to testify. She must be on the border of like, man, I think we're pretty fucked. Should I just like Hail Mary and testify? Or I don't know. Maybe there's like a hope that she can appeal something for this trial. Appeal and ask for a new trial. That way the first trial wouldn't have damaged her in terms of like comparing testimonies. I don't know. I mean, it's hard to get a new trial. What was the percentage again of people that win an appeal and get a new trial? It was like 5% or less. I remember hearing the number, but I don't remember. They are stall central. I mean, she can go through the motions of appeals, but, you know, we don't know if she's going to win. All right, we are reading. I think we're almost caught up with the live.
Are going to be tendering 2 exhibits to the court to introduce. I believe that both qualified or hearsay exceptions. The state's indicated that she's rejecting. If I could just have a moment.
I'm shocked she's not testifying. I thought for sure she assumed, like Charlie, that she could talk her way out of this. That's what I was thinking too. But maybe she got a little intimidated by Georgia today. Georgia was real fired up. Laughing out loud in the mail truck, looking real weird. She's learned from Charlie that she won't be able to talk her way out of this one. I feel like Charlie came off as someone who was just like really arrogant on the stand. I think Donna can play up the poor grandmother real well. Is she testifying? She was stalling for a long time. The judge says that after lunch break, he needs to know an answer. They came back. They wanted more time. He was like, no, fine, I'll give you 5 minutes. Jackie talks to her. They asked Donna, hey, do you want to testify? Donna says, I don't know. And he's like, I need an answer. Zellman's like, you know what? Jackie talked to her. Let me talk to her. We're done with that. Comes back. She's like, no, I don't want to testify then. I was thinking maybe she would testify and you do a Hail Mary. Like, fuck it, I'll just testify, man. Things are already looking so bad.
Mr. Zellman, concerning the items, we do need to move on so a ruling can be made.
I think the state said they weren't sure if they're going to put on a rebuttal case. Zellman is looking at exhibits right now, I think. There's like 2 exhibits. He was trying to figure out if there were any more, if they were resting their case.
Your Honor, yesterday, the state, or I'm sorry, not yesterday, but earlier in the case, the state introduced excerpts of the 2014 calendar that belonged to my client, as well as the 2023 calendar for my client under the rule of completeness. we are asking that the court admit the complete 2014 calendar as well as the 2023 calendar. That is, I believe it's states 51. No.
What's the question?
Councilman, concerning these items, what is the state's argument?
State's objection is hearsay, Your Honor. The portions that were admitted by the state were for very specific purposes. The rest of this item is not needed to add context to those individual.
So Zellman wants to add in the entire planner, the 2014 planner, and then 2023 and 2014 planner. Enter it in, and George is saying no, it's hearsay, not relevant. We don't need the whole thing for context.
Individual entries. It's a day calendar. It's not a narrative. I don't think there's any argument for completeness. There's tons of self-serving hearsay in those documents. The state objects.
Your Honor, with respect to the 2023 calendar, the state introduced a few pages that listed my client identifying items that she was going to sell. Based on the questions that were asked, the implication from that is that my client was selling these in anticipation of fleeing the country. Contrary to that, there are a ton of pages going back to January 9th of 2023 where my client lists those very same items to get prices to sell, to sell, to sell. So it is misleading to just put in those couple of pages that the state put in on the 2023 calendar for purposes.
Who was going to lay the foundation concerning the items that you wish to admit?
Foundation's already been laid by the state, Your Honor. It was seized
I
by.
believe as the inculpatory matters, yes. As to whether or not she was planning to sell something in January of 2023, what witness testified concerning that?
No one.
Judge, the implication from the state's admitting those pages is that my client was selling these in anticipation of fleeing under the rule of.
But couldn't he cross-examine, or couldn't he have gotten? Oh, maybe it was supposed to be through Donna. Donna was supposed to probably testify and say that, well, yeah, I was selling things, when I was about to go to Vietnam, but I was already planning on selling those things in January. I guess no one testified to that. No one laid the foundation for that. It's supposed to be you, Donna.
Inculpatory matters, yes. As to whether or not she was planning to sell something in January of 2023, what witness testified concerning that?
Judge, the implication from the state's admitting those pages is that my client was selling these in anticipation of fleeing under the rule of completeness. We should be entitled to introduce the additional entries from the calendar showing that it didn't just start around the time that she decided to travel to Vietnam, but it happened previously. Not for the truth of the matter asserted, not that she was.
Hold on, these are not recordings. A book with several entries is somewhat different from a recording. As it relates to recordings, the rule of completeness, I believe, serves a different purpose in the manner that you're describing. As to each page of this planner, all of the information is not inculpatory. So to that end, what witness has laid a foundation for the pages that you seek to admit that are separate from the inculpatory information?
None.
All we're seeking to admit are the pages from the 2023 calendar that list those additional items. lists the items that the state has already put into evidence as my client intending to sell them prior to leaving the country. I've printed out the specific pages, and I've prepared a copy with highlights to be able to present to the jury during closing. But it's not the entire, we don't have the entire 2023 calendar. It's been marked for identification and it's in the clerk's possession. So these are just the pages with those entries.
As to that, I will reserve whether the rule of completeness will drag across the pages that you're seeking to admit. I'll do some additional research, but again, every item that appears in the calendars does not have a relevant or probative hook to this matter. If there is not a witness that will testify or lay a foundation concerning this, I will reserve for now. Depending on the court's ruling, you may argue in closing. It's the same argument as the 2014 calendar.
Just one.
So they might be able to bring it up in closing, depending on how the judge rules on this. He said it's going to go and research about the rule of completeness. I thought for the rule of completeness, even recordings sometimes doesn't apply to it. Or I guess I'm thinking of Arizona with Lori Vallow's police interviews. Remember how this?
The argument for the 20.
Remember how the state only showed portions of it that were exculpatory to Lori Vallow? Hey, the TV's probably about $2.49. Thanks, Taxi. No code talk here. We're not scheming anything. What? Or maybe are you scheming with Rain again? Thank you. I appreciate it.
14 calendar would be the same under the rule of completeness. Obviously, there are things in here, and I said this to Ms. Kaplan earlier, that include personal information that would have to be redacted. Prior counsel provided a scanned.
Oh, but with Lori Vallow's statements, they weren't. That's right. It wasn't like all inculpatory. A lot of it was like self-serving statements. That she said to make herself look like she wasn't the suspect, and she was trying to make Charles Vallow look really bad.
Copy of this to the state. If they could send that to me, I could identify the items that I think should be redacted. The specific purpose of offering the 2014 materials has to do with planning the 70th birthday party of our client's husband, and the specific entries that she made identifying the tasks that she was going to carry out for that.
Again, is there any witness who will testify to these matters, or you're just offering them as rule of completeness?
Rule of completeness, Your Honor.
Ms. Kappelman, any additional argument that you might already made?
The only entry from the 14 planner that was admitted, has been admitted so far in this trial, is the page that shows
The license plate
the
number.
license plate number, sir. And so I don't see how birthday party planning adds to the completeness of possessing the license plate numbers. I would object. In addition, I think this exhibit is in a little bit different posture because the 2014 planner in its entirety has not been identified at all. Only that page was identified. The 23 planner was identified as by a witness as being seized from the residence.
I will reserve ruling as the 2014 planner as well. Beyond that, if the court does permit these items to be admitted, the defense will be able to admit them prior to any instructions and closings, and you'll be able to argue them if they are admitted.
Yes, Your Honor. And for the record, what I've done is I've marked the 2013 excerpts as defense, 2023, sorry, as defense 51, and the 2014 as 76.
Please leave them with the clerk.
Judge, if Your Honor does rule that those items are admissible, the state would request complete redactions of all the items that are not related to the specific purposes the defense articulated.
Certainly no objection to that, Your Honor.
Please begin the jurors.
All right, I think the jurors are coming in.
The state has made I want to check the redactions on this video.
This is jurors are trying to come in.
What a day
Defense
for the
may call
jurors.
Next witness.
Your Honor, at this point in time, the defense rests.
Members of the jury, with the defense having rested, is the state planning to recall or call any rebuttal witnesses?
No, Your Honor.
Why was he talking to Jackie? Was he pretending to confer with Jackie really quick before he said they were going to rest? Or what was it for?
With both the state and defense having rested their cases at this time, we are going to go into recess for the evening. I have some matters that I need to discuss with the parties, and from there tomorrow you will receive your instruction on the law and the closing arguments will take place. Once again, do not discuss this case with each other or any other person. Do not seek out any additional or outside information from what has been presented to you in this courtroom. Please report tomorrow at 8:45, and we will get started at 9 o'clock, or at least attempt to. Have a good evening.
Oh man, maybe the jury will have their verdict tomorrow. How many people have the state given deals to that were involved in this case? One. He was the hitman that testified. Luis Rivera. He was offered a plea deal in exchange for dropping all the deeds. Garcia didn't get anything. The other hitman, Katie Rivera. Katie McBenoit, nothing. She's hoping for something, but she hasn't gotten anything.
Please open your copies of the jury instructions. My custom in going through the jury instructions is to go through each one.
How many people has the state given no crimes in general? Yeah, one. Luis Rivera. The two women that testified, the inmates that were snitches, they didn't get anything from the state. They're hoping to get something from the state, but it wasn't through Dr. Kappenman. They're working on a plea deal with another attorney for the state.
Any requests or changes that are being asked for by either party, we will address as we...
Yeah, that's all who I know of. Luis was the smartest of the bunch. As the saying was.
go through each instruction. Let's start with 3.1, Introduction to Final Instructions. Are there any requests or changes being sought?
No, Your Honor.
No, sir.
3.2, Statement of the Charge. Any requests or changes?
I don't know if I want Katie to get something or not. No, but I do feel bad for her kids, though. I don't know. Oh, no. What happened?
Is the
Oh, give me a second. We are right around. Jury leaves. Right around here.
address going through the jury instructions is to go through each one. Any requests or changes that are being asked for by either party, we will address as we go through each instruction. Let's start with 3.1, Introduction to Final Instructions. Are there any requests or changes being sought?
No, Your Honor.
No, sir.
3.2, Statement of the Charge. Any requests or changes?
Not from the state.
Your Honor, the only request that I would make is that the name of my client and the names of the charges not be in all caps.
So stylistic changes.
Yes, Your Honor.
State, do you wish to be heard?
No, sir.
I will make that change. Let me make a note.
No all caps. Maybe it seems like it's being yelled at you.
Moving on to 7.1, Introduction to Homicide. This is a mandatory instruction in all murder cases.
Katie's kids have Alfredo. He got a plea deal, didn't he? You mean Sigfredo? Alfredo. No, Sigfredo Garcia was not given anything. They, yeah, he wasn't offered anything. So any information that he had, pretty much Rivera knew. I guess he could talk about the communications with Katie. But yeah, as far as I know, Garcia didn't get anything. Just Rivera.
Cases. As to the first paragraph, Donna Adelson is accused of first-degree murder in count 1 of the indictment. Is there any request or change?
No, sir.
As to the next paragraph concerning lesser includeds, is the defense asking for all Category 1 lesser includeds?
The kids are always almost the people that suffer the most in situations like this, and it's extremely sad. Yep. Do it for the money. You know, the hitmen, when they got their money, the one guy that has the kids with the Katie, he bought 3 cars shortly after murdering Dan Markel. It's like, no, not like you're saving that money for your kids. You know, not like you're saving it for their college tuition. He just spent it on himself, got some cars. Why do you need 3 cars? Or it was like 2 cars and a motorcycle. My bad. And he wasn't even having a job that was steady. No steady pay. So, yikes. Oh, how much was Bitcoin back then? All right, so they're gonna work on the jury instructions. I'll probably just listen to this on my own, but it's just basically a lot of them typing, maybe making changes. It'll feel like we're just working together. You know how they have like those work co-op stuff? So I'm just going to end it right here, guys, and I will see you guys tomorrow. I'm going to work on recapping today, and although we were out early today, it's a lot that happened today. Oh, there's so much that happened. Donna Adelson has decided to not testify, although it seemed like she was possibly maybe really considering. She wanted more time. She wanted to go over the evidence more with the attorneys. And ultimately, she has decided to not testify. So tomorrow, we'll see if the state is going to put on a rebuttal case. She said that she wasn't planning to, but I don't think we got any finality from Georgia afterwards. We'll see what happens with that. But I'm assuming tomorrow, closing arguments, and then jury will be sent in for deliberation. And then maybe we'll have a verdict for Donna Adelson by the end of day tomorrow. Or maybe the jury will deliberate and then come back possibly on Monday to continue deliberation. So we'll see. They wanted Katie to help Garcia to get Garcia the long nap. Yeah, that's why Katie apparently said she didn't want to take the immunity and, you know, get Garcia thrown on the bus because he was looking at DP. Hey, Martin, thank you so much. I appreciate the 48. Thank you so much for the super chat. Thank you for your support. I appreciate it. Thanks for hanging out with us. For those of you guys who are just joining us, or if you guys are not familiar, we do have recap videos of this trial on the channel. We've got day 1, 2, 3. Feel free to check them out if you guys are behind, or if there's some days that you wanted to refresh your memory, perhaps, or maybe, you know, these trial dates are very long. So if you guys want to go back and watch some of the days that maybe you weren't fully paying attention, go check out our recaps. And other than that, I'm just going to go work on today's recap. And I will see you guys tomorrow. Fresh and early. And I got to turn, I'm like so hot right now. I got to turn my AC. I had a dream last night that one of my clients wanted to pay me in Bitcoin. Oh, botcoin. What's a botcoin? I don't know about botcoin. I don't know about that. Thanks, Martin. I appreciate it again. Thank you so much. If Katie testified against Garcia, I know he was facing DP. So I think when she testified, she said that she didn't want her baby daddy to, you know, if he was convicted, she didn't want him to get the DP. Who has Katie's kids? I have no idea. Foster care? No. From my understanding, Katie has a mom that she was taking care of. I don't know if the mom is still alive and well, but I'm sure Katie has family. I think she's Filipino too. So maybe she has some family, you know, that can help her out. But I do feel bad for the kids because mom and dad are gone. But you know what? Maybe it's better for the kids anyway. Seems like mom and dad were not really the best people, you know, especially if they were gonna be hired to murder someone. Wendy's immunity extends only to her testimony. From my understanding, Wendy's immunity, whatever she testified to, was not going to be used against her if they were to investigate her, try to prosecute her, and then they can't use what they find out from Wendy's testimony. Although I feel like they probably didn't find out much. They can't use that against her to launch like a new investigation. But, you know, today Wendy's attorney testified, and I'm saying that, like, if Wendy ever has to testify in the stand, and if she's going to say the thing where, oh, I didn't know about, you know, not being able to relocate and, you know, have my attorney fight this again because I forgot what with prejudice meant, or that, oh, I, you know, didn't tell my mom and she didn't know what it meant. The attorney did testify today that Wendy's an attorney. She understood it. She understood the ramifications. And that this attorney also explained to Wendy. This attorney also saw Wendy explain to her parents. And the attorney also explained to Wendy and her parents together. So that'd be kind of interesting, you know, if they ever go after Wendy. I feel like, I don't know. I feel like there were some days where I felt like they weren't gonna go after Wendy. And then I started having really strong feelings that maybe they will go after Wendy. But I feel like I've cooled down from that now. And I don't think so. I don't know. But then again, I don't know what the state has up their sleeve. I don't know what they have. It should be revoked for lying on the stand. Wendy's a stranger to the truth. Oh, man. DB, he built a box for it. You know, I'm just so over the representing myself people. You're like, no, I just want attorneys to do it. Let the client sit there and absorb, you know. Let them sit there, and then we'll get them for testifying. If they testify, then, you know, we'll make comments about them. But I don't want them to defend themselves. It's just a shit show, and honestly, it's just a major annoyance and pain in the ass for the judge. But, you know, for the judges that have to go through that, I applaud them for their patience. All right, y'all. So we are going to end it here. Thank you so much for hanging out with us. I appreciate y'all being here. I will see you guys tomorrow. Check out the recaps. And then we also have a second channel where I move my vlogs on there. And so hopefully after the Donna Adelson trial is over, we'll have more time to edit the vlog stuff. But yeah, thanks for hanging out. You guys take care, and I will see you guys tomorrow. I stream on both YouTube and Twitch. Feel free to watch on either platforms that works for you guys. And take care. I'll work on the recap for today now. And if you guys missed it, keep an eye out for it later. I don't have fiber internet anymore, unfortunately. So I used to be able to upload these really quickly onto YouTube. But when you don't have fiber, it takes forever to upload on YouTube. So annoying. All right, bye.